besides this is obviously going to be, if you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or
I don't really know what this is, but I didn't do it. I'm innocent, Judge. Not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant, Matthew L. Moore, not guilty of murder, as he stands charged in count 1 of the indictment.
Elvis has left the building. It's done.
Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Hello. Good morning, good afternoon, good evening, wherever you're from. America, Europe, UK, Australia. Good day, mate. Wherever you're from, hello to you all. Day 4, Ashley Benefield. Here we go. The Black Swan murder trial. Interesting. What's the poll saying so far? Let's have a look at the poll. Bear with me. Poll, 26 votes. If you were deciding now, how would you vote? If you decided, then you should vote not guilty. Because I say that because if you're not on the guilty side, you should definitely, that means you're undecided, which means it's not guilty. So 26% of you say guilty, 74% says not guilty. Interesting. So here we go. Scrivs, Wayne, how are you, fella? After Netherlands, I really don't think the state has proved their burden, and that's without the defense. I don't disagree. Remember, the state also have a rebuttal left. They got a rebuttal case to put forward as well, so they'll probably put some people there as well, so they can bring more people back on. Crime Junkie, hello, my darling. You agree with Wayne? There you go. Good morning to you, my darling. James Bond, I don't think the state has proved it. How are you doing, fella? This isn't Karen Reid. I don't know if she's factually innocent or not. It doesn't know. Yeah. If there's any doubt at all, James, she's innocent. As in not guilty. Good day to you, Gitmo. How are you? Hope you're doing well. Christine, my darling, how are you? Hope you're well as well. Thanks for popping in and out yesterday. Sassy Bartender, hello to you, my darling. Hope you're well. The Sweeney is in the house. Dennis is in the house. How you doing, fella? How are you doing? Hope your green fingers with the garden's going well, Dennis. Much love to Brenda as well. Hope she's well. Kelly, hello to you, my darling. Happy Friday to London, everyone. When do we think this will wrap up? So they got a full day of testimony today. So yesterday they were going to take today off. the jury, but they couldn't in the end. So what they said yesterday was if they took today off for the jury, then they would have needed Monday, Tuesday, and possibly a part of Wednesday for the defense. So if that is still the case, that means today, Monday, say half day, Tuesday for defense, and say half a day maybe for the rebuttal. So that's the rest of Tuesday. Both sides will rest. Then on Wednesday, they still need to go through jury instructions. They still need to create all that stuff. That'll probably take half a day. And then I would imagine Wednesday afternoon is when closings will happen, and that's when it'll go to the jury. So I think the verdict would probably be here late Wednesday afternoon to the morning of Thursday. It depends if they're allowed to stay on to deliberate or not. So yeah, we'll see. Or they might be sent home and then come back fresh on Thursday to deliberate. So we'll see. So I'm guessing Thursday would be my guess. They will wrap it all up, as in verdict and everything. And so we'll see. Gigi, hello to you. Howdy. How are you doing, Gigi? Hope you're well, my darling. Care, good morning to you. Hope you're well. Afternoon. Yaya Trucker. Hope you had a great night. I did, thank you very much, Yaya Trucker. Hope you had a lovely night as well, you and Winnie the Pooh. Good morning to you, Shari. Oh, Shari, was that you that I just... Shari, I love it. So Shari just had a cheese and rice t-shirt delivered. And look at the dog. Happy days. Thank you for sharing that on Twitter, Shari. I've just literally... Oh, I didn't even realize I don't even follow you. I follow you now. I just literally liked and shared it, Shari. So there you go. Thank you for your support, my darling. I appreciate that. It looks great. SRA, hello, morning to you. Hope you're well. There you go, Wayne. Bond, happy 5 o'clock everywhere. Yes, somewhere it's 5 o'clock, isn't it? Oh, Susanna, it's Susanna. Oh, Susanna, day and night. How are you doing, my darling? Nice to see you. Disney Queen, how are we, Karen? Hope you're well as well, my darling. Karen, good morning to you. Happy Friday. It's Friday. Fuck, is it? Yeah, I forgot it's Friday. I thought it was Thursday for some reason. Hello, Karen. Hello, Lisa. Good morning. Afternoon, Dylan mods and chat. Hello to you, my darling. Hope you're well. I'm not sure the mods are here yet. Kirsty, good day, Sheila. Good day, mate. How's it going, Sheila? Lovely to see you, Kirsty. Hello, my darling. Nice to see you. Love this channel. Thank you very much. I appreciate that. Granny doesn't like my channel. Granny told me to fuck off. So if people don't know, Granny told me there's a username called Granny who told me a couple of days ago she did not like my views. So she would be leaving my channel. So I was like, okay, thank you. Katrina, how are you? Good morning to you. Thank God it's Friday. I know. I just realized it's Friday. Factually innocent is different from legally not guilty. No, well, I mean, yeah, okay. I could dispute that with you, but okay. Fairy Land Acres. Good morning, Dalan, and everyone from the Sunshine State. Hello to you, Fairy. Hope you're well. Hello, Lady Law, my darling. How are you? Nice to see you on the way to work, I believe. Hope you're well, my darling. Good afternoon, Dalan X and all not proved anything to me. Hello, Dawn. Nice to see you, my darling. Hope you're well. Deb, how are you? You okay? Nice to see you, as always. Kelly, nice to see you as well. No worries. Oh, yeah, Kelly, I just said hello to you. Sorry, I'm in the zone, you see. Saying hello to everybody. Lavina, nice to see you. You popped in yesterday. I did see you. Hello to you. Shari, yes, that was me. I know, just followed you back. I didn't realize I wasn't following you. People follow me. I don't get notifications of it. So I didn't realize, but I followed you back now. Thank you for the tweet. I have to cut the grass so it'll be in and out. No worries. Listen to it. It's going to be interesting defense. See what they put together. Ariel spent this morning catching up on the trial. The state case was underwhelming at best. I totally agree with you. I expected a lot more, Ariel. Yes, a lot more. Carol, don't forget to press the like button. Please like it, people. 30 of you have liked this. That's fine. There's 40 here, 30 have liked it. That's good. That's fine. Otherwise, I'll have to play the song again, people. Wayne, got a feeling jury won't be out for long either. Yeah, it depends really. It depends. because it just takes one person to either be guilty, not guilty. So, and they could be stubborn. So, factually innocent produces a kind of overwhelming public support we see in Karen's Reed case or in some of the Innocence Project. But there's overwhelming support for her. That's what I mean. There's a lot of people that think she's factually innocent. So it's the same thing, really. There's a lot of protesters out there. So just because potentially we're not involved in it as much, there's a lot of people that think she's factually innocent. And the protesters, this is why they call it the Karen Reed 2.0 trial. Hi, Sean, Dylan, but that's fine, Sandra. Sandy from Palmer, Mass, listening to you at work, sneaking my phone. Thank you very much, Sandra. Hope you're well, my darling. Hope you're well. What's happening there, Chappie? Hey, where you been? You're late. I got to dock your wages now, Hack. What's going on? Hope you're well, Hackster. Hope everything's well. James, I'm not going to dispute with you, man. It's whatever. It's what do you call it? There's a huge amount of support for her. Do you know what I mean? We're engaged with Karen Reed a lot on it. We see her a lot, but there's a lot of people on the streets that really do believe she's innocent, factually innocent. And the same with Karen. Is she factually innocent? I mean, people could debate that as well. So there's more of a divide than I think. I would say. I would say probably there's more support for Karen, yes, but don't underestimate how much support there is for Ashley out there as well. There's a ton to support. There you go. I needed that. Thank you, Hackster. I can pin that now. Dock my wages. Well, I mean the T-shirt things. I think this case is a bit tricky because we know she killed him, but was it self-defense? Yeah. I mean, this is where you got all the domestic violence stuff into it and stuff. There's a lot of groups, obviously, about that around there as well, which, I'm not an expert on. I don't really touch upon it, but I know that a lot of people in here have discussed it. And, it's not a surprise to me that most of you think she's not guilty. So from discussions that I've seen all of you have in here. Morning, Amy. How are you doing, my darling? Hope you're well as well. Nice to see you. Nice. Lou Barber. Hello, my darling. Oh, baby Archie. Baby Archie's back. Is that you or that your daughter, Lou? Because you look young as hell. Anyway, but I think that's your daughter. But it wouldn't surprise me if that was you, Lou. Hope you're well. And that everybody that is welcome to Baby Archie. If people don't know, Baby Archie was born during the Karen Reed trial, and she's there. He's there. He's a cutie, absolute cutie pie. TJ, good morning to you, TJ. Welcome back, third day running. Wonder who Mr. Taylor is calling for defense. Tons. A lot of people are coming back. A lot of people will be coming back as well that we've seen already. As a TV survivor myself, I believe she was abused. Should she have done it this? No, but understand it. Yeah, I think that there's a lot of views on that. As I say, I'm sorry to hear that you went through that, Amy. As I say, I don't really touch upon it. I let you guys speak about it in a safe space. I don't feel like I can contribute towards it, but I do enjoy learning a lot more about it. I've learned a lot from you guys, so thank you for sharing your stories, all of you. I know there might be some of you that haven't shared your stories, and that's absolutely fine as well. Just know it's a safe space here. You can if you want to. And that's you. Fucking hell, Lou, you look fucking super sweet, super young. I know I won't say your age. I know your age, but you look super young. Oil of you or something. It's it's good. Fair play to you. It does. I honestly, I thought that was your daughter, but I should have known better. I think she has to take the stand. Once she does, I will make up my mind. She seems sus to me still. I've not made up my mind yet, which means you're not guilty, Erin, currently. So you're on the not guilty train. But we'll see. I don't know. We'll see if she takes a stand or not. You know what? After the prosecution rested, I think that she should have taken a stand as well, right? Because apparently that's what you should do in self-defense cases. But I think the state's case was so underwhelming and so bad that I don't actually think she needs to take the stand right now. Personally, I don't. But we'll see. Hey, Brandon, how we doing, Brandon Best? Good morning to you. Hope you're well. Ashley says not on trial. Free her, Maine. I agree, Erin. There you go. Same here, lady in Boston, TV victim here. Sorry, boss, Sassy as well. There's a lot of you, I know. There's a lot of you. And for those of you who have lived it, I cannot imagine. I never have. So it's hard for me to relate. Yeah, I can't relate to either. That's why I try to be respectful as I can to all of you. Sassy must be the coin share. Well, you're Celtic, so we're Celtic. We're related, Lou. It's fine. Good morning, Donna. How's the moving going? How's the family in loves? I love that. Good morning to you. How is the daughter-in-law and the son? Have they moved in properly yet? Hope everything's going well with you, Donna. Understood, Darren. Sorry to hear that, guys. The prosecutors have shown me absolutely nothing to make me say absolutely guilty. No, I mean, I know I've heard a lot more stuff outside of the court, but I can't even look at that. Do you know what I mean? So, and I know coming into this trial, a lot of people were saying that he was shot in the back and stuff. Well, we found out that's not true, So there's a lot of misinformation out there as well. So she looked very distraught yesterday. Yeah, this is heavy. This is heavy on her. Wherever if you think she's guilty, that's fine. But this is still heavy on her. On her shoulders. Wherever you think of her, it's bad. It's I believe, yes, so it's 25 years minimum she's looking at, 25 years to life. And if he does put the manslaughter stuff in, that's still up to 30 years. So she's fucked. If they put manslaughter in as a lesser charge, I think she'll be probably done as a compromise vote, which I hate that. But they're all settled. Happy days, Donna. Bond, yep, agree. They haven't seen any good evidence from the prosecution. No, I agree, James. I agree. Which is surprising to be fair. She should go on the stand. Can't be difficult. Gotcha question. She should go on the stand. Can't be difficult. Gotcha questions from. I normally would agree in this case, but I don't think they did anything for her to go on the stand. Terry, hello to you. How are you? I do know this. As a mom, I am very, very aware and observant of my daughters, so they do not live through that either. Good on you, Erin. No, the child is with her. Yes, the child is with her. Yes, the child lives with her. Okay, and I think her mother. I think it's a grandmother, mother, and daughter. Tricky case. So many can relate to Ashley, yet this is a case of self-defense, as Lee and law enforcement and other agencies claim no DV. If all DV victims could shoot to kill and walk, well, this wouldn't be the USA. Yeah. 25 years minimum, Wayne. Minimum 25 years. 25 years to life. So I thought I heard she's living with her mum and daughter is there too, but I don't know. Yeah, no, that's what it is. Yes, is she paying for the attorney, or she's paying for the attorney? I believe. I believe. Well, we've seen this, haven't we? Law enforcement can be very wrong. We've seen this countless times. How bad law enforcement can be. Hang on. Right, the court is there. I'll put it up now, but no, nothing's moving. If not guilty, will you reach out and ask her to dance for us? Can you imagine? I hope that didn't come out the wrong way. No, I don't think it came out the wrong way. I know what you mean. I know what you mean. It's hard sometimes with words to find the right word, isn't it? They're genuine DV victims, and there's people maybe that aren't. So yeah, it's hard. Oh, she's just arrived. Hang on. She's let her hair down today a little bit. I'm really conflicted with this one. I'm not sure either side have convinced me of guilt or that it was self-defense. I grew up with DV. I'm a survivor myself. I'm really Not sure. Thank you, Lou, for sharing that. Yeah, well, this means that she's not guilty, Lou. If you're not convinced she's guilty, so I would say that means she's in your eyes currently. But the defense haven't put the case on yet. And also, what you need to remember as well, people, is we don't know what the jury instructions are going to be. What is manslaughter? What is murder two in Florida? So we need to look at that as well. So it might tick some boxes, not others. So we'll wait for them. At the minute, I'm not guilty, but that could definitely change. Remember, the prosecution can put a rebuttal case on as well. So we'll see. People in the chat say they watched the deep dives on Grizzly True Crime. Not sure if anyone have watched that. Grizzly did a deep dive on a Minnesota case, and her facts are way off. Yeah, I don't watch Grizzly. I used to, but she's done a few cases where she's been, I'm not going to say wrong, but she stopped quite being. Yeah, there's a couple of people have said this to me as well, Erin. You're not the first one to say that. She doesn't show all the evidence, is what I would say. So I like Grizzly. I think she's good, but I don't watch her anymore for deep dives. That's why I do my own deep dives. What I see is what you guys get. Basically, she's good at it. Don't get me wrong, but it's just she has. I've seen her give wrong information before as well. That Boone trial should be good when she. Do you know what? I was talking to Sean, potentially criminal, about this, and I said the same. Should be good, and he said no, it's going to be a shit trial because it's just going to be a mess with her. It's going to be a frustrating trial. He said, as viewers, we're going to be really frustrated with the trial because she doesn't know the law, and it's going to be a mess. So we'll see. We'll see. I'm still probably going to cover it though. Hello, Young. How you doing, my darling? Hope you're well. Lady in Boston, we've certainly seen this in Carlton, Stoughton, the horse. Yes. OMG. People who make that kind of thing up is like Amber Heard. If you watch that trial, you'll see the.
Good morning, everybody. We're back on the record in the state of Florida versus Ashley Benefield, 2020 CF 3014. It's Friday, July 26th. We're getting ready to start for the morning.
Hey, Jessica.
When we left yesterday, my understanding that you were off to talk to Miss Brown.
I spoke to her.
Right. Are there any matters that need to be brought up before we bring the jury in?
Not to my knowledge.
Defense? We're ready. You ready?
Hey, Jem.
Right.
How we doing, Jem?
I'm not sure if they're up yet. All right. We're a few minutes early, but we'll go ahead and get started. Go ahead and bring them in.
Hello, everybody, if I missed you. Hello, Toots. Hey, as well, Jessica. Hello to Logan. Hello to Carter. Hope you boys doing well. Morning, Jem. Wonder what the case would look like. Different prosecution team. Well, there's that. Yeah, there's that. Yeah. Hello, Darcy. There are lots of you here. Hello to you all. I love you all. Thank you for being here, people. Steph, good day, mate. Ole. Erin, ha, ole. See you later. Scared me too as well, Toots. Apparently,
Good morning, everybody. Welcome back. The usual questions. Did anybody discuss the case amongst yourselves? Begin deliberations? Did anybody talk with anybody outside of this jury about the case or do any research on the people, places, things, or legal topics we've heard anything about?
Yeah.
No, sir. When you left yesterday, the state had rested its case. Mr. Taylor.
Thank you, Judge White. We call Faith Brown.
Case the clerk, may you read this one?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do.
Good morning, ma'am.
Good morning, Your Honor.
Just please make yourself comfortable in that chair. Pull yourself up to you're about 12 to 15 inches from the microphone. It does adjust up, down, left, right, however you need it. If you just speak in a loud, clear voice, it'll pick everything up.
Thank you, Your Honor.
Good morning.
Good morning.
Will you tell us your name, spell your last name for the court reporter?
Faith Brown, Brown.
Ms. Brown, are you employed?
Yes,
How?
I am an attorney.
And how long have you been practicing?
Not quite 20 years.
Do you have a specialty?
I practice exclusively family law.
And in your practice of family law, is email communications traditionally used on behalf of you and your firm?
On a day, yes,
Okay. Do email communications, are they employed in correspondence with the various courts that you have matters pending in?
yes.
Is the exchange directly with the judge or representative?
The representative,
And their title is what?
judicial assistant, or JA.
Mhm. And these emails, Ms. Brown, are they ordinarily sent and received in the normal course of business for your firm?
Yes,
And are they kept under your care and custody?
yes,
Are the emails preserved at or about the time that they are either received or sent?
yes.
I'm going to pass to you, Ms. Brown. May I, Your Honor?
Yes, ma'am. Yes, sir. I'm sorry.
I'm going to pass to you what I marked as Defendant's Exhibit 6 and ask you if you would take a moment and review that. Just give me a moment. I'm going to show it to the prosecutor. While they're reviewing that, in September of 2020, were you representing Ashley Benefield
I was.
in family court?
Yes, I was.
And what case do the contents of Defendant's Exhibit 6 represent?
This was in reference to the petition for injunction for protection against domestic violence that I filed on behalf of Ashley Benefield and her daughter, Emerson Canny.
All right. Are those emails an true and accurate reproduction of the emails that you sent and received on that day or those days?
Yes, they are.
Your Honor, I'd move at this time to introduce that as Defendant's Exhibit number 6 into evidence.
Any objection?
No.
And received.
Thank you. That is a string of emails that covers a range of dates.
Yes, it is.
Would you tell the ladies and gentlemen of the jury, Ms. Brown, what date the first email starts on?
Sure. The first date was September 17th of 2020.
And when is the last email?
The last email is when I forwarded the email to my client, Ashley Benefield, on September 23rd, 2020 at 9:30 a.m. But are you referencing the last email between the three of us in the email?
My next question indeed is, would you be kind enough to tell ladies and gentlemen of the jury who were the participants in this string of emails?
The participants in the stream of emails was Vicki Mechanic, who was the judicial assistant to Judge Diana Moreland, who was the judge presiding over this matter, Stephanie Murphy, who was representing Douglas Benefield, and myself.
And it's normal and customary, is it not, to the extent Ms. Murphy would be representing the adverse party, that you would share all correspondence with her between you and the judicial assistant?
Yes, it was a requirement.
Okay. Do you recall, having reviewed the email, was there a particular issue in play?
Yes.
What was it?
We were trying to, initially, we were trying to stipulate to the release of Dr. Brad Broder's report.
And were you attempting to secure a date to do that?
Yes, we were. Well, eventually.
Okay, so I have some very specific questions for you. First, would you tell us whether or not, based on that correspondence, Dr. Broder's report was set for release on September 30th, 2020?
It was not.
In fact, based on those emails between you, Stephanie Murphy, and Judge Moreland's JA, was there even a date that existed at that time for the release of Dr. Broder's report?
There was not.
If somebody testified that the release of Dr. Broder's report was set for September 30th, would that be accurate?
Oh, sustained.
Would you take a moment, if you don't mind, and read the emails?
Sure. Did you want me to read them out loud or to myself?
Yes, read them out loud and start with the string in chronological order. It covers a 6-day period. 17th to the 23rd.
The 17th to the 23rd, yes. The first email was on September 17th of 2020. It was a Thursday, from Attorney Stephanie Murphy to Family Division 4, which was the judicial assistant's email address. I was CC'd on it, as well as my paralegal's email address, Sarah Hawk at myflfamilies.com, and Dr. Brad Broder. It states, "Good afternoon, Vicki. I hope you are doing well and have had a good week. Please see the attached joint motion for release of psychological evaluation and report and correspondence regarding same with regard to the above referenced case. Thank you, Stephanie." Shortly thereafter, same day, the judicial assistant responded, "Received, thank you. Can one of you kindly prepare a proposed order in case the judge wishes to grant your motion?" About 30 minutes later, Ms. Murphy responded, "Thank you, Vicki. I will work on that right now and send it to Ms. Brown for her approval." The next morning, Friday the 18th at 10:18 a.m., we received a response from the judicial assistant, marked importance high, that stated, "Good morning, Ms. Murphy and Ms. Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation and report. The judge will allow an expedited hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. Broder and Manatee Children's Services must be present at the hearing as well." And must be present at the hearing as well is underlined. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only, and only is underlined, matter being heard on September 30th day is the injunction hearing. And then the next sentence is also underlined. Please advise whether Wednesday, September 23rd will work for all parties. Thank you, Vicki Mechanic, Judicial Assistant to Judge Moreland. A few minutes later, Attorney Murphy responded with an email that said, "Thank you so much for all of this information, Vicki. I admit that I did not go back to check what is scheduled for that hearing, so please accept my apology. In my mind, these cases have always overlapped so much that I just took it for granted that the upcoming hearing is just the DVI. I am available for that hearing. I will contact Dr. Broder, and we are trying to track down the correct attorney who represents Manatee County. Sarah Hawk, it appears, represents Sarasota only." The next email was actually from my assistant at the admin email address, because she handles my calendar, September 18th at 10:58 a.m., where she stated, "Ms. Brown is available at 9 a.m. However, she has mediation starting at 9:30. The next email was about 2 minutes later from the JA, stating, if this goes forward on the 23rd, it shall be via Zoom." Then at 2:09 p.m., Attorney Murphy emailed, "Good afternoon, Vicki. Ms. Brown and I are both available next Wednesday at 9 a.m. on Zoom. Dr. Broder is not available as he is out of town on an anniversary vacation with his wife. I have calls into 3 different people with Manatee Children's Legal Services, including the DCF regional headquarters, to find out who needs to be included from the organization in the hearing. We have been directed and redirected to the wrong people several times. Can we go ahead and set the hearing?" The next email was about 15 minutes later from the JA stating, "Good afternoon. No, per my email to you both this morning, the judge stated that Dr. Broder must be present at the hearing. Vicki." So that was Friday, the 18th. The next email was Tuesday, September 22nd at 2:20 from Stephanie Murphy, where she wrote, "Good afternoon, Vicki. Dr. Broder never got back to me regarding whether he could appear at the hearing, even by audio only, while he is on vacation. So I wanted to let you know that per your prior emails, we cannot have the hearing tomorrow morning. When Dr. Broder did speak with Attorney Faith Brown on Friday, he told her that he would be returning Wednesday night. Is there any chance that Judge Moreland could schedule the hearing for Thursday? We will be in mediation in this case, but we can take a break to do the Zoom hearing."
What is the JA, Ms. Mechanic's response to that request?
Unfortunately, no. The judge has a full docket on Thursday, and even if she didn't, Manatee Children's Services would need to be present as well.
All right.
That was Tuesday, September 22nd. So then on Wednesday, September 23rd at 1:02 p.m., Ms. Murphy, Attorney Murphy, wrote, "Good afternoon, Vicki. I've spoken with Attorney Kimberly Griffin, who represents CPS, and who confirmed that she is the attorney who will need to be present for the hearing per Judge Moreland's instructions. Now that we know who the hearing needs to be coordinated with and Dr. Broder is returning tonight, can you please forward additional hearing dates and times for this matter?" To which the judicial assistant responded about 25 minutes later. "Unfortunately, there is no availability before the injunction date of the 30th.
All right. Was there anything unclear about the fact that the only thing being heard on September 30th, 2020 was the injunction?
No.
Was there any chance, under any circumstances, Dr. Broder's report was going to be released on September 30th, 2020?
No.
I don't believe I have anything further, Your Honor.
Cross?
Yes.
I just went through these emails along with you, and you say it's very clear that the release of the report was not going to be heard on the 30th. In reading this, it's hard to get that because the last email says, unfortunately, there's no availability before the injunction date of the 30th. But that still means if the attorney got the doctor and the appropriate people present, that it maybe could be heard on that date, correct?
No.
Okay, so it was your understanding it was not going to happen?
Correct.
All right. What was your understanding of what was going to happen on that date, on the 30th?
The injunction for protection against domestic violence hearing was going to be held that afternoon.
Okay, so you were going to call witnesses, you were prepared to call witnesses?
Yes.
Okay, and have a full hearing on Ashley Benefield's motion to get an injunction against Doug Benefield. What? I didn't.
I'm sorry, can you repeat the question?
So the hearing on 9:30 was, in your opinion, only to hear the motion to get an injunction that was filed by Ashley Benefield against Doug Benefield, and that was the only thing to be heard on that day?
Correct.
Okay. And wasn't it true that previously you had agreed to drop that injunction?
It's sustained.
No further questions.
Peter?
That's all, just a request to publish the email.
Absolutely. By passing? Okay, and can this witness be released?
Yes.
And can the witness be released?
Yes, Judge.
Ma'am, you're released from your subpoena, you're free to go.
Thank you, Your Honor.
Thank you. No.
Oh, so sorry.
Pass it around.
Thank you.
Do you believe in the man on the moon? Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. I don't know the Cher songs. I don't know them. It's frustrating. She's got some power ballads, hasn't she? But I don't really know them. What are we waiting for? I don't understand. Anyway, hello Rebecca. Hello Nikki C. Life is hell. What could do? I have press some other. Like, ooh. Oh, nice hippie chick. Nice. What are they doing? No idea. But I'm actually reading the chat today. First time I've smiled all week. Ah, nice, Lou. Nice to hear that. There you go. Hey, potty mouth. Do you believe in life after love? Synthesizers, life or love? Do you believe? I need to get the tune. I don't know it. Oh, thank you, Ariel. Thank you, Ariel. Perfect. Thank you. You see, someone's on the ball here. Thank you, Ariel. What? What have I done now, Steph? Go on. Let's go, Rebecca. Stop it. Stop right now. Thank you very much. I need somebody with a human touch. Hey, you, always on the run. Da 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 da. Hold my bum. Ba-da-ba-ba. If I could turn back time, if I could turn away, do you believe in life after love? Okay, I know that if I could turn back time, if I could something, whoa. I love the opening ceremony. Oh, I missed it. Yeah, I don't know the tune of that. I could, if I could turn back time, if I could find a way. God, I beg you, do not say shit. Okay, fine. Hey, morning, Vicky. Okay, Sassy, I won't. Who am I fooling? Crazy it is. Hey, where were you yesterday, Potty Mouse? We missed you yesterday. Leslie Ann, good morning, my darling. This case, the Clarice case, highlights why most courts still don't allow cameras. State authorities should be embarrassed that they charge there is no evidence of intent. I don't disagree with you at all there, Leslie. Don't disagree with you. Like that song. See, you know the song. Yeah, I just, the tune, how it goes. Some of them I don't remember. Ariel always knows. I'm useful, dope. I love Cher.
Can the attorney's approach for me?
I love Cher. Ariel, useful sometimes. Not knowing the song, you're cute. The songs I know are like, ole, 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 ole. Erin ha, Erin ha, ole. And do you all see Erin's taco? This is Erin's taco. Her personal taco. Multitasking with it. It tastes good. And you can play with it. It's good, isn't it? Oops. Put it back the wrong way. Oopsie. Love it. I know, Brandon. There's loads. I think it's James, you, and Wayne. I know. Find a way. Oh, I'm way behind. 7 p.m. tonight. Mask. I'll take back those words that hurt you, and you'd say, if I could turn back time, if I could find a way. The Celtic fans case yesterday where the women I was found not guilty. Yeah, Thompson, yeah, that was incredible. Did you see the judge, though? The judge was a right bitch when they read the verdict. Woof! Yeah, she testified. I think she was on the stand for like 2 whole days. Sorry, sassy. Hey, Joe. JB, just awful move. No, JB, what? What's awful? My singing. Hey, TJ, no, just the jury are looking at the emails, that's all. I take back all the words that hurt you, and you'd stay if I could turn back time. For fuck's sakes. Hack, hack, hack. Oops. I've had 3. I got a me darling. Yes, Leslie, my darling. You're all my darling. Good morning to you, Linda. How are you doing, my darling? Right, bitch. Hello, Joe. Huh. Yeah, I think so. Depends on timing of it. There's no date set yet, but I think so. Unless it clashes with something else. So I'm 90% sure I'll cover it. But like if it clashes with like say Karen Reed, then no. Do you know what I mean? So it depends. Yeah. Oh, you actually taking the bar, Ariel? You actually taking the bar? Oh, good luck to you, Ariel. I thought Erin Hack was joking. Oh, best of luck to you, Ariel. If I could reach the stars, I'd give all to you. Then you'd love me. Then you'd love me, like you used to do. If I could turn back time. Yeah, good luck. Oh no, I got you, Ariel. In Michigan. Well, good luck, Ariel. Everyone say good luck to you. Dan, she's fired enough for covering it like she fired every goddamn attorney. I still haven't thought the prosecution would do more. Yes, I agree. My darling? I don't know when you're serious or not. That's the problem. I'm embarrassed to admit that I gotta be a Yeah, but you gotta start off and be a prosecutor, though, don't you? It's good that you're a prosecutor, so you got that experience, and then you become a defense attorney. Well, what will the defense do to shift the burden? I mean, just see what they will do. I'm interested. You're all my darlings in the chat. You're all El Chatty. Everyone in El Chatty is my darlings. Well, not everybody. A few of you can, you know who you are. That can piss off, but most of you, 99% of you, are my darlings.
All right, the jury has completed their review of Defendant's Exhibit 6. Mr. Taylor, your next witness.
Yes, sir. The defense calls Ashley Benefield.
What? The fuck? She's testifying. She's testifying, everybody. Fucking hell. Okay, here we go. Right.
Do you solemnly swear or affirm that the testimony
Fuck.
about to give will be the truth, the whole truth, and nothing but the truth?
Right. Calm your tits. Strap yourselves in. Let's fucking go. Let's fucking go. I did not expect this. Let's go, people.
Good morning, Ms. Benefield. As you've heard me tell other witnesses, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, to right. And if you speak in a loud, clear voice, the electronics will pick up everything.
Okay.
Mr. Taylor.
Good morning. Will you tell us your full name and spell your last name, please?
Ashley Christina Benefield, Benefield.
How are you feeling this morning, Ashley?
Nervous.
All right. Try best you can to relax and we'll get through this.
Okay.
Tell us a little bit, Ashley, about where you were born and raised.
I was born in Corpus Christi, Texas, and I grew up in Annapolis, Maryland.
What type of family values were instilled in you?
Objection, relevant.
Oh,
I believe in the importance of kindness and compassion, empathy, honesty, hard work, accountability.
What type of work did your father do?
My
Objection, relevant.
I'll allow it.
my dad was a Naval Academy graduate who was a Navy pilot, and then started flying privately for the airlines, which is what he still does.
And how about your mom?
When I was born, my parents decided that my mom would stay home to take care of me full time since my dad traveled so much.
I want to ask you a few questions about your childhood. Did you have any siblings?
I grew up an only child.
Were your parents active in your development as a child?
Yes, they were very active in my schooling and supportive of my pursuit of the arts.
Hold on 1 second. I'm sorry. We need some. Get some headsets. How many? Oh, I'm sorry. I apologize. I misunderstood. All right, Ms. Benefield, yeah, if you could scoot a little bit closer and speak up so the jury can hear you.
Okay, I'm sorry.
Do the best.
I apologize. Go ahead, sir.
Sure, do the best you can, Ashley.
Okay.
Do you have any hobbies?
I love art. I like drawing, painting, sculpting, ballet. I enjoy gardening, baking, cooking. Most importantly, I'm a mom.
What type of high school did you attend?
Objection.
I'm going to sustain at this point.
I'm trying to establish her ballet, Your Honor.
All right. If it's it's related to something specific, then
Yes,
yes.
sir. Thank you. Tell us about your high school, Ashley.
I went to a small private Christian school.
And did you study anything in particular in high school?
I was focused on pursuing ballet.
And was ballet a large part of your curriculum when you were in high school?
Yes, I danced full time. I actually finished my last few credits my senior year with an accredited homeschool program for athletes, so I could dance during the day.
Do you still dance professionally?
No.
Why not?
I retired after I tore my hamstring.
I want to ask you about Doug. When did the two of you meet?
We met August 25th of 2016.
And tell us what your impression of him was when you met.
He was very confident in who he was, passionate about what he was doing for work. He was fascinating to talk to.
What was it, if you recall in particular, that attracted you to him, Ashley?
He was funny, very smart, charming. We just instantly clicked.
Was Doug in the military?
Yes, just like my dad, he was in naval aviation.
Did he turn out to be who you thought he was?
No, not at all.
I want to direct your attention, Ashley, now, if I can, to the day of the homicide, September 27, 2020.
Okay.
Specifically late in the afternoon. Would you tell us why Doug was at your home?
He came over to help load some of the larger items that my mom and I had kind of pre-staged in the garage into the U-Haul truck.
And were there any discussions between the two of you about the order that these things should be placed in the back of the truck?
Yes, we had discussed that my things would be going in last, right at the front, so they would be easy to get out first. At one point, he had me help him load one of the larger pieces into the back of the U-Haul truck. And when I was up in the truck with him, I realized that everything had been all like mixed together and it was no longer separated. And I pointed that out to him, and he got really offended and upset. He said, "It shouldn't be your stuff, my stuff, your house, my house."
Was there a particular demand he made at that time?
He said I needed to start acting like a wife.
Tell us at that point how you chose to deal with him.
I tried to change the subject. I could see how upset he was getting. So I wanted to kind of alleviate that.
And how was Doug reacting to your efforts to do that?
He was getting more upset and aggressive and threatening.
Do you attempt to avoid confrontation with him?
Yes.
What do you do?
I was trying to get him to leave. I kept suggesting that maybe we should be done, saying I was tired. We should just wrap it up for the day.
And what was Doug's reaction to that effort?
He heard me, but he completely disregarded what I was saying.
Ashley, would you tell us if there came a time shortly thereafter where there was physical contact between the two of you?
Yes.
Tell us about it.
We were in the living room, and as he came up to me, instead of walking past me, he walked like right into me, like a body check. He like thumped me.
His shoulder to your shoulder?
Yes.
And describe for us, if you can, the the force of the bump?
It caught me off guard. I almost fell. I stumbled.
How was he acting at that point?
He was clearly hostile. He was mumbling under his breath and was glaring at me.
What was your concern?
I could see that it was escalating, and I didn't want him to blow up at me.
Was there a second instance of physical contact?
Yes.
Tell us about that, please.
We were in the garage, and it was very much like the living room. I had just suggested strongly that I wanted to be done for the day. And he, as he came up to me, he walked right into me. Again, body checked me.
Finally, was there a third instance of contact?
Yes.
What happened?
We were in the hallway, and we were coming opposite directions towards each other, and he had a box. And as he walked up to me, he looked me in the eye, and he drove the corner of the box up into me.
Where?
My side.
Indicating on your right side.
Yes, sir.
In the hip area?
Yes, sir.
What was the result of that?
Scratching. It burned.
Yes, sir.
Ashley, I'm going to hand you what's been marked as defense exhibit numbers 8, 9, and 10. Pat,
Yeah, just do me a favor, whenever you're holding them up, they were facing the jury until they're admitted.
Sorry.
Yes, sir, thank you very much. 8, 9, and 10?
Yes, sir. Will you tell us what Exhibit 8 represents, Ashley?
It's a scratch right here.
And was that scratch caused by the cardboard box that you just related?
Yes, sir.
When was that photograph taken?
The night of September 27th, 2020 at the sheriff's office.
Okay, and how about exhibit number 9?
Also scratches on my side.
From the same incident?
Yes, sir.
Also taken that evening at the sheriff's office?
Yes, sir.
Okay, and exhibit 10?
The same scratches as in 9. They're just, it's a close-up.
Do these photographs, Ashley, truly and accurately reflect the scratches and bruises you received on late that afternoon on September 27, 2020?
Yes.
Do they accurately reflect how the scratches looked when they were fresh?
Yes.
Thank you. I move respectfully, Your Honor, defense exhibits 8, 9, and 10 into evidence.
Any objection?
No.
They'll be received.
What was your response, Ashley, after being struck by the cardboard box?
I apologized.
Why would you have apologized?
Because I could see how upset he was, and I didn't want him to get more mad at me.
Where does Doug go after that incident?
He continued to the garage with the box.
And what happens at that point?
We started getting into a back and forth about being done for the day and what still needed to be packed and that I wanted to be done. And we ended up in our daughter's bedroom, and he started screaming at me. He said, "Shut the fuck up." He started calling me names. And he said, "I can see what you're doing. You're trying to get me to leave." He said, "I don't have to leave. I can stay and spend the night if I want to because I'm your husband."
At that point, Ashley, how did you feel with respect to your own personal safety?
I was scared.
Did you take any steps to try to avoid anything further?
Yes, I ran to try to leave the house.
And where did you run to?
To the front door.
Did you make it?
No.
Tell us what happened.
He stopped me. He grabbed me by the hand and he yanked me back. I'm not really sure how he did it, but he spun around so he was in front of me, between me and the door.
So
He said,
I'm sorry, go ahead.
he said, "Where the fuck do you think you're going?"
What was your response? Do you specifically recall? Tell us.
I just blurted it out. I said, "I'm done and you need to leave now."
What was Doug's reaction to that command to leave now?
He said, "You can't fucking leave me."
Then what happens?
He hit me on the side of the head.
Ashley, I'm going to ask you what's been marked as defendant's exhibit number 7. Tell us what that represents.
It's a picture of my face.
Is it an accurate picture of what your face looked like on that night?
Yes, sir.
Who took that photograph?
I don't remember her name. She was at the sheriff's office.
At the sheriff's office? Okay. Now, what is it about that photograph that shows or reflects the slap or the hit that you got to the side of your head on that day by Doug?
That side of my face is swollen and puffy and discolored around my eye.
And is your eyelid drooping?
Yes.
On the side where you were hit?
Yes.
Your Honor, I move defense exhibit number 7 into evidence.
Received.
What was different at that moment, Ashley, than at any time in your prior relationship with Doug?
He had never actually hit me before.
What did you do?
I ran
Where?
to my room
Why?
because I was scared.
Ashley, did you have anything in your room that could protect you?
I had my gun.
Did you grab the gun?
Yes.
As you're grabbing the gun, what, if anything, did you hear?
I heard the door hitting the doorstop.
As if it is flung open?
Yes.
And what do you see, Ashley, when you look up?
Doug was standing in the doorway. His face was red. Like the veins were bulging in his neck. The way he was looking at me, it didn't even look like Doug. His eyes were black.
Does he yell anything at you?
He said, "You're fucking done."
And what does he do at that point?
I held the gun like in front of me and I said, "Stop."
And he like turned and he got into this like, it was like a fighting stance. I got low and he started like moving his arms and his hands around. He was making these like jerking motions.
What were you expecting when you were holding the gun out in front of you and you told him to stop?
I thought when he saw it, he would leave.
Did he?
No.
At that point, Ashley, what are you thinking?
I thought he was going to kill me.
Tell us what happens next.
He started coming towards me, and then he lunged at me, and I started pulling the trigger. And he just kept coming, and I remember trying to move to get away from him, but he kept coming at me.
Ashley, would you tell us why, if you're holding a loaded firearm, you were attempting to move away?
I was trying to get away from him. I was terrified.
All right, so you're firing. He keeps advancing. What happens next?
It was like his feet slipped out from under him and his legs went up in the air.
When Doug hits the floor, what's your immediate reaction?
I ran to get help.
Can you tell us how many shots you fired?
I have no idea. I was in a panic.
Do you remember anything about the shooting beyond what you've told us here?
It was a blur.
Where did you run for help, Ashley?
To my neighbor's house.
What's your neighbor's name?
John Sept.
Ashley, I have to ask you a couple of very difficult questions. You okay?
Yeah, sorry.
Ashley, tell the ladies and gentlemen of the jury why you shot Doug.
I was scared to death. I thought he was going to kill me. There was nowhere to go. I was trapped. In my own house, he wouldn't let me leave.
As you sit here today, Ashley, how do you feel about what happened?
Horrible. He's the father of my child. So I'm going to have to explain it all to her.
Judge, I wonder, could we have a minute, maybe a brief recess, like have her compose herself?
All right. Members of the jury, if you can step out for a couple of minutes, we'll bring you right back. Just leave your notes where they are. You put them face down. Please don't begin your deliberations. You can use your phones, but don't talk with anybody outside the jury about the case. Don't do any research on the people, places, things, or legal topics we're going to talk anything about. Thank you. All right, you all can have a seat. Ms. Benefield, you can have a seat. Need to take a moment to compose yourself?
Yeah, would it be all right if she stepped out?
No, sir.
May I approach her? With no conversation?
As long as you don't say anything. Yeah.
Not say a word.
Yes.
I think I'm with similar to Josie in a way. Like we need to see her on cross-examination. I'm not going to judge her on just this. I want to see how she deals with cross-examination.
I'm sorry.
Ma'am, there's Kleenexes here next to you. Those.
Okay, thank you.
Yeah, I do get it though. I don't really see tears. I get what people are saying though.
I'm sorry.
All right, Judge, I think you can bring it back in.
Okay, great. All right, let's go and bring the jury back in.
We'll see how she does in cross. I like to see the divisiveness in chat as well. Some are
Yes,
like
sir. They might have stepped into the facility, so we'll wait a minute.
two different camps. You know what I mean? Hello, Stormcar. Hello, everybody. Hello, Wendy. Hello. I'm not sure who's coming now. Kathleen, Dana. If you didn't see Resistance to Silence last night, go and watch it. It was a good show. I've not watched it all yet. They got new merch out and everything, so go and support Resistance to Silence. And I will support them as long as Dana does not wear a tank top. I've said that. Good morning, Munchie, as well. Hello to you. You're late. That's why you come at the right time, I think. Right. I'll go back to this now then. Oops, wrong one. Where's it gone? Tootly Pip, hello, my darling. Okay, don't move on. It's okay. It's just different opinions. That's all. Okay, it's different opinions from people. This is what we're saying. Everyone's got a different opinion on it. I understand it could be tough, but please, you don't have to move on. Okay, just. But if you do, that's what take care of yourself. Okay.
All right, let's bring him in. Luscious. Luscious. All right, we're gonna it'll be a couple of more minutes till the jurors are finished with their break. So let's 9:56. Let's say at 10:05 we'll reconvene. Ms. Benefield, I'm going to allow you to leave the stand. However, you are in the middle of your testimony. You may not communicate with anyone at all during your testimony. Do you understand? So you can step down and use the facilities. That's just fine, but you cannot communicate even with your attorney while you're testifying. All right? Okay. You need to step out. You can do so. So we'll be in recess until about 10:05 or so.
Loopy. How are you doing, darling? Eva does not have a bra on. Yeah, I didn't like the laughing they had there. Listen, I get used to it. I do. I agree with Amy. I don't think this chat's bad. I get that some people don't maybe agree, and I know there's some comments about her faking it and stuff, but I just think we there's different opinions. I think it's a good thing that we have different opinions. Personally, I just hope that people don't take it personally, that others have different views, and that we restrict views. I want to hear views from everybody. Unfortunately, that means we do lose some people as well. But hopefully Care comes back. I like Care, but and if anyone else did leave as well, I hope they come back, but we will never constrain anyone's opinion, even if I don't personally believe she's faking it. I still validate that some of you do think she's faking it. So, because it's break time. It's break time. If I could turn back time. Do you think she's singing that? So, if I could fly away. Hang on, let's see how many likes we got. Oh, people. I have to play it. Dana's here, so I have to play it. Press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Here we go. We're back now. To be honest, I don't really want to watch her cry. You like 69, Chrissy? I know you do. Like we said yesterday, spread your legs. What was the song? Put your hands up in the air. It was like, put your legs up in the air, spread them out like you just don't care, ladies. Let's go. In reference to the judge, I always feel I've got to justify that. Judge said, spread your legs, so it turned into the song. Put your legs up in the air, spread them out like you just don't care. Ooh, yay. Let's go, judge. You dirty judge. You dirty judge. I love Christmas songs. I love them. I love Christmas songs, young. Munchie, hey, how you doing, Munchie? Hope you're well as well. Trauma's trauma and have to relive it again. Yes. Leslie, where's Leslie? Where is Leslie here? I'm not seeing Leslie. Dana loves the song. Press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Pros improve the case. I agree. Well, echo chambers are not good. Well, thankfully, no echo chambers with you, with that potty mouth of yours. So toxic, so different opinions are needed. Absolutely different opinions needed. Even if you totally disagree with the other person, it's not a bad thing. As Josie says, opinions are fine. We just don't do personal attacks here. And the chat is not personally attacking anyone. So have all the opinions you want. Yeah. Like, there's a lot of people in chat now I disagree with. I disagree with their opinions. I love your opinion though, because that means you got an opinion. What do we always say, people? Opinions are like arseholes. We've all got one. So the polls are 50-50. Hey, Jem. So chat's going to be to yeah. Which one, Jessica? Oh, the like and subscribe. It's absolutely terrible for Eva and Ashley. Both of these women, I believe, were traumatized by Doug. I hope those aren't. Oh, Leslie, you're Leslie. I was thinking, who's Leslie? You, Leslie. I have a big old titties. I wear one on my so my back doesn't hurt. There you go. You have to. Big old titties. I love it. And my movies. Hey, Jodie, how we doing, my darling? If people don't know, Jodie's recovering from COVID. Nice to see you, my darling. I felt her pain, and her saying I'm sorry is a big DV victim flag. There you go. Bum, 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 bum. Bum, 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 bum. Be, be, re, 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 re. Oh, Mike! Mike! I'll resubscribe if you don't sing. Oh, for fuck's sakes. Mike, man. Oh, I'll stop singing now for you, Mike. The judge was flirting. He was like, yeah, ladies, get ready, get set, go. Get your legs up in the air. No worries, Munchie. Closing today after actually no, I mean I'm surprised. Right, so this is the weird thing, right? Because they said there's about 2.5 days of testimony, and Ashley's straight on today. Is it because they think that she might do badly and just like get her out of the way? Because you'd finish with Ashley, but they put her on super early. Maybe it's just a case of look, let's just get it done today. Bum, ba-da, bum, ba, bum, bum, ba, ba, ba. Well, my favorite font. Throw your hands up in the air, but I can't for the life of me get to work on my devices anymore. Oh, is that font? Poke your eyes and pinch your cheeks. Crafty Cow, hello, my darling. Listening while putting messages away. I love that. For people that don't know what messages is, it's groceries. These Scottish people. It took me forever to understand what they meant by messages. I thought the post it was. No, it's groceries. Listening while putting groceries, messages away. I'm unsure on this. I tend to believe more than not she's being truthful. There you go. There you go, Steph. Let's fucking go. I'm way behind again. Right, let me just skip here then. Dennis Sweeney in the house. He's already liked it. Oh, I don't play Amber Heard. I don't want to play Amber Heard. If I'm being honest with you, I'm not a big fan. I don't think she did cry. I don't remember she had tears. Go on, Dennis.
Oh, all right. Thank you, be seated. All right, I've checked. The jury is all back. They're ready to go.
Ready.
Come on back. Ready?
Yep.
Hey, Jenny. How we doing, my darling?
Yes, I'm sorry.
Thanks, Mike. I can imagine. Morning, Justice. Morning, Pixie. Good day, mate. I got you, Heather.
Okay, let's go ahead and bring him in. All right, you all can have a seat. Welcome back, everybody. Did anybody begin deliberations or talk about the case amongst yourselves? Did anybody communicate with anybody outside the jury about the case? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
Everybody says no. Mr. Taylor, you can resume your direct examination.
Thank you, Judge White. Ashley, would you tell us where the pistol was in your bedroom?
It was in a storage bin. It was on top of my laundry basket.
Will you describe the storage bin?
It was like a square bin with hard sides and cloth covering the sides.
Do you remember how old Emerson, your child, was at the time of this incident?
About 2.
Was Emerson able to access that storage bin?
No,
Whose firearm was
mine.
it? Did you have a license?
Yes, sir.
I'm going to show you, Ashley, what's previously been marked as Defendant's Exhibit Number 2. And Your Honor, I'd like to, if I could, put that up on the screen. Could we?
Are you from the Elmo?
For the blinds.
Oh, sure. And one more set of lights.
Thank you, Deb. Ashley, take a look at the picture on your concealed firearm license. And in particular, are we able to zoom in on the portrait, the picture? Yeah. Ashley, do your eyelids look the same in that picture?
Yes, sir.
Do they look different in the picture that we admitted after you were slapped?
Yes, sir.
Let's put the, let me see now. Let's put Defendant's Exhibit Number 7 up on the screen. Ashley, what side of your face did he hit you on?
The left side.
The left
The left side.
And as we're looking at this picture, it would be to the right?
Correct.
Is your eyelid on the right side the same as your eyelid on the left side?
No, sir.
And how about your eyebrow? The space between your eyebrow and your eyelid on the right side, is that the same as the space between your eyebrow and your eyelid on the other side?
No, sir.
All right, thank you, Judge. I think we can lift the blinds. Was the firearm registered to you, Ashley?
Yes.
I'd like to now direct your attention back to your initial introduction to Doug. How long was it before Doug expressed his devotion to you?
It was about 4 days after we met that he told me he loved me.
Did any significant event follow after he expressed his love for you?
He flew me to South Carolina, where he was living at the time, and asked me to marry him, and I said yes.
You remember the date?
September 7th, 2016.
How old was he at the time on September 7th, 2016?
54,
And how old were you?
24.
When you finally moved in together, what was it like?
It was challenging. Doug hadn't told his daughter Eva that we had gotten married, and so when she found out, she was really upset. Just understandable. Her mom had suddenly passed 8 or 9 months before, and I was a complete stranger to her. Now I'm moving into her house.
At that point in your relationship, Ashley, describe for us the man you thought you'd married.
He was very loving and attentive. He was always with me. We did everything together. We laughed a lot. And he made me feel very special and loved. He always was looking for ways to be with me and to do things for me.
Was there a short time after that you were separated?
Yes, sir.
And what was the reason?
Before I had met him, I had planned a trip. And so I went on my trip. It was a cruise with my mom and one of my girlfriends.
Were you able to communicate with Doug while you were on the cruise?
Yes, sir.
How?
We mostly messaged each other.
I'm going to pass to you what's been marked as defendant's exhibit number 3, I believe, for identification.
Yes. Oh, wait, I'm sorry. Okay. Oh, the ones that need to be, sorry.
Yes, sir. I'll take a minute and go through those, and I'm going to ask you about them.
Okay. Do you want me to read all of them, or?
Yeah, go
okay.
through all of them. And then I'm going to ask you some questions about them.
Okay.
Are those text messages actually a true and accurate copy of the messages you received from Doug Benefield while you were on the cruise?
Yes.
Your Honor, at this time, I would move defense exhibit number 3 into evidence.
Objection?
Yes.
Yes.
Okay, another approach. What's this? It's just an email. What's the approach about? And also, thank you to everybody that is sharing their experiences in here. I know how hard it is Well, I don't know how hard it is. I can only imagine how hard it is for somebody to share your experiences. So, if you feel comfortable, do so. If you don't, that's absolutely fine as well, But it is an eye-opener for some of us that, never experienced TV before, So, hello, Elizabeth. Very sweet. I'm not sure about how sweet I am. Oh, thank you, darling. Vicky, I don't believe her, and I'm not sorry. You don't have to be sorry. As I say, you're entitled to your opinions. That's what makes us all unique, that we all have differing opinions on it. So it's absolutely, don't need to apologize at all, my darling. Amanda Sterling. Amanda, I did see you earlier on. Hello, my darling. Nice to see you. Hope you're well. Hope you're well there. Donna, you said it right, yeah. All that have experienced DV, you have love and support, yeah, absolutely. I know it can be quite triggering, I can imagine, just, so, yeah, I can imagine that for some of you, this might be triggering, or some people might want to leave, but just know, come back, wherever. I can fully appreciate that. I don't know who the lady is, to be honest with you, Young. I don't live in a DV shelter, spent months living with other victims. I don't believe her. There you go, proof inappropriate, again. From different experiences, isn't it, This is what makes you unique. This is what a jury's going to have to decide, isn't it? So, if we were the jury right now, 70% say not guilty, 30% say guilty. So, I'm stuck in the middle with you. I need more. Give me more, Denise. Feed me. Feed me more. I don't know, Young. She'll be there all week. Maybe a family member. No clue. But I know. It breaks your heart, yeah. Must be so hard for the Jews. Yes, I imagine there's only 6 of them as well. So, which is a little bit more intimate, Six of them. I'm not sure. 5 women, 1 man, which is surprising because, like, as a man, I've been being honest. I tend to believe her, if I'm being honest with you. Where lots of you maybe don't. So,
Move to introduce defense exhibit number 3.
Any additional objections?
Oh, I'm sorry, not other than what we discussed.
Okay. Admitted, subject to what we discussed at the bench.
Ashley, in this exhibit number 3, who's represented in blue and who's represented in green?
I take a look again. I'm blue and Doug is green.
You're blue and Doug is green.
Yes, sir.
Okay. So I want to ask you what you thought and how you felt after this series of text messages where he said the following to you. And I'll go through them and you can respond.
Okay.
Like always being armed. And understanding them and how to conduct warfare in them for the kingdom. If I dwelt on it, I would go into a rage to remove them from the earth. I desire to exterminate them, and holding back is a challenge. They are rats that should be removed. last night, just the jerks arguing near you about put me in sheer murderous mood, but I was stuck. I couldn't defend you. But could have been a fight, etc. Only you being with me will over time remove the images in my head. It is same, and knowing you were taken advantage of still in my mind makes me explode with anger to take them out. God made you for me. You haven't seen the warrior side and never want to. We went from joy and passion to now I'm in a testosterone rage inside. But kill the bad people. How long had you been married when you received these texts from Doug?
I believe it was about a month or so. Probably thereabouts.
Do you recall approximately how long you had been married?
Well, we got married in the beginning of September, and this would have been the end of November.
Okay.
So more than that, I'm sorry.
What did you think? Was there anything about those texts that caused you to pause?
You know, at the time, I kind of tried to write it off that he was my new husband and he was just trying to be kind of manly and, you know, be protective and, you know, was trying to show that he really loved me. I think that was kind of what I
Did you think it was flattering?
Yeah.
Ashley, how long did this facade that you've described of Doug's last?
Probably about 3 months.
And what signs did you begin to see that he was not who you thought he was?
When I got back from the cruise, he started becoming very controlling and possessive. He started criticizing everything about me, like the way I would wear my hair or did my makeup or the way I dressed. I found myself trying to change everything about me to make him happy.
If you had to pinpoint a specific incident, Ashley, early on that stands out to you, what would that be?
A friend of his had come to town to visit, and we went out to dinner with him. And when we went to leave, Doug had had a little too much to drink, and so I said that I would drive home. And he instantly got really mad at me. He was offended. He started screaming at me, and it continued all the way home. And when we got inside, I told him that he was drunk and he just needed to go to bed. And that really set him off. And he tried to flip over the dining room table. He threw a chair at me. He kept screaming at me until he stopped, and then he apologized. And he said it would never happen again. He said he's really sorry.
And Ashley, did it happen again?
Yes.
Explain what happened.
We had gone to church one Sunday, and after service, after everyone was leaving, we talked to the pastor in the lobby area in front. And at one point, Doug stormed off, and by the time I caught up with him, it was in the parking lot, and he started cussing at me, calling me names. And when we got in the truck, he accused me of having a thing for the pastor, and he said I was a slut and a whore. And he screamed at me all the way home.
Ashley, was he aggressive and threatening like that in other instances?
It started happening more and more with me, with our animals. He would hurt our pets.
On approximately how many occasions was he cruel to your pets?
A handful.
How would Doug react following a dark episode?
Well, he was either really up or really down. And after, he'd be very sweet and apologetic. And he'd be kind. And things would be good. And it was kind of like a flip of a switch. And something would set him off again.
Did you find anything one day, Ashley, that gave you insight into Doug's marriage to his previous wife, Renee?
Yes, sir.
Tell us what it was.
I had been going through and kind of cleaning and organizing. And I was going through a bunch of old devices like phones and iPads. And I found a texting conversation between Doug and Renee, his previous wife.
Let me pass to you, Ashley, what we've marked as defendant's exhibit number 11. Can you identify that, Ashley?
This is part of the texting conversation. This is a text from Renee Benefield to Doug.
Is that a true and accurate copy of what you came across that day that you just related to us?
Yes, sir.
At this point, I'd like to move that into evidence as defense exhibit number 11.
No objection.
Received.
I'm going to read this to you. Let me know if it's accurate.
Okay.
I was deeply disappointed that you distorted the truth about who you really were when I married you. I loved you, though finding out you weren't really what you pretended to be. You kicking me so hard on New Year's Eve on our honeymoon because you were having trouble functioning in certain areas. You holding a gun to your head twice in my home that I opened to you with my children that still love you. Having to sell everything down to my wedding ring. Finding out you were on Viagra, which all of you had to do was tell me, you know I wouldn't care. Trying to film us making love on our honeymoon. Finding out that you wore eye pencil on and on. I loved you so much I didn't care. That's why I was shocked to think you would take pictures of me without asking. Is that accurate?
Yes.
Tell us, Ashley, how Doug would act when he would go off.
He would call it a fit of rage. Sometimes it was as simple as him just yelling and screaming at me or cussing at me, calling me names. Other times he would throw things or break things or smash things. He would come at me like he was going to hit me. He told me I was lucky that he punched walls instead of me.
Are there any incidences in particular, Ashley, that stand out to you?
Yes.
Tell us, please.
We were having an argument, and he came at me like he was going to hit me. And our dog, Sully, jumped up in between us, and he punched him in the face so hard that he knocked him out. I just remember screaming because I thought he had killed him.
Were there other times that Doug hurt the animals?
Yes, he had kicked, punched Sully. He threw our cat multiple times. One time he threw Snuffy down the stairs.
What kind of impact did this behavior have on you?
I was always walking on eggshells, trying to do the right things. Because if I said the wrong thing, he would get mad at me. And so I always tried to do it right. If I wore the wrong thing, he would call me a whore or a slut. I feel like I couldn't do anything right.
Was there an incident, Ashley, in June of 2017 that you vividly recall?
Yes.
Please explain it.
We were having an argument, and it started getting really out of hand. He pulled a gun out, and he was like waving it around, and then he threw it at me, and it hit the wall behind me, punched a hole in the wall. So I went to run to try to leave. He pulled the gun out and held it to his head. He said that he's gonna blow his fucking brains out, and I was gonna have to watch him. And he pulled the trigger and he shot a hole in the ceiling in the kitchen.
Ashley, at that point, what were you thinking about your marriage?
He wasn't anything like I thought he was. I feel like I had made a really big mistake marrying him. It was like I was just living in this nightmare. I never knew what I was going to get.
Did there come a time in July or August of 2017 when you found yourself with child?
Yes.
So let's be clear here chronologically. You became pregnant after this incident where you related that he shot the gun in the ceiling of the kitchen?
Yes, it would have been like right after that, I guess.
Was it planned?
No, it's the last thing on my mind at that point.
How would you deal with Doug?
I tried to do all the right things and keep him happy. Kind of just go with the flow. I didn't want to rock the boat ever.
Did you have a difficult pregnancy?
Yes, I was really sick.
Did you go home from South Carolina to stay with your mom here in Bradenton at the end of August 2017?
Yes, sir.
Did there come a time when you returned to South Carolina?
Yes.
Would you tell the ladies and gentlemen of the jury, Ashley, why you returned to South Carolina?
I had decided that I was going to leave him. And so I went back to get my things. When he brought me down, I didn't even have like a suitcase or anything. So I went back to get my stuff. And I wrote him a note and left him a letter saying why I was leaving.
I'm gonna have an objection.
Can you approach?
Sorry to hear that, hippie chick. He did knock out the dog, allegedly, punched the dog, allegedly. Yeah, sorry to hear that, hippie chick. I mean, if you hit anything hard enough, punch it hard enough on the nose, you could knock them out. Like, I know somebody that's knocked out a cow with one punch. So, hey, Bev, cry now. Nice to see you, Bev. Not planned, sorry, but she's slow. Heat animals too gross. Allegedly, you know, so yeah. Obviously, just remember this is a direct. We've still got cross to come. So I did see the prosecutors smile a little bit, like, you know, nodding to each other. I don't know why they're smiling to each other. Lulu Hertz. Lulu Hertz says, good afternoon, Dylan. Good afternoon to you, my darling. Cannot stay as it sickens me to very closely abuse women, tortures,
I'd
and
like to
see.
make a statement for the
That's
record.
fine.
I'd like to make a statement.
I wish you well. I'm sorry to hear that, Lulu. Come back. Come back. Hopefully you come back, Lulu. I do get it. It's triggering for people. I get it. So, you know, if you need to leave, that's absolutely fine. But hopefully you come back, Lulu's here. It's nice to see you. Nice to see you, my darling. Hello, Lou. Our second Lulu Barber and Lou Hillier. I'm very well. How are you, my darling? Please make sure you go and like the stream, please. We got over 100 people here, 107 people here, 93 likes. So if you can just like it, I would be very grateful. 94 likes now. Thank you very much, whoever that was. Okay. No, but in all seriousness, this is obviously can be very Stormcat. You're always late doing it. Why? I don't know. Erin Hack said something about Donald Trump or something. Hey, grilled cheese and mayo. You all keep changing your names, so I'm not 100% sure who everybody is anymore. I don't know who everybody is anymore. You've changed it to something. That wasn't used to be your name. What was used to be your name? Oh. There you go. I knew Hacks would know. They met at a Trump fundraiser. Greg! See, this is what I mean. I knew I'd recognize the photo, but I didn't recognize the name. Greg, how you doing, fella? You changed it, you see. I don't know people with a new name. Sorry, Lulu.
All right, Ashley. Can you identify what we marked for identification of defendants exhibit number?
Sustained.
Well, she can't even identify it.
No, sir. I made my ruling.
You told us you left him a letter?
Yes.
All right. I'm going to ask you a series of questions. Let me pass this to you. You can.
Judge, I'm gonna object.
Sustained.
Do you remember independently everything that you said in the letter?
Not everything, no.
Would it help refresh your recollection if you were able to see the letter?
Yes.
Judge, objection.
Sustained.
At the time that you wrote the letter, Ashley, were the contents fresh in your mind?
At the time, yes.
The letter was written in September 2017.
Yes, that's correct.
It's now 2024,
Yes, sir.
so 7 years ago.
Yes.
All right. Do your best
Okay.
to try to respond to a series of questions I'm going to ask you.
Okay.
What did you tell Doug?
Objection, yes, sir.
Sustained. Sir, can we approach, please?
I mean, I think it's a little bit unfair for her to recount a letter from 7 years ago. Since this morning, she's been on the stand, Lou. She went on the stand at about 9:30. No, sorry, she went on the stand about 10 o'clock Eastern. She's been on the stand for 22, 40, 23. She's been on the stand for about an hour, Lou. I don't know who the lady is. I don't know who that lady is. She's on the well, I believe she's on the Doug family side. I just like it's a letter she wrote. So from 7 years, look at her. Her emotion, her face and stuff. Whoa. It's only recently the objections have been coming in. There's only been like 2, maybe 3. But to be fair, there's been a break in between. So in total, she's been on there for about an hour and a half or something. But of testimony for an hour.
How did you feel about your personal safety when you left Doug?
I was scared.
What was it that made you uncomfortable?
It was a lot of things. It was the things that he'd done, like punching our dog and shooting the gun and different things he would say and do.
And were you afraid for just you?
I was pregnant at the time. I was scared for the baby.
Were there instances, Ashley, where you felt that your own safety had been placed in danger as a result of conduct by him?
Yes.
Can you give us some examples?
I guess one thing that comes to mind is sometimes he would drive really scary, yelling and screaming at me and like running up on curbs. One time he almost hit a tree.
Did you strike that? Describe the kind of things that would be done to intimidate you.
He would get in my face. He'd yell at me. He'd come at me like he was going to hit me.
What about breaking things?
He would break things, smash things, threw things at me.
how would you describe, if you were using adjectives, his behavior?
Possessive, controlling, manipulative, aggressive, scary, unpredictable.
Ashley, did you take any steps in addition to leaving this letter to protect yourself in South Carolina?
Yes.
What did you do?
I filed for a domestic violence injunction, like a protective order.
Ashley, I'd like to pass to you what we've marked as Defendants Exhibit 13A and 13B and ask you if you can identify them.
Okay. Um, 13A is the
Approaching again. I mean, bloody hell. Well, they're trying to keep out this time. The prosecution have been trying to keep a lot of stuff out, I think. I don't know. I'm just waiting for the cross I am now. I'm like, not sure how long more he's got. Boo, 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 boo. Yeah, I don't know why they get nervous though. It's just like they know all about all this stuff. If they generally believe in their case, they shouldn't be nervous at all. This is what gets me with the state when they get nervous. They want to hide stuff. It's like, well, just let everything in. If your case is that strong, which this is not very strong, then you shouldn't be nervous at all. Right. Right, so I'm just looking here now. Oi, we got 105 likes. Thank you, everybody. That's fine, Mary. That's fine.
Ashley, what was the date? Did the court grant the injunction?
Yes, sir.
Was there a hearing?
Yes, sir.
Were you present at the hearing?
Yes.
Was Doug present at the hearing?
Yes.
Did the judge rule at the hearing?
From the bench, yes.
All right. What was the date of the hearing?
November 3rd, 2017.
I'm sorry?
November 3rd,
2017?
Yes.
Okay. Now, was that order that the judge decreed violated?
Yes.
By who?
By Doug.
How?
He sent me a package
in the mail.
Sent you the package here in Florida? From
Yes.
South Carolina?
Yes.
What was the package represented to be?
A birthday gift, I believe.
And did you open it?
Yes.
What happened?
Well, when I opened it, there was an overwhelming smell, like a real strong chemical smell, and I got like an instant headache.
Did you report it to the police?
Yes.
Hi, Heather. How are you, my darling?
Ashley, I'm going to pass you what we've marked as defendant's exhibit number 14 and ask you if you can identify it.
Okay. What do I do with these? Okay. Yes.
What is it?
It's a picture of the package he sent to me.
Is it a true and accurate picture of the package that you received on that day in November?
The outside of it, yes.
All right, Your Honor, on behalf of Ms. Benefield, we move that into evidence.
No objection.
Received. Defendant's Exhibit 14.
What did you do with the package after you opened it?
I sealed it back up and I put it in the garage before I brought it to the sheriff's department.
Now, you told us when you received the package, aside from the contents giving you a headache, that it was in violation of the South Carolina restraining order.
Yes.
Did you, when you contacted the police, request that they take some action?
Yes.
What was the result?
No charges.
Okay.
Objection again. I think this does make the prosecution look bad, though, with all the objections, because if I'm a juror, I'm like, what the fuck? Why are you hiding? What have you got to hide, people? Just my opinion. But I do think if you over-object, sometimes it can be a bad thing. Yeah, I know, Joe, as well. If the defense is now going to bring in the heavy metal stuff, that's nuts, because we'll make her look cray-cray. So, yeah, that's interesting. I don't remember this heavy metal stuff. So, yeah, I'm intrigued to see what happens. I'd think the pros are being shady. I do, yeah, that's how I'd be thinking. Because especially if you're a lay witness, as in, a lay juror, and you don't watch true crime stuff or you don't watch trials, your first instinct is going to be like, but why? Why can't we just see everything? What's the issue here? Yeah, like you said, if the case is strong, it should stand on its own. Yeah, if it's good enough to bring to court and bring to trial, it should. She's all cried out, but still very emotional. Was the heavy metals proven by blood work? I don't remember that bit. Joe might remember. Mary says, I don't be Mary, quite contrary, says, I do not believe her at all. All calculated, no tears. Take a break for sympathy. She wanted him dead. Got what she wished for. Too convenient. There you go. There you go. That's one scenario. Yeah, and that's fair. You know, if that's what you believe, Mary, that's fair. Fair. Joe, she claimed Doug was poisoning her and the baby with heavy metals. Okay. Hi, Donna.
Were you subsequently notified, Ashley, by the state attorney's office here in Manatee County that no charges were to be filed?
Yes.
Do you remember the date that you were notified?
Not off the top of my head.
Let me show this to you and see if it refreshes your recollection.
Okay. At the top, it says October 8th, 2018.
Ashley, when did you give birth to Emerson?
March 19th, 2018.
Where was Doug when you gave birth?
He wasn't there. It was during the restraining order from South Carolina.
So he wouldn't have been allowed to have contact with you.
Correct.
You remember how long the South Carolina restraining order was to last?
I believe it was 6 months.
Does there come a time when you're concerned about the South Carolina restraining order expiring?
Yes.
So at or about the time of that, what steps, if any, did you take to protect yourself?
I filed for a domestic violence injunction here in Florida.
What was the result?
It was denied.
And was there any directive entered with respect to Emerson?
There was a time sharing agreement set up.
Shortly after that, or at or about the same time, was there additional litigation that you filed?
Yes.
Do you recall what it was for?
Divorce and termination of parental rights.
In the termination of parental rights petition, Ashley, did you tell the court?
Go ahead and finish the question.
Did you advise the court in your petition about prior domestic acts of violence by Doug?
Yes.
I'm sorry. Overruled. You may answer.
I'm sorry.
You're okay. Go ahead.
Okay. Yes.
Do you remember, or can you tell us today what you told the court?
I mean, not all off the top of my head.
You can answer.
I wouldn't be able to tell it all to you off the top of my head from memory now.
Okay, let's see if I can refresh your recollection.
Would you like me to read the whole thing, sir?
I'm sorry?
Do you want me to read the whole thing?
No.
Okay.
I would just like to ask you, has your recollection been refreshed?
I'm just getting to that part now.
Okay, then without referring to what's in front of you, tell us.
Can I finish reading this section?
Remove the document
Yeah,
from.
you need to remove the document if the memory's been refreshed.
I just said I didn't finish reading that part.
So he needs to finish reading.
I'm sorry, take your time, finish reading.
Okay.
Sorry to hear that, Linda. Yeah, I know. I can imagine. Well, you're in a safe place here, my darling. Hope you're okay, Linda. Mama aims at Erin Hacks in like 250 streams at the minute, so she may respond later on. There you go, Shari. There you go. Thank you, Shari.
I don't expect you to remember all the details. I'm going to ask you for the high points.
Okay, sorry, there's just a lot in here. Okay.
So tell the ladies and gentlemen of the jury, Ashley, the things that you had to say.
I talked about him punching Sully and kicking him, throwing our cat Snuffy, about him trapping me, grabbing me, yanking me, tripping me, shooting the gun in the house, punching holes in the walls. He trapped me in the closet, smash things like that.
All right. As part of the domestic violence injunction that you filed here in Florida, that was before Judge Moreland, was a deposition taken of Doug.
Yes.
Were you present?
Yes, by phone.
Who else was present at the deposition?
My attorney, as well as Stephanie Murphy, Doug's attorney, and a court reporter.
Was the judge present at the deposition?
No.
Were you able to hear the entire proceeding?
Yes, sir.
Did Doug make
Objection,
Approach.
I don't know Tuddy Pip. I don't think we've heard of any Tuddy Pip in here as testimony. Only what we're hearing now, I believe. I can't remember, if I'm being honest with you. Hello, Fuzz. I don't know how to say that. Fuzzy Lou. Fuzzy Lou? Fuzzy Lou. Why would there be tears 4 years after the fact? No excuse to find out guilty. No, I don't disagree with you. Do not disagree. Cat named Monkey Greg. Oh, jeepers. I like cooking as well, people. Yeah, it's a clean up afterwards. That's the pain, isn't it? Da, 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 da. Yeah, totally. Off the top of my head, I don't remember. So it can't have been mentioned because I don't remember it. Do you know what I mean? As testimony. And I'm only going by what is coming into court. I'm not speculating by anything that has not been submitted. So I don't think it's been touched upon then. Well, it wouldn't be touched upon, to be fair, because it's only now the defense are starting their case. So we'll probably hear if he did. Bam, ba, bam, bam, bam. Sassy, I knows nothing about that. What, cooking? You don't like cooking? Jeepers, Heather. Love inventing new meals. Yes, nice. I think it is good. Oh, that's good. You got them all well trained, Carol. Lamb. Oh, there you go. Heather, potty mouth. He's been going for dinner 11:30 Eastern every day so far, so hopefully he stretches it a bit. I don't fancy having dinner again. It's too early for me because 11:30 is like, 4:30 here. Just way too early. But don't worry, ladies, I got Peter Tragos for you again. I got Peter Tragos ready for you. Opening statements of defense stated Doug had previous TV with his first wife. Yes, however, I'm not counting it because it's no evidence. That's the only reason. I don't think there's any evidence of it being done yet. So, but you are right, Crafty Guy, spot on as always. Just there's no evidence of it yet. So, but it will come in if it is true. So, I know with this attorney, I don't know what's true, what's not half the time. Lamb is one of my favorites. Where's Dana when he got Lamb? Here he is. Would love it, yes. I'm not a fan of sushi. I'm not a fan of sushi, if I'm being honest. They can explain to you, yeah. It's popular in America. I need to try it. There's a Champions pub in Peabody where they do steak tips. Ba-da-ba, ba-da-ba, ba-da-ba. No, but yeah, we're both correct. It's just I just mentioned the evidence bit, that's all. But you are correct. Ooh, ba-da-ba, ba-da-ba. Oh, was that the ex-wife then? I didn't realize that was the ex-wife. I did not realize that, Steph. Oh, I must have missed that. Then. I remember the text, but I didn't think it was the ex-wife. But oops, my bad then. Calm your tits, Vicky.
Ashley,
Can we approach based on this as well?
okay?
Fucking hell. Blood. Cheese and rice, everyone. Cheese and rice. Approach it again. Yeah, Vicky, you're going to need a shower after Tragos comes on again, like yesterday. Cool you down. Or get you all messed up. Hello, Meki Techie. Mexi Texi. Mexi Texi, she's so sexy. Do, 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 do. Hello, Mexi. Good day, people. Happy Olympics. Happy Olympics Day, everyone. So what happened was judge must have sustained whatever he wanted to put in. Then he went to put another exhibit in, showed it to the prosecutors, and they went, "Nope, we need to approach again, Judge." It's like, okay, cheese and rice. Carol, cheese and rice. Sarah, hello, my darling. Is this DA pulling a lally? I don't know. I don't know. No, I agree with you, Marais, but the trouble is, we just don't know what the jury think half the time, do we? Hello, Casey. How you doing, my darling? The first wife died, so yeah, no. It was the attorney I think you're thinking of. Oh, here we go. Oh, I thought that was him. So anyway, hello, Casey. Do you like spicy food? No. I do not like spicy. Spicy, me and me do not go well. She's deceased. Yeah. I don't think we can still state stalling as defenses continually tried to put. I'm not even saying they're stalling, Joe. I think it just looks to the jury like they're stalling. I think it looks bad on the jury, to the jury. So for me personally, I can understand because this attorney can be a little bit shady, but I think for the jury, it might be like, what the fuck? Donna, you're spicy enough to that. Thank you, Donna, my darling. Thank you. Who's that for? Toots. I like both. Yeah, that's what. Yeah, you explained it, Mama Ames. Beep, 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 beep. Come on, Eileen. What's going on? Aaron, you've missed a lot in chat today. Mama Ames was talking to you, and you just totally ignored Mama Ames, Aaron. Shame on you, Aaron Hack. Work ahead of Mama Ames in the chat. Unbelievable. We're on sidebar. We've been on sidebar for probably a quarter of an hour now. 2 sidebars. We had one sidebar. They were about to commence, and then the prosecutors went, we need another sidebar. So we didn't get anywhere. You got to make your own Caesar dressing with anchovies. Oh, anchovies. No, sassy. Make me hungry for lunch, and I haven't even had breakfast. I know, I'm hungry now as well. And it's like 4:15 in the afternoon. And now I'm like, nam. Sidebar. It was star. They should have gone through all of this and approved it outside the jury present. The problem is, yeah, it's the defense, I think it is more than anything. So, steak tips, steak fries. Show the picture again, Dylan. Steak tips, steak fries. What picture's that, Toots? I'm not sure what picture that is, Toots. Oh, no. Bond, no. Anchovies belong on pizza. 100% don't. They're disgusting. Pineapple does not. Pineapple, 100%. It has a place on pizza. 100%. I love pineapples. 11:15. Finally caught up and watching. Ah, there you go. Anchovies, same here. I want food. Baby wants food. It's 4:15. Oh, what did I say then? Yeah, sorry, it's 4:15. Yes. Oh, I thought it said 4:15. Sorry, yes, 4:15. Anchovies and tuna juice. No, disgusting. I'm on vacation, moving slowly, just sipping. Oh, there you go. Happy vacation. How long have we got left? You all, yeah, I know. Making me hungry. I know. Love anchovies with olives. No, I don't like olives. Stop it. You can marinate it overnight. The trouble is, whenever Heather Taylor's in a conversation, she's answering questions from like 20 minutes ago. So I've no idea what she's on about. James, no way, bruh. Nice one, Mike. You know the score. There you go. They are fair, and I will represent the cows. There you go. Taco soup last night. What the taco soup? I have to be creative because haven't had stovetop since May. Oh no, Carol. You need to go on another cruise, quick. Yeah, I'm same as you, Mike. Same as you. I love fish, but not the slimy, slippery little ones. Sardines. 100% on pizza. 100%. Absolutely. Oh, they did. Yes, you're right. Chrissy. It was Chrissy. Just Chrissy was. Yes. There's steak tips. I won't do it right now, this second, because obviously we're in the middle of this. If I remember, I'll try and put her up in a second. Well, I love you, Delana. Just belly laugh. Thank you, Heather. They need to hurry up because I need to go shopping. Dang nabbit. Well, they will be going for lunch. Well, they might go for lunch now. I mean, they always go early. It's a staycation, sitting by the pool and sipping cocktails. Nice. Don't yawn, Delana. You made me yawn too. Sorry, I'm sorry. James, no way. If you go to Hawaii, you'll get pineapple and pizza. I'm with DA. Oh, I'm with the man, Dylan. Happy days, James. Poll. I don't know how to do a poll. Okay, no, I'll do it this way then. So not guilty, 70% on this. Fine. Right. There you go. Poll. Which one would you choose? Anchovies or pizza or pineapple? I know some people say neither, but I just left it as that. Which one would you prefer? No, Palmer, not yet. Just Iron. It'll come in, I imagine. Oh no, you like both. Well, you got to choose your favorite one. Do I want to miss Peter? Munchie. Yeah. Pick the lesser two evils. Now see why she's on the stand. She's the only one that can testify to all of this proof of abuse. Yes. So what I think happened as well is, I think the prosecution were planning that she would testify, but not this early. I think they thought that they'd keep her till the last witness or near the end. So I think they probably thought they had all weekend to plan. But can of Coke, not a bottle. Ooh. Found harmless. Nice one, Heather. Yes, I agree, Amy.
Ashley, I'm going to pass to you what's been marked as defense exhibit number 17.
Okay.
And ask you if you can identify it. Ashley, do you recognize that?
Yes, sir.
Tell us what it is.
They're text messages between me and Doug.
And do they truly and accurately reflect texting back and forth between you and Doug?
Yes.
On behalf of the defense, Your Honor, we move into evidence defense exhibit number 17.
Objection overruled. Defendant's Exhibit 17 will be received.
Ashley, in defense exhibit number 17, the text messages, does Doug admit to shooting the gun in the house?
Yes.
Does he admit to throwing the gun at you?
Yes.
Does he admit to punching holes in the drywall of the house?
Yes.
Does he admit to punching the dog and rendering them unconscious?
Yes.
Objection, no, he does not. Those text messages do not say that.
If I'm going to sustain, if you want to publish the exact exhibit that's been admitted, you can do so.
We intend to publish upon completion of the examination. I want to ask you, Ashley, if I can, about other instances of abusive conduct. Was a tracker at any time placed on your car?
Yes.
Was it done with your permission?
No.
Did Doug no, hold on. While the state is reviewing that, Ashley, I'm going to pass to you defendants exhibits 19 and 20. Tell us, if you would, what they depict.
Holes in the drywall of the house, our house in South Carolina.
Refer to them specifically. Exhibit number
19 has a picture of a hole in the drywall with my hand next to it. It's kind of been like pushed back in.
Is it a true and accurate production of what existed at that time?
Yes.
All right, and the next one?
20 has a picture of a hole, like a fist hole through the drywall in our home.
Okay, is it a true and accurate photograph of that?
Yes.
On behalf of the defense, Your Honor, we move them into evidence. State, any objection to defense 19 and 20?
No.
Received.
Fucking hell. So he handed them the next exhibit and now they're approaching again. Fuck's sakes, like. It's interesting because yesterday the defense did a speaking objection and the prosecution went nuts, but the prosecution just did a speaking objection themselves, which I thought was quite funny, the fact that she thinks it's okay for her to do it, but whatever. Okay. Yeah, we're going to see these. Well, I mean, they're supposed to be published because obviously the one way or the other, we're going to see what these things say because the prosecution say that is not what these exhibits to put.
Ashley, did Doug admit to placing an illegal tracker on your vehicle?
Yes, in a message to me.
Did you report that to the police?
Yes,
What was the result?
no charges.
Were there incidents, Ashley, where Doug would appear unexpectedly?
Yes, a lot.
And how would that come about? Can you give us an example?
I'd be driving down the road and I'd see him in the rearview mirror, a couple cars behind me, or he'd be right behind me. Or sometimes he would show up at places that I was, just unexpected. I'd see him, or like in the parking lot.
And was this while you were living here in Manatee?
Yes, I was living here
And where was Doug living at the time?
in South Carolina.
How could he do that?
He was driving here.
Was this also during the time that the South Carolina injunction was in place?
Both then and after as well.
Did you report those incidents to the police?
Yes,
What was the result?
no charges.
Was there an incident with a neighbor, Ashley?
Yes.
What happened? Ashley,
She,
were you present
yes,
for the incident?
yes, he was outside in the yard at night looking in the windows of my house.
What is the neighbor's name?
Marianne Croft?
And was this reported to the police?
Yes.
Did they respond?
Yes, they came out.
Was it daytime or nighttime?
It was nighttime.
In your presence, was an identification made that it was Doug?
Yes.
What was the result?
No charges.
Was there an incident, Ashley, where you and your mother came home to find someone in the driveway of your home?
Yes.
Who was it?
It was Doug.
What did he do when he saw you?
He was on foot in front of the house, and when he saw us, he took off running.
Did you call the police?
Yes, I had to call several times before they sent someone out.
Did they take a report?
They did, but by the time they finally got there, he was long gone.
What was the result?
No charges.
I want to introduce what we've marked as defendants exhibit 23 and 24. You identify that?
Yes.
What does 23 show?
23 is a picture of Doug with his shirt off. He's like taking a selfie.
And is that how Doug looked at or about the time of the shooting on the 27th?
Yes.
All right, and what does the next exhibit show?
It's also a picture of Doug with his shirt off. He's working out. He's like doing like a push-up, I guess.
Does that too accurately represent what Doug looked like on the day of the homicide?
Yes.
Your Honor, on behalf of the defense, we move those two exhibits into evidence.
Any objection? No. Received?
Just one or two more questions, Ashley. Was there a time back around May of 2020 where you wanted to learn about co-parenting with an abuser?
Yes.
Objection. Previously.
Sustained.
To the question, Your Honor, or to the line of inquiry?
To the question.
Okay. Did you take any steps, Ashley, to try to determine how to co-parent?
Yes.
All right, and what was that?
I did some like Googling and reading to try to find helpful articles on what to do to make things
I'm going
good.
to pass to you what we've had marked as Defense Composite Exhibit 4, A, B, C, and D.
Objection, Judge, previous room to be discriminated.
Can you approach?
Did you just say you need to explain that to him? She needs to stop that because that's not appropriate. Hang on. Okay. Hello, Bill. How you doing, Bill? Hope you're well. Tangled Tiara, pineapples. Right. Let's see where the verdict is so far. Bond. No wonder James bowed out. Anchovies got 16%. Pineapple 84%. Sorry, James. The cops did a very bad job again. By the sounds of it, anyway. McGoogling. So I can imagine they probably go for lunch before. Maybe they start cross, but knowing this judge, he likes to take early breaks, so they might take a break and then cross. I do wonder how many more witnesses they'll have after Ashley, though, the defense. How many they're putting in.
Actually, I'm going to pass.
Defendants. Oh, go ahead. It's got to be.
Thank you. We'll pass you defendants exhibit number 4.
No, I already ruled on authenticity in the past. So over the state's objection, admitted.
Thank you. Take a look at exhibit 4A, Ashley. What's the date?
5/11/2020.
And did you do an internet search on 5/11/23?
2020. Yes.
2020, rather?
Yes.
And will you tell us what the subject you researched was?
Domestic co-parenting with an abuser.
All right, and would you go to exhibit 4B? What's the date of 4B?
5/11/2020.
Did you do an internet search then?
Yes.
What was the subject you researched?
Ask Amanda. How do I co-parent with an abuser?
All right, and 4C?
Yes.
What's the date of 4C?
5/11/2020.
And did you do an internet search then as well?
Yes.
What was the subject?
Co-parenting versus parallel parenting with an abusive ex. The Good Men Project.
All right, and lastly, 4D. What's the date of 4D?
5/11/2020.
Did you do an internet search?
Yes.
What was the subject?
6 tips to help you co-parent with an abusive ex.
All right, Your Honor, I think I'm finished if you just give me one moment. Actually, I'm going to pass you what's been previously admitted as defense exhibit number 6.
Okay.
Do you recognize it?
Yes.
What is it?
It's a whole chain of emails that were forwarded to me by my attorney.
And what is the date it was forwarded to you on?
It says Wednesday, September 23rd of 2020.
Did you read it?
Yes. I mean, do you want me to reread it now or?
Did you read it when it was forwarded to you?
Yes.
No further questions, Your Honor.
All right, go ahead. Can the attorneys approach, please?
Probably go for lunch now. They're probably. Hey, Cassie. Hello, my darling. Hello, Amy. Nice to see you back, Amy. Amy, for those that don't know, Amy is a first-time viewer yesterday, and she's from California, and she made it back. So nice to see you, Amy. I think it's mixed feelings here. Fairy, why do people have to act so ugly? Who? What? Who's acting ugly? Take everyone out to the pool. Happy days. Take us out to the pool. Let us know how we're doing. So I think they might go for lunch now. Yeah, Amy, do not, like, just so you know, Amy, this is a celebrity we have in called Dana Leonard. He is our resident celebrity. He is on the show Resisting the Silence.
Miss Benefield, you can step down. You can take your water, you can step down.
Okay, should I?
Just leave everything there.
Okay. Can I throw this out? Okay.
Members of the jury, it's about 11:45, so I'm going to let you go on your lunch break at this point. If I could have you guys back downstairs in that jury assembly room by 1 o'clock. And when I say by 1 o'clock, maybe 5 till, because the goal will be to go ahead and get you on up here and get started right around 1 o'clock this afternoon. Please remember, do not discuss this case amongst yourselves in any way, shape, or form. Don't discuss it with anybody outside of this jury, and do not do any research.
Hi, John.
Watch television, read articles, anything at all about the people, places, things, or legal topics we've heard anything about. All right, leave your notes just right there on your chair, and we'll see you back right at 1 o'clock. All right, you all can have a seat. Ms. Benefield, when we had taken that break earlier, I had instructed you that you're in the middle of your testimony. You still are, because now the state's going to have the opportunity to do its cross-examination. The rule of sequestration applies to you. You may not discuss your testimony, any questions that have been asked with you, anything about the case, including with your own attorneys and defense team. Do you understand?
Yes.
Okay. Otherwise, you guys are free to go, and we'll see you back here. Just maybe a couple of minutes, as I said, state and defense, maybe just a couple of minutes before 1 o'clock with the goal of getting everybody up here and started right at 1.
Okay.
All right. Exhibits. The clerk's checking right now. Parties, stay still until the clerk tells me that she has all of the exhibits that have been entered or proffered. Wait, 4A through D, you had proffered, but then you took them back?
I believe she
Okay.
has.
Those are the same ones?
Yes, sir.
You didn't remark new ones?
No.
All right.
It's 4:45 here, so no. It's too early for lunch, unfortunately. For dinner. Heather, your mouth is a celebrity. Right, so I'll show you a picture of steak tips, Amanda. Hang on. Let me show you steak
I
tips.
need 13A, B. The thing's 13A and B. Oh, you know what? Those weren't admitted.
Right. Not admitted.
Right. No, so they weren't admitted. It was referenced and then that was it. Okay, all right, you guys are all set. Have a good lunch.
Thank you.
Right, so these are steak tips, Amanda, just so you know. Share screen. There you go. Those are steak tips, Amanda, with fries. So steak fries, or chips, as we call them, and steak tips as well. So steak chips or fries, steak tips. See them there as well. With ketchup. So this is Chrissy and her daughter. This is just Chrissy's daughter in a Bruins top. And that's it, yeah. So there you go. Right. Rump tips in the UK. So rump tips. Okay. There's a lot of not guilties around here. Yeah, I agree. So far, not guilty. Right, let me put Tragos on for you, ladies. Vicky is very excited. So we're on lunch break now until 1 o'clock Eastern, 6 o'clock UK time. And that's 10 o'clock Pacific time. So 10 a.m. Pacific time. So let me find Tragos for you beautiful ladies, my darlings, and then we'll right. Now I'm pretty sure the when the judge said spread your legs, no one flinched. But I imagine if this guy says spread your legs, most of you would comply. So there you go, ladies. Right. I will be back probably just before 1 o'clock. And then yeah, I'll be around. Too early for dinner for me. I want dinner about 6, half 6. So yeah. Right, beautiful people. I shall see you. We'd all be doing splits. You're all like, put our legs up in the air. Peter Tragos is here. Split them up. Right, here you go, ladies. There you go.
What's up, everybody? We have day 3 in the books on the Black Swan trial for Ashley Benefield. And what happened outside the presence of the jury seemed to be much more important today and enlightening today and learning experience today for us than what actually happened in front of the jury. It was quick, it was fast, it was furious. The state is already done. They rested, but so much happened in the beginning and the end of the day. Today, I fixed my mic. I heard it sounded weird. It was the camera mic that was on, but now we're back. Now we're ready. Let's get into it. All right, so we had a mic issue, but let me know in the chat if everybody can hear me fine. Saying fix the audio. I think I fixed it. Camera is good. Mic should be on the right one now. Yeah, better. Okay. All right, we fixed the mic. For some reason, it was hooking up to the camera mic that's listening. Okay, so we're good to go now. And like I said, so many things happened outside the presence of the jury today. That's going to be a big part of our focus. And it's important when this stuff happens because it affects the trial and it affects what eventually comes in front of the jury. And what we hear outside the jury doesn't affect their opinion. So we've got to make sure we can keep separate what we hear in front of the jury and outside the jury. And a lot of what we're going to focus on today happened outside the presence of the jury. But it lets you know, it gets you into the mind of what lawyers deal with, what judges deal with, how you make decisions, how you make things work in a trial, how you always have to adapt. You always have to be ready for literally anything. And it started today with 2 major issues. Number one, we hear that a witness that has already testified but is still under subpoena can't talk to anybody about the case, about the trial, about her testimony, about what she saw, what she's heard. And we had a juror issue. Somebody said they saw a juror at a restaurant where there was reporting and things on the news about this case and other people in the restaurant talking about this case. So how do we deal with that? How do we fix it? That's really important always to focus on. And the judge has to come up with the best remedy and how to keep this a fair trial and continue the trial moving forward. So the first thing we find out is it was Eva Benefield, the daughter of the victim, Doug Benefield, not Ashley Benefield's daughter, his daughter from his first marriage. And she was the one who talked to a reporter outside the courtroom about this case. And so the judge says, let's call her to the stand. Let's find out what she said, because right now it's hearsay. We don't really know what's going on. Let's hear what she said, and let's figure out if it's a big deal, if it's a nothing burger, if we can just keep moving on with the case. So here we go.
You appeared yesterday and testified before Judge White in this case, did you not?
I appeared on Tuesday and testified.
Tuesday. Time flies. At the end of your testimony, do you recall Judge White instructing you about having contact with anyone because you were to remain under subpoena? Do you recall that?
I recall.
Okay. And you were here today because...
So it's also important to point out this is the defense attorney questioning her only in front of the judge, not in front of the jury, to try to figure out were any rules violated? Did she do this on purpose? Was she trying to affect the case? Or was it an innocent mistake that didn't affect the case at all and is not going to be a big deal?
The state requested that you remain as a potential rebuttal witness.
Correct.
Now, what did you think Judge White's directions to you meant?
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
So, I'm sorry, did you finish?
I'm finished.
Fine. Did you realize that when you decided to have a conversation with the reporter?
Yes, sir.
All right. Tell us, if you would. I'm just trying to get an explanation. Tell us, if you would, what you were thinking that...
Objection.
Oh,
That's not what she said.
what you were thinking that you felt allowed you to do exactly that which Judge White cautioned you not to.
I was caught off guard in the hallway when I was under extreme emotional distress after being here, hearing different testimonies about my father's murder. And when I spoke to the reporter, I made sure not to talk about any of the testimonies or anything that happened in the courtroom or my testimony.
What did you?
So again, she says she was under severe emotional distress, which is totally understandable. And she was caught off guard by the reporter, which again, a big chunk of this blame goes to the reporter. SoCo Judy said she's on TikTok too. I wonder if the defense knows this. They do know this. They do know this. And we are going to discuss this and what this means and how it changes just the fact that she gave an interview to a reporter.
You discussed with the reporter?
Just how I felt about the situation and who my dad's character was as I saw him.
All right. So, this is Ava Benefield, the daughter of the victim who already testified. And there was allegations that she gave an interview to a reporter while she was still under subpoena. So now she's testifying to talk about what exactly she discussed.
About the situation, you mean about the case, the trial?
Not about the trial.
What situation were you referring to?
My emotional state.
You post on social media?
I do.
TikTok?
Yes.
Any others?
No.
Following your testimony here last Tuesday, did you make any posts?
I did.
Tell us how many?
3.
3. And tell us one at a time.
She made 3 posts on TikTok. Okay. She's just admitted that. That's out there now. So we're going to discuss that a little bit. And the main point of this is not even necessarily to get her in trouble. It's just to say, if she's already kind of talking about the case and doing this stuff afterwards, she shouldn't be able to be recalled as a witness. It doesn't diminish her testimony. It doesn't strike her testimony. She's not going to be sanctioned. She's not going to be thrown in jail. She's not going to be fined. Theoretically, you could argue stuff like that for, violating a court order in this situation. She's a kid. She didn't know. She didn't mean to do anything. But an appropriate sanction may be, just in case you're wondering, what can the defense do here? What are they asking the judge for? What decisions does the judge have to make? Should the judge not allow her to be recalled by the state if they want to? Is that something that the state should lose the opportunity to do based on her actions?
Were all 3 of them on Tuesday afternoon, Tuesday evening?
One was on Tuesday.
And when were the other 2?
Yesterday.
Okay. And tell us, as to the first post, what was it about?
I said that I testified.
Okay, and did you have anything to say about your testifying?
I talked about it being on live television,
What else?
that somebody back home was watching.
I assume you have copies on your phone?
I do.
You have your phone with you here today?
I do not. Not on me.
Where is it?
It's over in the benches.
In the bushes?
In the benches.
In the benches here in the courtroom?
Yes, sir.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
Judge, I'm going to object if he knows where they have it. So
Well, I don't know.
it's an invasion of privacy. They can look up.
Not if it's on social media, but we started off talking about just speaking with some reporter, and now we're talking about a social media post. If you've seen it, and if she's violating the rules, let's just get it out.
Okay, I'm trying to find that out.
So so now it's a fishing expedition.
So it's not a fishing expedition. I disagree with the judge here. If she has admitted it and we know it's true and we know it happened, it's not a fishing expedition. Now, the question is, did she do anything to violate the rules? And the judge is saying, if you don't know or you don't have a good faith basis to say that she did anything to violate the rules, why are we looking at her TikTok? Why are we going to look at her phone? That would be kind of invading her privacy a bit. But it's not great, right? If you go on social media and you talk to reporters, I realize the reporter, again, is who I put most of the blame on. And again, she just said she didn't talk about anything about her testimony or the trial or really violate the rule even in that interview. But it's just not a great combination for somebody that may still be called as a witness, in my opinion. The judge kind of cuts it off at this point and says, if you don't have a reason to believe that she did something to violate the rules, then we're not just going to keep digging on this. And thank you, Chris and Rebecca, for gifting memberships. That's always awesome. And Rebecca said she effed up. I don't care how young she is. She was given a warning. Yeah, but did what she do affect the case at all? Did it affect her testimony or anybody else's testimony? That's the real question. She definitely shouldn't be doing this stuff while she's still under subpoena. If she wasn't under subpoena anymore, it's unwise, but it's not necessarily breaking any major rules. So I understand kind of the judge's predicament. It would have been a pretty easy decision for me to say you can't recall her to testify, but the judge at the end of the day decides to reserve ruling to a future date. He does have a couple questions for her. We'll listen to those and then we'll go ahead and pause it again and explain.
If you know a violation, let's talk about it. If not, let's just get moving. We got jury waiting.
I understand that, Judge. How do I know? Like, she's told us she posted 3 things. How do I know what it's about? What if one of them involved discussions that were inappropriate? How am I to know that? I've been a little preoccupied, and I don't do social media.
Sir, if you have specific evidence, let's talk about it. If not, you have a team. You've got 3 people in court right behind you. I don't know. Maybe they can look it up. But let's focus on what we know about, as opposed to digging into speculation.
I have no further questions.
Ms. Benefield, when you had
this another opportunity, the defense attorney let the judge know he didn't like what he did, and the judge makes comments later like, it won't be the first time you disagree with me or don't like what I do. It's not phasing the judge at all. Jacqueline said that she wanted to know what was on the deleted TikToks. So I guess they're deleted now. I don't know. I didn't look them up. They didn't come out in court. I didn't feel like it was necessary for me to look them up or, try to dig into this anymore if the court's not going to consider it. If the court ends up considering it and it ends up coming out, then maybe we'll discuss it more. But it is interesting and probably the best decision to delete them, right? So it doesn't have any further effect on the case, if anything at all. Michelle asked, Ava's also been in the gallery since her testimony, which I didn't think she could because she was still under subpoena. I am wondering if it's because she's a victim in the case. And victims sometimes have similar rights to parties and are allowed to sit in and listen to testimony. I haven't heard anybody specifically single her out as having different rules. She is still under subpoena. Christy asked the same question. I'm confused why the rule exists if she's allowed to be in court for the other testimony and hears those. How could her actions hurt the trial? So her actions could hurt the trial if she goes out and talks to other witnesses, talks to people about her testimony, discusses what they think she should say on rebuttal. If I get called again, what should I say? How should I affect my testimony with this or that? What do you think other people testifying has to do with my testimony? Is it inconsistent? How can we get our stories straight? Kind of those kinds of questions you can't ask. You can't talk to people about your testimony anymore if you're still under subpoena and have already begun testifying. Jules Abel said, the 6-month in another state plan for custody went out the window when he also decided to move to that state. Seems like desperation could have set in at that point. The prosecutor's theory is falling short for me, though. Well, falling short and already have fallen short at this point because they have rested. So their case in chief is done at the end of our video today. So we'll see kind of where you guys stand at that point.
Conversation with the reporter in the hallway. Were there any other witnesses around?
Yes.
And the judge is kind of not super happy there. There are other witnesses around, but I think she was trying to be super honest and truthful. And she was like, yes, there were other witnesses. I think she means other people heard and saw this interview. That's what I think she meant. I don't think she meant witnesses to the trial, which I think is what the judge was asking.
I'm sorry. Let me re-answer that question. None that testified.
Okay, so you're saying there were people standing around,
There were people
but
around.
none of the witnesses in this case.
No, sir. Not that I remember.
Did you talk specifically about the questions that were asked of you or the testimony you've given?
No, sir.
All right. Do you have any follow-up questions to my questions?
No, sir.
Do you have any follow-up questions to my questions? All right, Ms. Benefield, you can step back out.
So at the end of the day, the judge reserves ruling and says, I'll take it up later if the state even decides to call her. Because if the state's not going to call her, it doesn't matter. We don't need to waste our time with this. But before we moved on, he called her back in before she sits in the courtroom, and he's going to explain to her again how important this is to make sure we keep the trial going the right way.
Right there. Liam, the court has ruled at this point that I'm reserving ruling on whether you're going to be allowed to be recalled as a witness or not in this case. I don't know if that's going to happen or not. I'll make that ruling down the road. But I want to admonish you about the instructions that I've given and the importance of those. They matter and they need to be followed. Do you understand? All right, ma'am, you can retake your seat.
All right. Then that's not it. We have the issue with the juror, and the judge decides to question the jurors individually, one by one. Did you hear about this? Did you know about this? This incident that happened in the restaurant, we knew it was a male juror, but we didn't know which male juror. So as he brings them in, I think there's only 2 male jurors on the jury, including the alternates. So eventually we get to the right juror, and we're going to jump to that part to hear how the jury answers the questions, which I thought was about as good of an answer as you can have when you find yourself in the situation that this juror found himself in.
Hello, sir.
The judge asked this same line of questioning to every single juror as they came in. We're only going to listen to the one that's relevant, the one that says, yes, that was me, and kind of explains what he did.
Can you please remind me of your juror number? It's for Monday. 43. Thank you, sir. The reason I'm bringing all these jurors out individually is because I received a letter this morning from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter essentially says. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So they're calling everybody out individually to say, do you know anything about this? Are you aware of this situation? And also, have you been following the court's admonitions? Have you been influenced? Have you seen anything outside of these 4 walls?
Yes, Your Honor, that was me at the restaurant. I was getting my lunch to go, and I was
Immediately admits it, says he's getting his lunch to go.
keeping everything out of my view and wasn't looking at anything on the news.
He was keeping everything out of his view and not looking at it. Okay, I mean, that's not the best, right? You'd rather not even be on, but how was he supposed to know it was going to be on? He went in to get his lunch to go. He wasn't watching it or anything like that.
The news, and I left immediately because I felt uncomfortable, and I haven't gone back to the restaurant. That's what I did. I ate my lunch in the park right in front of the courthouse.
All right, sir. So when you said you weren't paying attention, was that to the television?
That's correct. I was not in view of the television at all. And I asked the business owner to have my lunch to go so that he was like, leave.
And did you overhear 2 individuals in that restaurant discussing a witness's testimony?
I did not.
So the reporter overheard 2 people talking about it. This juror did not, so that was not even a big deal. He didn't watch the coverage. It didn't affect his testimony or his opinion of the case. He left immediately, and he didn't even see the reporter or notice the people talking about the case. So the reporter, in an abundance of caution, his or her lawyer wrote into the judge, making sure everybody's abreast of what's going on. I think that's really important. I'm glad they did that. All this stuff, kind of this outside influence coming in, can really throw a trial off the rails, right? And I think the judge and everybody involved has been handling it really well so far, dealing with issues, trying to combat them, trying to keep it fair, trying to keep it insulated to what's happening in these 4 walls. But this is such an example of what can happen, especially when a case starts getting some high profile media coverage. It ends up on the TV. People are talking about it at restaurants around the courthouse, and people are TikToking about it. And we've got to make sure we keep this to a fair trial and we protect the rights of the criminal defendant and the state. Sandy said Eva posted that she just testified and said nothing if else about it. Her other 2 posts were about what she was wearing. Okay. Seems innocuous enough. Eva was a teen when DB moved to Florida. Did she also move? I have no idea. I'm not sure because I, like Rebecca, knew nothing about this case till the trial when she started watching with us. However, the state has not proven their case so far. Well, today is the state's last day. They rest today. So if they didn't prove their case today, it's going to be really hard for anybody to get to a guilty verdict, which we'll get there. Leslie said, what is Marcy's Law? Marcy's Law in Florida is the rights of victims. We make sure we protect the rights of victims as if they're a constitutionally protected party. Sometimes that means sitting in a trial. Sometimes that means being at certain hearings, having the opportunity to be heard, the judge or the state attorney having to take their opinion and their feelings into account when making plea offers. So basically, it's protecting the rights of victims. All right. The next thing we're going to talk about, we're finally going to get to a witness. The officer who downloaded Ashley's phone and Doug's phone, basically for like an hour on the stand. Gosh, I don't know what's going on with my clicks today. Sorry. With him on the stand, basically for an hour, they read through Ashley and Doug's texts. Not a lot of comments by the state, not a lot of questions by the state. I was trying to think, like, are they trying to make a big deal out of this? Because if they are, I might be missing it. What I picked up from it, which I think later was kind of confirmed, was everything seemed to be fine leading up to the night in question. Ashley and Doug seemed to be getting along fine. She didn't seem to be in fear for her life. He didn't seem to be aggressive or hurting her. She didn't seem to be manipulating him. He didn't seem to be manipulating her. He didn't seem to be psycho-obsessed. She didn't seem to be trying to make her distance. Now, there's a million explanations to why that could be. They either could be manipulative, hiding things, scared, whatever it may be. But
Was that to the television? That's correct. I was not.
all right, am I back or no? I can't tell. There's some storms here, so I think it froze. All right, I think I'm back. All right, let me know. I'm seeing that I'm glitchy, so I don't know. I don't know if it's worth it to keep going or if it's just too bad. All right. So John said it seems full quality now. So hopefully you guys can hear me and see me. We're going to listen to their last interaction together here.
And I'm clicking on the attachment for the record.
Now appears to be.
Go ahead. I'm sorry.
It appears to be maybe the U-Haul truck that they're loading up.
And that was sent from Doug.
That was 511. Yeah, that was incoming. Yes, from Doug to Ashley.
Okay. And then the next message.
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
Last communication, pretty normal. Nothing crazy going on. Then they take a break to make a legal argument, but eventually they end up putting in a video that the defense wanted to keep out. The state wanted to get in as an interaction that just kind of shows how things were going for them at the time in living color for the jury to watch.
I didn't know what it's doing. I think it's giving you clues that I gotta guess. Get real. Real.
Working mother, not a working mother.
Working mother, not a working mother?
Not a working mother. With an A.
Oh, no, it's running out of time. House. Real house. White. Housewives of.
So once again, I think the important part about that is to show what their relationship was like, how they treated each other, how they were acting right before all this happened. And a lot of the OGs step up and they know how frustrated and annoyed I get at technical difficulties. So thank you, Rebecca, for letting me know it's all good and it's back rocking. And then, of course, Netwoman drops the bag of memberships, spreading the love. 50 new memberships will join the Lawyer You Know crew. Thank you so much, Netwoman, for doing this. And take a deep breath and we just keep moving on. We just keep rocking and we keep breaking it down. All right. So on cross, he basically just asks this witness, can you talk about the motivations behind the texts? Do you know if he actually believed the Bible verses he was putting out there? Was he really as good of a man as he seemed like? You know, people can sometimes trick people in their text messages. That could have been what's happening here. They wanted to get into Ashley's searches and wanted to get into some of their texts, and the judge didn't allow them to. In my opinion, I don't necessarily agree with the judge's ruling. I do kind of think the door was open. This witness could have testified to it, and this witness could have authenticated them. But he basically said he's not going to allow the defense to get into it during the state's case in chief, which I kind of am fine with that, except that other stuff has already come in. But I hope that the defense is able to get into this during their case chief, because it seems very relevant to me and it seems like it should come in, and I don't see any reason for it not to. Edward asked, will she take the stand? I don't know. She hasn't taken the stand. She hasn't testified yet, but the defense's opening statement led me to believe that. I don't know how they get that evidence in without her taking the stand. Sometimes defense attorneys do that. They say stuff even though it never comes into evidence, but if I'm the state, I'm moving to strike that and not allowing them to make those arguments in closing argument and having the judge to instruct them that the defense attorney made comments in the opening statement that didn't come in at trial. I would do that as prosecutor. Some judges will allow it, some won't. Wait, did the juror get to say stay on or not? The juror stayed on, Bethany. The juror stayed on. Kelly said, I learned about this case from Eva's TikTok over a year ago. Her TikToks were no big deal. They were like outfit checks. Her girlfriends are there with her. Her girlfriend is there with her. Okay. I don't know the rules of evidence, obviously, but it seems that the judge ruled against the defense unfairly when they wanted to bring in evidence that seemed legit and important. Your thoughts? So it seems like the judge is basically saying you can bring it in during your case in chief, not during the state's case in chief, which there are some rules that allow the judge to do things like that. So I understand it, but I think it became appropriate and relevant at that point. I would have let it in if I was the judge. Rebecca, thank you so much. 20 more memberships. Tons of new members coming through today's video. If you're a new member today, let me know in the chat. Then we get to the medical examiner, who goes through his background, his training, his information. They go through the graphic photos. They go through the entry and exit wounds and, confirms what the state said, that it wasn't kind of a straight on shot. He wasn't standing right in front of her, and the way there was no stippling. It wasn't just 2 or 3 feet away. It had to be more than 3 feet, which again, could he have really been that aggressive or scaring her or coming at her if he was more than 3 feet away? The defense came up on cross and was like, well, she could have been moving back. 3 feet's not really that far. So I felt like the ME kind of did his job, but it wasn't, a home run for either side. And then the last witness was Hosworth, who basically just explained how a firearm works, how there was no stippling, no GSR, gunshot residue, so it wasn't that close. The defense got up and crossed and was basically like, so basically you're saying the bullet was fired from that gun, no stippling, no GSR. And he's like, yeah, I guess. Same thing with the other officer who read the text messages. He's basically like, you just got called to read text messages. And that's also why the defense wanted to respond with some text, because they were trying to make it seem like everything was great. The defense wanted to bring in the threatening texts that were a little bit older. The judge said no, but he's like, this is why her mindset was the way it was, which is spot on for a battered spouse syndrome. Judge didn't allow it in now. I think he is going to allow it in later. Kelly D. Wasn't Ava calling Ashley a liar and things like that in an interview? Is that an issue with her testimony? I didn't see it, so it's hard for me to comment on that. I'm not positive. If somebody wants to send me the interview, I'll take a look at it. Charicity, you asked yesterday for those who say she's manipulating how, and never saw in the chat. Can we discuss where the proof is? I'm just curious what I'm missing, honestly. my opinion, just my opinion only, and I, again, would love to hear what people in the chat think she is manipulative, is just basically the state saying the words she's saying are not the words she means. She's saying one thing, acting differently in front of him and not in front of him, behind his back, and that's manipulative. The defense is arguing that's fear. The state's arguing that's manipulative. I don't think they've had a single person come in and say she's manipulative. And I know she was manipulating him. Everybody said they seemingly had a good relationship, which maybe she's faking it and that's part of the manipulation, but manipulating him for what? Because she wasn't trying to get him to go away, right? I mean, she could have manipulated him worse, said she was going to Maryland and actually moved somewhere else, or like lying to him that way. I've heard a lot about this, like, fake poisoning allegations, but they didn't really dig into it. I think maybe if they were going to try to prove she was a liar and a manipulator and a master manipulator and trying to screw him over, proving that stuff was a lie and that she knew she was lying and all this stuff maybe would have proved more manipulator. I don't feel like they dug into it enough for me to be like, oh yeah, she's definitely doing this. I'm a DV survivor, law school in my 40s, support women. I don't believe her. I pray she takes the stand. Okay? Shouldn't interpret LOL and smiles as getting along. DV victims go along to survive. The judge keeps asking the prosecutor to slow down her speech. Has that ever happened to you? LOL, like the man bun. So it has happened to me. Yes, it has happened to me. What's never happened to me is speak up. I do find speaking up, but yes, sometimes I have been asked to slow down by court reporters. Sometimes I've had cases where the court reporter's like, at least you're loud. Many people spout scriptures but don't live by them. Absolutely. And I think that's what the defense was trying to get off. And the defense has also already said, like, he tricked her into thinking he was this, spiritual man or moral man, things like that. Do you know how long the defense's case in chief is? Thanks. It seems like they said it's going to be about 2 days. We're going to talk about that more when we get to the end of the day today. Wait, so I'm confused. So the TikToks were over a year old or recent. So I think there's both. I think there's old TikToks, but I also think that there's TikToks she did after her testimony while she's still under subpoena. So I think there's multiple. Good question, though. Kathleen, I think you overlooked a lot regarding the text. He initiated everyone. She mostly reacted with emojis only. He never asked about the child and much more that was telling from a DV perspective. Okay, the reason I'm reacting the way that I did is the defense didn't point any of that out. So I don't know if that's going to become part of their theory. And usually juries pick up on what the defense points out or what the prosecutor points out. Sometimes, though, like you're saying, they pick up on their own thing. And lawyers don't even know what they're going to pick up. And that's why I asked. I said, from my perspective, it just seemed like everything was fine. But from your perspective in reading it, which is why it'd be cool if we were on a jury together and you could be like, hey, no, Peter, look, pull these texts up, take a look. She didn't respond with, yeah, I love you too in a long paragraph. She just hearted it or thumbs up it. His comment, because I know that happened a bunch of times through the text. So that's exactly the point of different jurors coming in, different backgrounds, aiding in the discussion. And I think that's really important. Okay, I want to get to the defense's JOA argument. They had a bunch of scheduling discussion that ended up being for naught because they were not going to, have court tomorrow. They were going to have a work day. But eventually we get to the judgment of acquittal. And I thought it was a pretty interesting argument by the defense. We're going to play some of the defenses. We're going to play what the judge said. The state basically made the normal argument because they knew they were going to win. The state wins 99.9% of these. The defense almost never gets a JOA. But I do want to listen to kind of how the defense breaks down why they believe this judge should acquit Ashley Benefield.
As the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit. For purposes,
he's saying the state didn't prove depraved heart and didn't prove that it wasn't self-defense. Those are the two big deals that they didn't prove.
Of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship. But there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life.
So while that's true, they didn't prove that she hated him. That's not all depraved heart is, right? If she wanted to remove him from the situation to get what she wanted and she wanted to hurt him to remove him, that's enough for depraved heart. And in a light most favorable to the jury, a reasonable juror could find that she had ill will enough to get rid of him to have the baby on her own, didn't want him in the picture, and that's why she did what she did. It doesn't necessarily have to prove, like through text messages, that she really hated him and wanted to hurt him, but I get what he's arguing. I think it's interesting that he's talking about that 911 call. He calls it a 9/11 call. Where that was the self-defense claim, and so the state didn't disprove it at this point, which sometimes the state doesn't need to disprove it until after the defense raises it. So that's kind of the novel, interesting argument here.
The alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 911. And 911, of course, is what you do to summon help. And there has been nothing indicated otherwise that Ms. Benefield displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is "he attacked me and I shot him." There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield. And if they were properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden.
I mean, I think that is a good argument that they have not disproved self-defense at this point. I think they could have proved potentially a depraved heart killing, but that they have not disproved self-defense, because usually the defense doesn't get to raise it with evidence in the state's case in chief, which is also why the judge didn't allow them to raise that. But once it's raised, then the state could have called their rebuttal witnesses. So usually after the defense's case in chief, the state does have a rebuttal case in a self-defense case. It's an interesting argument, not a winning one, but we'll hear a little bit more between the lawyer and the judge.
Of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintal, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th. The only evidence that we've seen that supports their
Again, that is not taking the facts in the light most favorable to the state. So that's not a winning argument. If there's an arguable fact, the witness clearly said it was, He thinks it's not. He thinks he's going to be able to impeach her. We'll talk more about that later, but that's just not actually an indisputable fact as if, he's saying it is. So one thing I'm going to do, Rebecca said, believe it or not, the medical examiner gave a lot of information. One of the other things he said is the way the bullet traveled through the leg, it was in an upward trajectory. The leg could have been up, which kind of falls in line with how the defendant, said through her lawyer in opening statement that he slipped and his legs went up while she was firing. Ashland said, we can't hear Doug's side of the story because he is dead and can't defend himself. Most people don't consider this. So what's interesting is a lot of defendants don't actually testify. So the defendant's voice is being heard through the criminal defense attorney. The victim's voice is supposed to be heard through the state and the prosecutors, and they're supposed to tell the victim's side of the story. Now, they don't get to get it from the victim's mouth in this case, so I get what you're saying, but they should be pushing to tell his story, no doubt. Netwoman said, DV isn't always physical violence. Carrying a loaded gun is very intimidating and just as damaging. Getting closer to 500,000 subscribers. Woot woot. Thanks for the daily recaps of this case. I agree with you 100% on the first part of your super chat here, that can be just as, if not more threatening, and put you into a certain context when future things happen. It really can. I think that's an important piece of evidence in this case. And it's hard to even fathom we could be getting anywhere near 500,000 subscribers. That's crazy. She was alone with someone who was apparently abusing her. Her mom left her alone with an abuser. Sus behavior to me. Yeah, I mean, there's a lot of just question marks to me, which Brianna said, I'm genuinely curious how the jurors are taking all this. I haven't really taken a side, but I don't think the state has fully proven their case just yet. So Kelsey, let's go ahead and throw up a poll, because the state has officially rested. They're done with their case. So we're not going to talk as much about self-defense yet, because the defense hasn't presented that affirmative defense in their case in chief yet. So what we're just going to ask is, do you believe the state has proven their case beyond a reasonable doubt? Because they're done with their evidence. They rested. If they have proven it beyond a reasonable doubt, the jury should feel that right now. The defense started out presumed innocent, but if the state was going to prove their case, the jury should feel right now the defendant is guilty beyond a reasonable doubt. Once they hear the self-defense stuff, they may think, oh, wait, the state now has to disprove that it was self-defense. But as we sit here today, do you believe the state has proven their case beyond a reasonable doubt? Yes or no?
Alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this. 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact? Where is there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think the judgment of the court is appropriate. Thank you.
Thank you, sir. State.
And just at the onset, he died as a result of that. Yeah.
She just kind of recaps the testimony. She's right. And, like I said, the state always wins. I'm going to skip ahead to the judge's ruling here.
We have a woman who is to killing Douglas Benefield on a naked theory. Somebody who has no prior history, and
he's making like a closing argument now to the judge, which is not usually a winning way to do this. But I do want to hear what the judge says.
Is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick, as the court knows the trajectory of the leg bullet was up. So how high do you want to lift his leg as he's running away? Because you would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick.
Yeah, I don't really think that fact helped the state, right? That the bullet was going up. So Maxaw said she had 3 loaded guns in the house the day he died. The Smithfield had 3 safeties, so she had time to take them all off, or she had the gun ready to go, or she didn't have all 3 safeties on. So I've seen different people handle firearms different ways. I don't know the answer, and I think that's a good point of discussion. That shows maybe planning. Maybe she was preparing to. Maybe she did want to do it, right? And I think that's how we would have to discuss it, but I got to be honest, the state better, prove that up and make that a big point, because I don't know. That alone, because of that 3 safeties, would not be enough for me to, overcome a lot of the issues with the state's case. Right now, you guys are saying so that there's over 1,000 votes in. Over 80% of you think the state has not proven their case, and around 20% of you think that they have. So we'll see if that changes as we continue through the defense's case, but that's where the chat sits at this point.
I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed and failed miserably to rebut it. And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement?
Annette kind of feels the same way that Maxos was just discussing. So maybe there are more jurors thinking about this back there like that, and maybe it is a damning fact.
Dr. Vega, that the pistol was facing Douglas Benefield when he was shot. Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing in front of him. That's uncontradicted. Thank you.
All right. Thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom. And
yeah, that's the problem with some of the defense's argument is he wasn't exactly doing it under the right standard.
Decide whether the state has established a prima facie case. Am I mistaken?
Yeah.
No. Okay. All right. I just want to make sure. So, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by preponderance of the evidence. I don't find support in the law for that. And I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think, based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima.
So that does not mean beyond a reasonable doubt, which is different than the question that I asked you. And Jojo said, what is the state's case they're trying to prove? We know she shot him, that it was premeditated. That not even that it was premeditated, but that it was done with a depraved heart. She wanted to hurt him. She wanted to kill him. She wanted to end his life. It wasn't an accident. It wasn't justified for any reason. And the state said it wasn't done by some other reason. They have to prove what her intentions and motives were at the time, not motive, but that it was done with a depraved heart. And again, it's an inexact science, which is why it's up to jurors and how they interpret that. Verified vegan. Peter, do you know this judge? Feelings? I do not know this judge. JT said, idea for our members only about time management. How do you run a firm, run your cases, keep up with these cases and us, and still have time for church and family? I don't understand how you do it. JT, I'd be happy to do that. I just don't know if a lot of the members would find that boring. So if you guys would be interested in that, let me know whenever we do community polls. Let me know in the chat if you would want something on this, like a day-to-day time management, whatever you would call it. I'd be down to do whatever the members want to do as far as content. Well, maybe not whatever the members want to do. Kelly said, I sent you the link with the interview for Ava, but it won't let me pay to make sure it stays out. I don't know what that means, but I will look and I will try to find that interview and I'll try to react to it in a future video. Rebecca, y'all hit that subscribe and like button, as this is the best channel and chat ever. I agree with the chat part, that's for sure. East Maine, Peter, did you see Sarah Boone today? I sure did. And at 8 a.m. tomorrow morning, bright and early, we're dropping a video of my reaction to it. So make sure you guys subscribe and hit that reminder bell so you don't miss any of those videos. In my opinion, folks saying lying guilty is based on vibes. I agree it's hard to say innocent at this point, but where is the evidence that say beyond a reasonable doubt, not self-defense? Gabby, this is pretty much where I feel like I'm at. I'm not swearing she's a great person. I'm not swearing she's not manipulative or didn't lie or didn't do anything wrong. I just don't think the state proved their case. And that's a big part of the criminal defense realm. I don't know what happened. I don't feel confident about it. Maybe the defense will clear some stuff up when they present evidence, but I don't know. James, I don't believe any of the arresting officers ever identified the defendant in court. Shouldn't that be a reason for dismissal? Can you explain? I don't know if it was the arresting officers, but she was identified multiple times. I even think the defense may have stipulated to it. I could be cross-referencing different trials. The defense must prove their case self-defense, not the DA. So no, the defense just has to present a prima facie case of self-defense, and then the state has to rebut it and has to prove that it was not self-defense. Azam, Peter, if the prosecution rested but hasn't proven beyond a reasonable doubt, isn't it supposed to be not guilty since the defendant doesn't have a burden to prove anything? Correct. So regardless of what happens now, if the jury thinks the state didn't prove it, they should vote not guilty. Doesn't mean there's not more of a trial. The defense wants to present their self-defense claim, which once they present it, then the state has to rebut it and prove beyond a reasonable doubt that it was not self-defense. So they basically have to prove the case twice. All right, so then we had some housekeeping matters, a couple Richardson's hearings, which is basically, did the defense violate the discovery rules? And one of them was with Attorney Brown, who I think is the family law attorney for Ashley Benefield, that the defense wants to call to basically impeach Attorney Murphy, who was Doug Benefield's family law lawyer. And they said they withdraw that motion because they're going to depose her tonight. She's going to testify tomorrow at 9 a.m., so we got to look forward to that. But then the state tried to argue that it was a discovery violation, that the defense didn't turn over or specifically point out certain documents. And this was just a wild back and forth, a wild argument, a wild accusation from the state where I was like, how can you say this with a straight face? So at this point, let me just set the stage and we can listen to some of the arguments back and forth in the judge's decision. But the state basically argues the defense violated discovery by not giving them a document that they, the state, had and presented to the defense. And yes, you have to be somewhat specific. You have to say, we're going to use this, we're not going to use that, whatever it may be. But it's not like they dropped, I mean, they talked about thousands of documents. They didn't. They said, here are the emails, here are the text messages, number one. Number two, the reason you do that, the reason we don't, as attorneys on either side, limit ourselves to one piece of paper or three pieces of paper is because we don't know what might become relevant. And if we don't discover all of it or tell you that all of it might be an exhibit, then you'll say, oh, you said page one, you didn't say page two. So there has to be some candor and discussion of talking about what we may or may not use. But sometimes we don't know that until we're going to be up and it's our turn to present. So I thought this was a bogus argument from the state. Let's listen to the back and forth and the judge's decision here.
Facia case for the elements. So I will deny the judgment of acquittal.
Sorry. Let me jump ahead here. 750.
Testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, have you had, not that I...
Oh, so this was the... Oh, sorry, I jumped ahead too far. Hold on, sorry.
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of a doubt that the testimony was wrong.
And so he's saying, like, we didn't even know we were going to use this, Judge. It's not like we were hiding the ball, but Stephanie Murphy came and said something we didn't expect. Now the state calls BS on that.
So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony. That can't be right either. So we have to find a happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. But
I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th,
BS is what the word is that she's saying. She definitely thinks it's BS.
Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said on page 4, I have an envelope to seal this if necessary. I have Ms. Murphy's standard ground testimony that I'll pass to the
You
court.
might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking. That was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at the standard ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word.
She's like, you knew this is how she was going to testify. This is how she already had testified or talked about in this sealed hearing.
Because it's clear from your hearing that he did, and Your Honor asked him, were these turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor, but they asked for it to be private. And although they said it was about making panic, they're the same emails. It's the same email chain. And so the state feels that it was intentional violation.
So I think this was a decent argument by the state. Again, I'm just like eye rolling the arguments about the document that they actually turned over. So let me read a couple of these comments, because this one from Teresa, this one from Nikki, followed this case the last year, believe she's guilty. Okay, that's how she starts. But the state either couldn't or didn't present all the info out there. No way could I find her guilty based on what they presented. Then Jill says, the prosecution has not done well. Her history with custody and dirty tricks and manipulation hasn't been illustrated. Is she a DV victim? My gut says no, but we never know 100%. Jill says she wanted her child to herself. I lean guilty, even with a DV pass myself, but I don't think the prosecution proved it, sadly. And then the squid. For me, arguments made by the state and the defense during opening both made sense and were definitely possible. My problem is the state hasn't proven that Doug didn't attack her. I still don't know the full story. I don't know if it's me rubbing off on you or you guys rubbing off on me, but I don't know a lot of the outside info some of you guys know, but it just feels like they didn't come close to proving this beyond a reasonable doubt. So I feel bad too. I feel bad being like, I don't know what happened. If she did do this, if this really was a plan, I'd love for the state to have the evidence to present her to convict her, but they just didn't. So under the law, I don't think I could vote guilty. But it was crazy. All those comments came in right in a row.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are.
Florida is crazy open. It's not trial by ambush. Everything should be discovered. No hiding the ball. And it's crazy because we do state and federal court in my office, and we also practice in some other states as well. But federal court, there's like almost no discovery. And in state court, it's like wide open, especially criminally speaking. And so it's just such a difference. And we live that and see it. And he's basically going to say it's so open as part of the reasoning for his decision.
This is not supposed to be a surprise or a gotcha statement. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Ms. Murphy and Ms. Brown as meaning different things? Could it be received by the jury to be substantial in their decision-making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are.
So basically what he's saying is, I'm going to tell you, defense, now, you got to point to the pages, tell them what you're trying to put in so they can make the arguments if they want to. Then he starts to read the colloquy to the defendant about testifying. But it's not the actual colloquy to ask her the question. It's just like a prelude, like, this is what I'm going to ask you later. And then this is something weird that I've never seen before. In the middle of this, the defense attorney's like, Judge, I'm uncomfortable. I think you're trying to drive a wedge between me and my client with this colloquy. And I was like, what? What's he getting at there? So again, just all these kind of very strange things happening outside the presence of the jury that I thought was a cool learning experience that we could discuss together, that you guys would enjoy and learn from. And even this, for me, it was different. It was different. So people are asking what a Richardson hearing is. So yeah, I explained it right in the beginning real quick. It's just like if there's a discovery violation. Actually, I think I might have been explaining this when I froze out. If there's a discovery violation, the judge has a hearing to determine if it was intentional, if it was trivial or substantial, if he needs to sanction somebody, if he needs to hold somebody in contempt, if he needs to strike a piece of evidence or strike a witness because you have willfully violated the rules of discovery. They had that hearing. That was the argument back and forth about that document. He allowed it in. They didn't end up having the hearing about the family law lawyer that they are going to call because the state can cure that by deposing her tonight. So there were some potential discovery violations, and a Richardson hearing is just the hearing we have to determine things about those discovery violations. Let me hit a couple more. Again, not knowing this case, playing devil's advocate here, nobody knows what goes on behind closed doors, whether you believe the prosecution or the defense. I don't think that's devil's advocate. I think most rational, logical people would agree with that. Sarah, question. What about the abuse on 2 ex-wives and the way he abused the animals? So that hasn't come in yet. That testimony hasn't come in yet, so we're not really considering it. It was discussed in opening statement, and I believe the defense will bring that in. If the defendant is presumed innocent, it is illogical to have to lean to the state when they request a dismissal. So we're taking it out of the hands of the jury, right? So if we're going to take it out of the hands of the jury, it needs to be 100% basically that even if everything they said was true, they would never win the case in a light most favorable to them. It's just for this element. It's not for guilt beyond a reasonable doubt, right? They're different standards at different points in the case because the judge would have to, it's supposed to be only a very small percentage of cases that this happens to. Churicity, how is it okay for the prosecutor to show the shot location different than the ME testified? He made it clear it was from the front. I mean, he said it was like from here. So is that really the front or the side? I kind of felt like side to side did kind of make sense with how he was describing it. The defense is going to say it's front. It's one of those gray area arguments. It seems like you don't believe the prosecutor, which again is not a good thing and doesn't bode well if that's how the jury sees it. To me, it doesn't really prove what the prosecutor is saying it proves, just because even if it was side to side, that to me does not prove it was not self-defense, especially multiple shots, people moving around, like a lot of things can happen. It wasn't quite, the Murdaugh shot trajectory. Thank you, Azam, for gifting a membership. Okay, so now I want to jump into when the defense jumps in the middle of this judge giving the colloquy and just makes a very strange argument I've never seen made before.
And you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs. You understand what you're doing. You're not being forced, threatened, or coerced to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended. I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client.
No, it's not.
My client,
It's just not. I've agreed with someone what this attorney said. I disagreed. Like, to make sure you weren't forced or coerced to trial does include lawyers, because sometimes clients come back later and said, my lawyer forced me to do this, or my lawyer forced me not to. So by having this colloquy, we prevent all of that. And most lawyers welcome that. It's protecting everyone. But he's getting up and acting like the judge is doing something coercive. I'm not with this argument.
trust that I have her best interests at heart. And
I hope that you do, and I believe that you do, but just trust it and don't mention it and don't confirm it. Come on.
my client trusts that I have her best interests at heart. And I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right
The judge is like, I don't get it.
to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional.
The lawyer trying to control the courtroom. Okay. He's trying to control it. This is purely judicial discretion. The judge absolutely has the right to read the colloquy as he sees fit. And by the way, this seems like a very normal boilerplate colloquy that he's reading. But I mean, this was a bridge too far, in my opinion. Rebecca, thank you for gifting even more memberships. The gifts keep on coming.
Intimidation of a woman who has made a choice.
Like you're making you're like the judge is intimidating her.
Or is in the process of making the choice after consultation with her attorney. And this is just piling the pressure on the client. I'm sorry, Your Honor, I find it uncomfortable.
You would be heard for, I mean, it's my decision.
I would like to be heard. I've heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes a decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield.
That's not really true either. You're not supposed to find out what is in the mind of Ms. Benefield. That's not the point. The point is beat into her. Okay, that was not good language for this. The point of this was make sure there is no gray area, that she understands her rights. We have to make sure, and sometimes it's hard. Sometimes we have to say it over and over and over again. Make sure she understands her rights, and then she can make whatever decision she wants. That's her right. She's a grown woman. She has autonomy. She has to make her decision, but we, as the court system and the judge, has to make sure that we even protect people from bad lawyers, because guess what? They exist. They exist. Bad lawyers exist. And the judge giving this information to the client is a protection over that. And that's why a judge has to, should, will, would do this exact thing.
So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say. And if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me. So
he's like, well, you did get upset at one comment, but he's like, you've disagreed with me 1,000 times. Doesn't bother me. Clearly doesn't bother you if I disagree with you. I like this judge's disposition at the end of the day. He's like, hey, brother, do what you're going to do. Tell your client what you're going to tell her. I got to do my job, and I'm going to do my job. So I appreciated that.
if you say, hey, don't answer that, okay. But I'm going to have it on the record, because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify. My lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll ask you, make sure that nobody's threatened you, forced you, or coerced you to make this decision. That nobody's promised you anything, any benefit or a particular outcome to make this decision. That you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it. And if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it.
So I did think it was a little bit weird that the judge did this now, because he's like doing it twice, kind of. But what he said is no big deal. And it makes people ask these questions. Why is the lawyer acting brand new? And is this the first time the lawyer's ever heard this colloquy? No, it's actually the opposite. This is showing the lawyer's not brand new, that he's kind of feeling himself. And he's like, I'm king of this courtroom. I'm going to tell the judge how I think it should be done, basically, is the feeling I got from watching. But at the end of the day, there was nothing inappropriate about that. A little weird maybe that he was going to do it twice, but It is what it is. And a judge controls the courtroom. And this is absolutely within a judge's discretion to do something like this, in my opinion. Mary C., thanks for gifting 5 more memberships. And these are gifted on the way out. So make sure you have your gifting tool turned on. Make sure you guys have hit that like button, please. Some of you guys said, I'm coming in late, coming in at the end of the video, catching the end. Make sure you hit the like button, even if you just came in at the end. And make sure you subscribe and hit the reminder bell, because Sarah Boone video dropping 8 a.m. So that's all we got. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a page you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.
Was I muted all this time? Fuck. I was speaking to you all and I was muted. Oh, what a plonker. What a plonker. Oopsies. First of all, thank you, Katie Santos. Thank you so much, my darling. Just want to say thank you for being you. Thank you so much, Katie Santos. I appreciate you for that. Thank you so much for the super chat. $20 super chat. So Lady Amy says someone is talking to Melanie. Yes, the reporter from the trial. I guess Eva stormed out, and her and her friends were laughing at the testimony. I hope. You're a day behind. No, I'm not, Linda. That was Peter Tragos' take from yesterday. So tomorrow we'll play his take of Ashley today. So he does it like late at night. So, but I like to listen to his take. I hope you enjoyed it. DH Amy, DH Cross, better tread light. If they come at Ashley aggressively, not going to look good. Should be interesting. Should be interesting. You're right. You are right. I also believe you asked a question earlier on. I just caught it. Two of the jurors are male. No, one juror is male. So there's 6 jurors. 5 of which are women. 1 is a man. There are also 3 alternates. 2 of which are women, and 1 is a man. So 2 men in total. So the jury itself is 5 women, 1 man. Just in case. Was blowing my hair dry singing, hit the like, please, hit the like and subscribe. It would mean the world to me. If you liked and subscribe. Like and subscribe, motherfuckers. Thank you, Jenny. Welcome back. Hey, thank you, Josie. Is he talking? I was talking. I was speaking. I was on mute. I didn't really understand. Hey, Ruka, my darling, how are you? Hope you're well as well. Lisa Reed, hello to you, my darling. Oi, good day, Aussie, Aussie. Oi, Aussie, oi, Aussie. There you go, Steph. Thank you. Here we go. Did you have a nice break? I did, actually. Nice. I have had a little bit of food. They're coming back in, right? Court is unmuted, yes. But yeah, nice little break. Thank you. Back to it. Thank you for the coverage, Dylan. No worries, Mike. Thank you, sir, for being here. Only 1 month. Thank you. Yeah, so it's 1 man on the jury. So it's only 6 on the jury in Florida. Why so few men on the jury? I wonder. I think it's a mistake because I'm a man and I feel sympathetic towards her. So I thought there would have been more of that. But they went for it, so I don't know. Raoul Dylan, apparently 58% don't believe Ashley in a court TV poll. What's our chat say? Our chat, I had one, not about Ashley herself. I don't want to do it about her. I think it's quite split, pretty 50-50. But the overall consensus before lunch was 70% believe she will be found not guilty. So, and 30% was guilty. So, and I know it's divisive. Some people think she's lying. Some people think she's been genuine. As I say, people have your opinions. It's all good. Haha, thank you, Steph. I'm back to the mismatch. No, just lunch, an hour and a half lunch, our 120-minute lunch. So nothing major. Here, Borden Court yesterday. That was something. No, I've not watched it yet. I've not watched it. Damn, just left the Grizzlies. The horror. What? Just left the Grizzlies. What's that mean? I don't get it, Gitcom. I don't understand the Grizzlies. A big team. Go. Again, thank you for the super chat, Katie. Cross is going to be intense. Crime Junkie, I agree. Yeah, I agree. I'm looking forward to the cross. I always look forward to the cross because that's the only time you can really tell. You know, she's been prepped for the direct. But that's the same for every witness. So, no worries there, my darling. And also, I hope your pussy's okay. I hope that they tread lightly and don't come across as bullies. If they do, that's a huge mistake. It's a huge mistake if they do. The 30% of idiots. No, they're not idiots, Linda. Everyone's got an opinion. Do you know what I mean? I personally believe she's not guilty. I don't believe the state have proven it. But some people might. So, can you put your email in chat? Yes, I can. Wait, what? Grizzly is another. Oh, you talk about Grizzly, whatever her name is. Yeah, I don't watch. I mean, yeah, I encourage people to watch it, make your own minds, but not my cup of tea. Hey, Josie's got it. There you go, Crime Junkie. Josie's on it. She's on it like a car bonnet. Look at that, Josie. Thank you, my darling. If they're too aggressive, she will struggle to keep her emotions under check. And I think that the jury would think that they're bullies, you know, so I don't think it's a good look. If you just go in there calmly, ask the questions, try and catch her out, you know, if you can, if there's any lies. There you go. You're welcome. Right, have you all liked and subscribed now, people? Oh, someone just liked. Thank you so much. I'm finding a lot of people unsubscribing. Don't unsubscribe, people. Yeah, cross-examination, Sassy. She does not seem at all the type that will get angry. No, I don't think she'll get angry. So once the jury back in, we will be cross. No, I don't think that. I think that's a big mistake. Big mistake. That's when we need to tell them that, hey, prosecutors, chill out, calm your tits. Elsewhere, like when I come in first thing, thank you, Amy. Some people don't. That's why I have to remind them. No worries, Crime Junkie, it's all good. As long as you've done this, hang on, where's it gone? As long as you people do, hey, Crime Junkie, as long as you've done this, it's fine. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Much better today, thank you. No worries. Crime junkie, hey. Hope she'll stay cool as a cucumber under cross. Wouldn't blame her for not crying for them. Yeah, we'll see how she does. Mama E just loves it. I always hit the like. Yeah, you go, Crime Junkie. I trust you as well. Next time you're in, well, or you're actually still here, but where are you from, Crime Junkie? I've always meant to ask you where you're from. Calm your tits, girl. It's your tits you need to calm, girl. Calm your what? Steak tips? No, tits. Calm your titties. Or your mum boobs, Raoul. Love it. Hey, Lady in Boston, let's fucking go. She cried real tears when the 911 call was played in court. Oh, I didn't. Yeah. Calm your tits. Hope the paralegal took a shower. Nashville. Nashville, okay. Nashville, Tennessee.
Yeah, let me know if you find everybody.
Okay.
It's a good state, but no state tax. No state tax, I believe, in Tennessee. Oops, let me just move that. I know Tennessee because Busting with the Boys are from Tennessee, so and the Titans, obviously, from Tennessee. Oh, actually, I did know that because you spoke about Tennessee before. Yes, I should have remembered. Sorry, Crime Junkie. Sorry, that's my bad. Titties. We all love titties. You know, nothing wrong with titties. Or as you know, you ladies probably like man boobies. We like titties. Same thing. It's just fat with like a sultana on the end. Ruka, 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 Ruka. Over there in Chicagoland. In Chicago, they put the green, the river green, don't they, for Paddy's Day? Breasts. Breasties, James, breasties. Oh, still waiting. It's the white noise thing that gets me. Oh, remember? Yes. So that's yes. For some reason, I thought that was Rebecca. I'm going to be sitting with a lawyer in the upcoming trial. I get to sit at the defense table. There you go. That's really good.
Good afternoon. We're back on the record in State versus Ashley Benefield. We've had our lunch break. It's about 1:08 in the afternoon. I have both prosecutors and Mr. Taylor here along with Ms. Benefield. Before we get started, Ms. Benefield, when we took our lunch break, I gave you the full warning that I give to all the witnesses that you've heard multiple times regarding sequestration. I was erroneous, however, because my instruction to the criminal defendant has to be modified slightly. You are allowed to meet and speak with your attorney over the break. I no sooner got upstairs than realized I gave you the full sequestration instruction. Now, there was no objection to it. Case law talks about if there's an objection to it or a deprivation of the right to counsel. But I want to make sure if there was any error, or even arguable error, that I correct that now.
I appreciate it, Judge. We'll be able to get it all worked out.
Okay, so I'm happy if you want to take time to speak because you're allowed to. I'm happy to take a recess and give you that time if you need.
Thank you. We're fine.
All right, sir.
I think there will be a pre-objection to something I intend to introduce.
Okay, yeah, if you know about him now, let's talk about him before we bring the jury in.
Well, I don't know which one to.
That was interesting. I like this judge, though. I do like this judge. Happy days, hippie chick. We're going to the pool.
All right.
Indiana.
Oh, well. You don't have to approach. Or unless you want to. Is it something we want to keep?
No.
Okay.
No.
It's her fault if she walked first.
I did.
So I have States Exhibit 103 and States Exhibit 104.
Yes. It's their objection, so.
Okay, yes, objection.
Relevance is to the modeling photo, and mugshot, we submitted a memorandum to the court. It's pretty clear case law, mugshots are not.
I disagree that the case law is clear, the mugshot is not admissible. But the relevance of both of those is to show her face before and after this incident, so the jury can make their own determination if there's swelling on her face. And I did say when we had a pre-trial discussion about the mugshot that I would not intend to enter it unless the defendant made it relevant by testifying that she had swelling on her face. So I do believe now that she said there was swelling on her face, I can introduce the mugshot that occurred weeks later to show.
I apologize.
I was done, I'm sorry.
Objecting party, rebuttal.
I know I wasn't able to introduce in the state's case in chief. I don't think they should be entitled to introduce at ours either.
Well, I think there was some evidence that was introduced. It all depended on what it was. Thank you both very much. 103, what did you refer that to? A modeling picture? Is a modeling picture showing the defendant's front face down to the chest area. And 104 is, I've not compared it, but you say that's the booking photo that was taken when she was arrested. All right, I was just checking because there's like a speck on it. I was checking to see if that was a paper speck or in the picture. So yes, what we originally talked about, I don't think I don't agree that there's a blanket prohibition on the entry of a booking photo. However, it is a bit of a more unique situation if there was an erroneous decision not to allow one party or the other to introduce evidence during the other side's case in chief. It's a fairly simple remedy that the other party can just call them in their case in chief or in rebuttal, lay the proper predicate and introduce the evidence if it's admissible. In this situation, it's a little bit different. Obviously, these would need to be authenticated by the defendant. So I don't think it's improper. I'll allow it. The only thing I'm going to require, however, is the 104 is just to be referred to by the date. On such and such a date was your photo taken.
And Judge, I respectfully disagree. There's no case law that says a jury cannot know that a person was arrested. The only case law is that a person cannot be made to sit at a trial in jail clothes. But there is no prohibition. They know she was arrested.
Mm-hmm.
So I believe that helps substantiate the date that it was taken and the time that it was taken.
And I think you can ask her the date and time. So, yeah, no, overruled.
All right, can I see the exhibits?
Of course.
And Judge, just for the record, the state has still not received the ordered defense exhibit list that we instructed them to get.
Are there any other defense exhibits? Well, let's finish. Let's close this issue out.
Yes, sir. I'm sorry.
All right, so defense has handed state 103 and 104 back. The question was asked regarding defense exhibits. I don't know what's left. I don't know what witnesses are being called or when, but do you have an exhibit list that complies with Rule 3.220?
I think we gave them all.
No?
Judge, they gave us 360 something items, file folders with multiple pages in each one. That does not comport with the rule. They need to tell us what they are going to introduce specifically.
Well, the rule calls for what do you intend to introduce?
We have them, share them with the prosecution today.
Prior to any other witnesses being called?
Yes.
Okay. Are you ready? State.
Judge, I just still would ask for a list because it's hard for us to, when showing us them, I don't have the ability to recopy them and do all those things like I would have if I'd gotten a proper list. And so it's just hard for me to be able to then go find the things to be able to figure out if they're complete.
So here's what we're going to do. We're going to have a mid-trial exhibit exchange. And we'll take a break. Maybe it'll be the mid-afternoon break. I have no idea.
We'll give them a list.
And you're going to get a list. And if not, you can go through them and you can write on a piece of paper exactly what they are. And if you say, I want a copy, they're going to give you a copy.
Yes, sir. Thank you so much.
Okay. Problem solved. You ready? You ready to go?
Yes.
All right. When we finish, Ms. Benefield, you were on the stand. So if you could reposition yourself, please.
And if we could put the screen down, please. And shut the lines. Thank you.
Yeah. The clerk is going to leave the lights. The clerk's going to leave the lights as is. When you need the lights lowered, then let us know.
What number is that? I don't know what you're talking about. 52. I don't need it. Oh.
All right, bring in the jury.
Okay, here we go. Here we go. Here we go. Here we go. Yeah, Mama Ames, sorry to hear about that, Mama Ames. Sorry to hear all your stories. I agree, Jim. No man should ever put their hands on a woman, only to hold and comfort them. Hello, Mrs. Ash. Hello, my darling. Nice to see you again, Mrs. Ash. See you for a little bit.
Are you all can have a seat? Welcome back, everybody. Over the lunch break, did anybody talk amongst yourselves or discuss the case in any way? Did anybody talk with anybody outside of the jury about the case? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
Everybody says no. On state, you may begin your cross-examination.
I would like to just start with a couple of issues. So first, Doug Benefield never punched you ever, correct?
Yeah, I'd say that's correct.
Doug Benefield never choked you ever.
No.
He never kicked you.
No.
He never pointed a gun at you.
He waved a gun in my direction.
But it was not pointed at you, correct?
It was pointed at me while he was waving it at me.
He never came at you with a knife.
No.
Or a club.
No.
Or a baseball bat.
No.
So there are 30 years difference between you and Doug, correct?
Yes.
And you got married after 13 days.
Yes.
And you spoke with him about, or organized with him about starting this ballet.
Yes.
Correct. And all of the money for the ballet came from him or investors, right?
My mom also funded the part of the ballet.
You didn't put anything into it. Money.
Not from my account, no.
Okay. In fact, during this time in South Carolina, you never worked, did you?
He wouldn't let me work.
Okay. When you said in the very beginning he flew you to South Carolina to visit before you were married, he paid for that, correct?
Yes.
Okay. And the cruise you talked about going on, he paid for that?
No.
He didn't?
He did not pay for the cruise. No.
Okay.
Yeah, he paid for my friend to go, but I had already paid for my mom and I to go. So.
Okay. So he paid for your friend to go?
Yes.
And he did not go with you?
Oh, no. Mm-mm.
I want to ask you about the text messages that the defense talked to you about. It's going to be Defense Exhibit 3. I'm going to hand it to you. But I have the entirety of it on a spreadsheet that I'm going to put up, which is State's Exhibit 99. If we could dim the lights, please. And Judge, based on the rule of completeness, State would enter into evidence State's 99.
Did you want to be heard in addition to what was said earlier?
I haven't actually seen the specific message.
Any objection to State's 99? Received.
So I'm going to put this up on the board behind you, screen. We're trying to get it to come up on the screen. Okay. So I would like to orient you to what we're looking at. So on the top line, it gives whether the messages are outgoing or incoming. That would be the third, fourth column that we're looking at. And what I would like you to do is read the body of these as we go through. I'm going to expand it so you can see it. And if you could just read these for the jury.
Okay. One part is just looking at Renee.
Who is that from you or from Doug?
It's from Doug to me.
Okay. So from Doug, one part is just looking at Renee. Okay, go ahead.
I'll tell that part to start. The day I met her, I felt her before I saw her. Oh. My ex-husband lived to argue. Renee and I maybe argued 5 times in 15 years, and even then ended up laughing. Smiley face. I'm a clown at heart and love people being happy. That seems like a hard act to follow. Baby. Like always being armed. Yes, my love.
And the outgoing messages are you or Doug?
It looks like outgoing is Doug? Yeah, outgoing would be from Doug.
Judge, can we see the date for reference of the messages?
It's up on the screen.
Where?
So yes, my love, I think was the last thing you said. And then what's the next thing?
Are you doing things that are dangerous?
And you're going to have to speak up just a little bit.
I'm sorry.
Here.
Are you doing things that are dangerous? To think of all the time that you were not with me and understanding them and how to conduct warfare in them for the kingdom.
Where was he when he was sending you these messages? While you were on the cruise?
I believe he would have been in Charleston.
Okay. He wasn't on a business trip?
I don't believe so.
Okay. Continue reading. All the other people.
All the other people. Then a rectangle. It makes me so sad. And then another rectangle. If I dwelt on it, I would go into rage to remove them from the earth.
And your response to that?
Yes, baby, I hate it. It hurts. He said I could defend myself, and you were easy prey for predators. You're sweet and want to please people, and they used that.
And you said? I'm sorry, and then he said?
I desire to exterminate them, and holding back is a challenge. They are rats that should be removed.
And you said?
Oh, baby, my love. Yes. Like that night, like last night, just the jerks arguing near you about put me in a sheer murderous mood, but I was stuck and I couldn't defend you. I said, thank you, baby, but I was okay. He said, but could have been a fight, etc. Only you being with me will over time remove images in my head. It is same, and knowing you were taken advantage of in my mind makes me explode with anger to take them out. God made you for me. And I said, yes, baby. He said to enjoy the beauty he did craft on earth. I see Renee as Eva's mom, not my wife. It is strange, but...
Can you pull that back up?
He said it is strange, but there is no emotional connection. I said, well, I'm glad. I just wish I could see it that way.
And you said, I'm glad. I wish I could see it that way. Were you talking about being jealous of his relationship with Renee?
I guess you could put it that way.
Okay. You can continue to read.
I know we both have a battle to fight in our minds. He was sitting on the mantle in the background. I'm crazy, I know. But it just killed my heart. I know I see you in my mind with a bad person with your legs spread and a shitty person choking you out. That haunts me. I love you and I never want to hurt you. I'm sorry. Rectangle. Now all I see is some douchebag on top of you, fucking you with your legs spread and him choking you out and fucking you more. Right now, I literally want to kill him or them. I said, baby, don't even think like that. He said, you haven't seen the warrior side and you never want to. I said, no one will ever touch me. I am yours. I don't. You are right. I want to see you only as my sweet and loving husband who is gentle to me and kind. He said, we went from joy and passion to now I'm in a testosterone rage inside. And who is always there and safe? That's what I said. And I said, let's not ruin the day. He said, but kill the bad people. Okay. And I said, tell me that you love me.
So this conversation was about things that you had told him that people had done to you, correct? When he's talking about, I'm imagining this, I'm imagining people choke you, he's talking about a conversation that you had had with him explaining that this had happened.
I think he was referring to on the cruise one night I was talking to him on the phone and I was sitting out in the hallway up at the top deck and I was just trying to get somewhere where it'd be quiet so I could talk to him. And it was near, there was some like a bar or something up there, I think, I'm not sure, but people were coming in and out, like maybe a restaurant. And while we were talking, he heard.
Is the answer yes or no? Did
She's saying,
You need to allow her to finish her answer, Your Honor.
let me finish your answer.
He had heard a couple guys that were talking loudly and he got upset because he thought these guys were going to hurt me. And so he had talked about then that he imagined that, you know, I was out in the world without him and that people were going to take advantage of me and that he didn't know what was going to happen to me.
And he was afraid for your safety.
Yeah.
And he was saying that if anybody hurts you or he thinks about anybody hurting you, it sends him into a rage.
Yes.
And that scared you.
I'm sorry.
And that scared you.
Well, as I said earlier, at the time, I kind of, you know, played it off in my head that he was just my new husband who was trying to be protective and like show that he loved me by kind of being, you know, manly.
Okay. So I want to talk about you having a baby. So Doug had a vasectomy removal in April of 2017, right?
Yes.
And you paid for that?
Part of it went on my debit card or my credit card.
And your intention was to get pregnant?
Yes, we had talked about that, yeah.
And this was how many months after you were married?
We got married in September, so October, November, December, January, February, March, April. 7.
And was this, during this time, you said he had started criticizing you, right?
Mm-hmm.
About the way you looked, your clothes, the way you acted. He was, according to you, he flipped a table, tried to flip a table, threw a chair, right?
Yes.
He would scream at you.
Yes.
He would call you slut and whore.
Yes.
And you want a baby.
I mean, yeah, we were married. We wanted a family.
Okay. So the vasectomy reversal happens, and I believe you said that this baby was a surprise. Is that what you said?
Well, we weren't like planning on it right then. You know.
Were you having unprotected sex?
I suppose so.
Okay. So you knew that unprotected sex would result potentially in a pregnancy.
The doctor had told us that it probably wouldn't work for a while. So it wasn't something that we thought would happen that fast.
Okay. But it did.
Yes.
How quickly? When did you get pregnant?
I guess July.
And right around this time is when you say the incident happened where Doug threw a gun at a wall.
He threw it at me.
Shot a gun at the ceiling. I think you made several allegations, correct?
Yeah, he admitted to it, but yes.
What were you arguing about?
I think Eva was part of it. I don't specifically remember.
And wasn't it true that you had a problem with Eva and you thought she was disrespecting you at that time?
I wouldn't say I had a problem with Eva. There was a lot of tension in the house, but yeah, there's a lot of things going on that were not ideal.
You knew she was 15.
Yeah.
And you knew she had just lost her mother tragically to death.
Yeah.
And you were how much older than her?
10 years, 9 years, 10 years.
And this tension surprised you?
No. I mean, at first he had told me that she was really going to love me and that she was ready to have a woman in her life and that he wanted me to move in quickly because she needed a mom. So he made it sound like she also felt that way.
And you had no feelings of your own?
I was excited to get to be her stepmom.
And you gave her a shadow box right around this time, correct?
For Christmas, so it would have been in December.
All right. And what was the shadow box?
You want me to describe it?
Yes.
It was like a small picture that had like deep sides and like the glass was at the front of it. And there was a sand dollar that I had painted and decorated. And I put it on like a black cardstock. And I wrote a saying on it that said something about how like you can be strong through the storms and that, you know, seashells are beautiful things that come out of storms.
And that shadow box is the reason you were arguing that day with Doug, correct?
I know it came up at one point. I don't know if that was the reason.
And what was the problem with the shadow box?
Eva had taken it apart and I guess had thrown out the thing that I made and was using the picture frame for something else.
What was she using the picture frame for?
She had put a rose from her mom's funeral in it.
And that upset you pretty badly, didn't it?
It made me really sad. I had taken a lot of time to make it for her and I thought it was special. And yeah.
You began crying.
Yes.
And you dropped to the floor and sobbed hysterically.
Probably.
You were so upset that she put her dead mother's rose in the shadow box.
Right. It wasn't that. It was that she took it apart. I mean, I would have bought her another shadow box.
You went to Doug and said it was disrespectful that she took this apart.
According to Doug?
No, according to you. You went to Doug and said, she's acting disrespectfully. You need to handle her. She upset me. I'm crying.
I don't remember saying that about that.
Isn't it, in fact, what you were arguing about before this whole incident with the gun and the ceiling?
Is this relevant as it relates to the daughter?
Can you approach, please?
Who did the daughter walk out? I missed it. She'd be quite aggressive as a prosecutor. I think she's fucking herself over here. I think Ashley's coming across very well so far, anyway. And it's interesting the judge called them all up. Why did she walk out? Oh, because they were talking about her. Well, if she ran out, hopefully she's not allowed back in then.
So the day that this argument happened, you actually, at one point, were in the car with Doug, right?
Yes.
Okay, you're going to the bank and going to do some other errands?
I believe so.
And the entire time you're upset about this shadow box?
I don't distinctly remember that, but the argument kind of came from there, I guess.
And in fact, it wasn't an argument, right? It was you being upset.
Well, he said that like life was out of control and he couldn't deal with the people at home and he couldn't deal with the people at the ballet. And he felt like everything was just too stressful and he was upset with everybody.
And didn't he ask you to stop?
I'm sure at some point.
And you didn't stop?
I guess not.
For the car ride? No? Yes or no?
I don't remember.
And you kept telling him you need to discipline Eva.
I don't remember saying that.
Okay. And he said, let's just stop talking about this for a while. I need to think.
He was yelling at me.
So he's yelling at you, but you weren't sitting there like you are now, were you? You weren't sitting there like this.
I guess I was buckled into the car, so I probably would have been sitting further back.
And you didn't stop. And then you get home, you're still arguing, correct?
He's still yelling at me, yes.
And you're not yelling at all. And the fact that he had a gun with him when you continued to argue in the house was because he grabbed the gun from inside the car to bring his items from the car into the house, correct?
I'm not sure why he had it, I guess.
Okay. And it was in a holster.
I believe so.
And you both used to carry guns.
Mm-hmm.
You carried guns on a regular basis.
Yes, ma'am.
Have had at the time more than one gun.
Yes, ma'am.
And you actually bragged, as well as Doug, about having guns, correct?
Yes.
And you would go shoot them on a regular basis.
I haven't been to their range since before the presidential election.
Okay. But during the time that you met Doug at a political event, you had one of the guns in your bra.
Yes, that's where I concealed carried.
Okay. So having a firearm in a car or in the house is not that unusual to you.
No, ma'am.
All right. So after you get back inside, there's this argument that continues on and on and on and on. And you're still asking Doug to discipline Eva.
I don't recall that.
Okay. And you say he was waving a gun around and threw a gun at you. Is that what you said?
Yes, ma'am.
So he has a gun in his hand, could point it at you.
He did point
but
it at me.
But he throws a gun at the wall.
No, he threw it at me. He missed me.
Okay. And it hit the wall.
Yes, ma'am.
Okay. When was this? What was the date of this argument?
I believe it was the end of June.
2017.
Yes, ma'am.
When was your wedding reception?
It was shortly after that, maybe like a week or two later. I don't remember specifically.
Okay. So even though you'd been married before, you were now having a wedding reception.
Yes, when we got married, it was just the two of us.
And at this wedding reception, you had a lot of guests come?
I'd say maybe a dozen. My friends and family came.
And they're dressed up?
Yes.
You're in your wedding dress?
Yes.
Okay. And I'm going to show you State's Exhibit 10. I want you to tell me what this is. Or I'm sorry, it's 100. I want you to tell me what this is. It's going to come up behind you. What is this a picture of?
That's a picture of Kevin, Christy, me, and then Doug.
Okay. And is that a picture from the wedding reception that we just talked about?
Yes, ma'am.
Okay. I'm going to show you State's Exhibit 101. What is that?
That's a picture of me and my friend Christy.
And is it at the same wedding reception?
Yes.
And State's Exhibit 102, what is that?
It's a picture of my friend Laura and me, and then my friend Christy.
And this is also at the same reception?
Yes, ma'am.
Okay. State will move into evidence, States 100 through 102.
Any objection?
I'm sorry, I missed it.
Any objection to states 100, 101, 102?
No.
Received.
Thank you. And in states 100, are you scared here of Doug?
No, I would not say no.
You said on direct examination that around this time you were living the nightmare. Those were your words, correct?
Yes, ma'am.
Okay. Were you living the nightmare here?
Oh, no, not at that moment. No, that was a very nice day.
How about at this moment?
Oh, it was a good day.
And states 102 at this moment?
Same. It was a good day.
So you get pregnant and you decide to move in with your mother. So when do you decide to move in with your mother in Florida?
It was the end of August, I believe. I was really sick, and he brought me down to my mom's house and dropped me off.
Okay, but going to your mom's house was your choice, right?
We decided together. He said he couldn't take care of me. He was too busy, and that my mom could take care of me better. So I was happy to go.
And you needed someone to take care of you while you were pregnant.
I was really sick, yes.
Okay. So you moved down with your mother at maybe August of 2017, you said?
The end of August, I believe.
Okay. But there's still this issue of the injunction in South Carolina while this is going on, this South Carolina-Florida thing, correct?
I'm not sure I understand the
Well,
question.
you said you applied for the South Carolina injunction, or you received the South Carolina injunction right around that time in 2017. Actually, I think you said November 2017.
Yes, a few months later.
So shortly after you moved in with your mother, a couple of months, you filed for an injunction in South Carolina.
Yes, ma'am.
And we talked about the fact that, or you talked with the defense about the fact that it was a mutual injunction.
Yes, ma'am.
So both parties agreed to stay away from each other, correct?
Yeah, I believe that it was for both parties to stay away.
No evidence was presented at this hearing.
I don't believe so.
None of your complaints were heard at this hearing.
There was like a written, like a filing.
But the judge, other than that, did not hear any evidence at the hearing.
That's correct.
All of that was forestalled because the two of you agreed, okay, fine, we will have this voluntary stay away order.
It was decided through the attorneys, but I believe that was, yes.
Okay.
Yes, ma'am.
So the judge never found that Doug Benefield was dangerous and ordered this injunction.
I'm not sure what the judge found. I don't know what you mean by that.
There was never a court finding giving you an injunction, other than you stipulated to it.
The judge ordered it, yes, ma'am.
Okay. And this injunction, actually, part of it says that neither party shall harass or threaten or do those types of things to each other.
Yes,
right?
ma'am.
Okay. So then after you're in Florida, you get a package that you say was in violation of this injunction. And it's a birthday present, right?
Yes.
It's a tea set.
Among other things, yes, ma'am.
And you liked tea.
I like drinking tea, yes, ma'am.
You drank tea all the time with Doug.
Yes.
Okay. And you opened this tea and you claim that it smelled so strongly that you automatically rushed it to the sheriff's office.
I didn't specifically sniff the tea. It was when I opened the box, the whole contents had a very strong chemical smell.
So you immediately rushed it over to the sheriff's office?
No, ma'am. I immediately sealed it up and I left it in my garage.
For how long?
I don't remember specifically. It was maybe a day or two. I don't remember.
It was a little bit longer than a day or two, was it not?
I don't remember.
Okay. So after this time goes by, you take it to the sheriff's office and you claim that this was a violation of injunction. right?
It was, yes, ma'am.
And you also claim that this was all part of Doug's poisoning scheme to poison you and your unborn child.
Hazmat informed me that there was toxic
I don't want to hear what
chemicals and-
someone else told you. I want to hear what you claimed, that this was part of his poisoning of you. Plan to poison you.
Well, based off of what I was told, that was the
Yes
conclusion
or
I came
no,
to.
ma'am? Yes or no? What, according to the way you felt, this gift was a part of his plan to poison you.
It concerned me. Yes, ma'am.
So no charges were filed for that, correct?
Correct.
So you filed for an injunction based on the same allegations, right?
When my injunction in South Carolina was getting ready to expire, yes, I filed for one in Florida.
Okay. So when you filed in Florida, about what time was this? What date?
I could give you a ballpark. It was in the spring. I don't remember exactly
Spring of 2018?
Yes, ma'am.
Okay. So you had left Doug in South Carolina August of 2017.
Yes, ma'am.
And you filed for an injunction in the spring of 2018.
That sounds right.
But you hadn't been living with him, correct?
Correct.
You hadn't even had any contact with him for a very long time when you filed for that injunction, right?
Well, other than him sending the box and, yeah.
Okay. So what violence were you trying to prohibit by filing this injunction? Everything that happened in South Carolina.
Well, I was just hoping that wouldn't happen again.
Okay. And at the same time you did this motion for an injunction, you also did a motion to terminate Doug's parental rights, right?
Yes, ma'am.
Okay. So during this time that you haven't been with him in almost a year, at least half a year, there hasn't been any violence other than you say the T said. You're filing for an injunction all at the same time that you're trying to terminate his parental rights. This is all correct, right?
Sounds correct.
Okay. And you hadn't even had the baby yet.
As of when?
As of the time that you were trying to terminate his parental rights.
I don't remember what the date was, but it would have all been around that time.
And then there's the hearing that goes on for this injunction, right? And this is in front of Judge Moreland, correct?
Yes, ma'am.
Okay. And you had a 2-day hearing on this?
Yes, ma'am.
Partially, it was a motion for your injunction based on these issues, and it was also Doug's motion to be able to see his child, right?
I believe at some point things got consolidated, but I don't recall specifically.
So at this point, Doug had not seen his daughter.
Correct.
And your daughter was how old?
As of the date, like the last court date?
Yes.
About 6 months old.
And had there been any violence towards you between the time that you filed for this and the time when you had the hearing and she was 6 months old?
He had showed up at night in my driveway, but I mean, there's no physical contact if that's what you're asking.
Okay. And was this a time when the baby had been born?
I don't remember the date of when he was in the driveway.
How about, since we're talking about this, let's talk about the incident you talked about where the neighbor said that that Doug was there. Can you tell me about that?
Yes, ma'am. He was outside standing in the yard at night, I guess trying to look in the windows of my house.
And where's this neighbor's house?
She is directly across the street.
Okay. And isn't it true, in fact, that this was very dark? It was very dark out.
Yes, ma'am, it was at night.
Okay. And your neighbor told you that she saw someone in her backyard walking, correct?
I think she said that when she confronted him, he kind of ran away.
Okay. She never told you he was at your window.
What she said was that he was trying to look in the windows.
In her yard?
The way the houses are situated, where he was standing, he was looking across into the windows of our house. Yes, ma'am.
And she couldn't see who this person was?
Object.
She told you?
She's asking Ms. Benefield about what the neighbor knew.
She told you she could not identify this person?
She said by just looking, as dark as it was, she had a hard time identifying him by his face, but that she identified his voice.
That's interesting. So let's talk about that. So when she tells you that there's somebody in her backyard, you go to her house, right? You end up together with her.
Yes.
All right.
Not at her house, but yes.
And you play a recording that you've recorded, like a voicemail from Doug, for her, right?
She believed it was Doug, and she said that she could probably identify his voice because he had a unique voice. And so I played a voicemail I had from him, and she identified him.
The fact is, she didn't tell you she thought it was Doug. You just asked her if it was Doug.
I believe she contacted us and said that there was a strange man looking across into our windows, and she was freaked out, and she wasn't sure if it was him.
Okay.
I don't remember specifically. I'm sorry, this was a long time ago.
And you play a recording of Doug's voice for her.
Yes, ma'am.
And she goes, oh, that's him.
Yes,
That's
ma'am.
the one that was there.
Yes, ma'am.
So that is the ID that Doug was in her backyard.
I believe she also described his body type, his stature. She said he was wearing a baseball cap, which he often did. So I think that was probably
Don't a
part
lot
of
of
it.
people wear baseball caps?
She needs to allow
I'm sure.
before she cuts her off.
I've been able to follow along, so I'll overrule at this point.
There's a lot of people that are 5'9", right?
Oh, yes, ma'am.
A lot of people that weigh 160 pounds.
Yes, ma'am.
A lot of people that wear baseball hats.
Yes, ma'am.
And isn't it true that this person in the backyard said to her, I live around here. I live here.
Mm-hmm.
Okay.
I believe so. I wasn't there for that part, but that's what I believe she told me.
Thank you.
Yeah.
Now I want to move forward to 2019. Around this time, Judge Moreland had already ruled that you could not have your injunction, right?
She denied it. Yes, ma'am.
And that Doug could have immediate visitation with his daughter.
She ordered time sharing, yes.
Did you start visitation with Doug and Emerson very shortly after that hearing?
Yes, according to the court order. Yes, ma'am.
And you decided you were going to go with him on this visitation?
I offered, and he said he would be glad for me to come. So yes, I went.
This person that you lived in a nightmare with, you decided to go with him on this visitation?
Yes.
Now, the Judge Moreland hearing, when she ruled, she made it very clear that she did not see your side.
Sustained.
You had no faith that Judge Moreland was going to help you from that day forward.
Overruled.
You had no faith that Judge Moreland was going to help you from that day forward.
I don't know that I'd say I thought she would never help me, but I mean, she denied the injunction, yes.
So you go for this visitation with Doug, along with him and Emerson, and that begins sort of I think Stephanie Murphy called it like a honeymoon period or a happy period piece. Would you agree with that?
Yes, ma'am.
Okay. So during this time, you spent a lot of time with Doug.
Yes.
And a lot of time with Emerson.
Yes.
And you weren't scared of Doug at that time.
He was being very kind.
Okay. So you weren't scared of him at that time?
No. I mean, I had things at the back of my mind, but he was being very kind.
So then around summer of 2019, you actually make arrangements with Doug. He's going to move into your mom's house.
He wanted to move in, yes.
You actually agreed to that.
Not specifically. He didn't really ask my opinion. He told me.
Okay. And then the date that he was supposed to move in, you made plans with him,
Hold on a
correct?
second. Sir, who's crinkling the paper? Is that Mr. O'Keefe? Sir, can you please stop? Thank you. Go ahead.
So during this time, you're speaking with Doug.
Yes.
Right?
Yes.
And you're talking with him about moving into your home.
He was insistent that we needed to
The
move in
answer is
together.
yes or no, please. You were talking with him.
She interrupting the answer.
If the question calls for yes or no, the questioner has the right to expect a yes or no, or I don't know, or I don't recall,
So
as opposed to a narrative.
You were speaking with Doug about him moving into the house
Yes.
and about his things being moved and when they were going to be moved.
Yes, I'm sure.
And at any time during this, did you say to Doug, no, you're not moving in?
Yes.
You said no.
I'm sorry.
You told him, no, he cannot move in?
Yes, that's why he ultimately didn't move in, as I said,
Okay.
I can't do this.
Isn't it true that, in fact, you didn't tell him no, you just weren't available the day he was supposed to move in?
No, that's not correct.
Okay. So you're saying the day he was supposed to move in, he knew he wasn't supposed to move in? Is that what you're saying?
We had a conversation that day, and I told him that I didn't want him moving in.
Okay. And then you did not take his phone calls. You would not speak with him. I think the word was ghosting. You ghosted him.
I don't know whose word that is, but that's fine. Yes, ma'am.
Okay. But visitation continued.
Yes, ma'am.
All right. And you continued to exchange custody of Emerson where? The sheriff's office or?
I believe at that time we were doing the sheriff's office.
And sometime around this time, you show up to this visitation with an engagement ring on, right?
No, ma'am.
Okay. Who is Dennis Beatty?
Dennis Beatty.
Beatty. Who is that?
He was a gentleman I dated at one point.
And it was during this time that you were dating him, right?
After I told him not to move in, and then we started just doing time sharing with Emerson. Yes, after that, there was a period of time where we dated. Yes, ma'am.
And isn't it a fact that Doug filed for a divorce after one of these visitations?
I'm not sure when he filed for divorce specifically.
He filed for divorce after he knew that you were dating this other man, right?
Once again, I'm not sure when he filed.
How did he find out? Did you tell him you were dating him?
No, ma'am.
Okay. How did he find out?
I think he was stalking me.
It wasn't the ring on your finger?
It was not an engagement ring. Yeah.
Well, it was a ring. Did he see the ring on your finger?
I'm not sure what he saw. I wear rings all the time.
Okay. So Doug files for divorce. And all of a sudden you file for, you start a bunch of complaints, correct? About his treatment of Emerson. What you say, his bad treatment of Emerson.
Well, she started coming home hurt.
It's a yes or no question. Did you file complaints about his treatment of Emerson?
Yes.
Okay. And you eventually filed for another petition to get an injunction based on those incidences that you claim happened with Emerson.
Yes, ma'am.
Okay. And you complained about the first time and nothing was done. Is that correct? With the police, no charges were filed, nothing was done?
I'm not sure specifically what you're referring to.
The first complaint that was made
about
Emerson and Doug, you agree that you made allegations.
Jack, can we?
Yes.
I missed that bit. What happened now? Fuck. I don't know who they are. Right, we're here. I missed the last 5 minutes, but up until the last 5 minutes, I think she's done really well. I think, but again, I've missed 5 minutes of this, so I don't know for the last 5 minutes she's done. But prior complaints. Okay, thank you, Joe. Thank you, Amy. Well, up until now, I think she's done a great job. Do you know what I mean? So, I think the prosecution have hurt themselves a lot here, you know. But as I say, that's up until 5 minutes ago, so we'll see what else is to come. There's more testimony to come, so we'll have to see. Dawn's like, she's a bitch. She's a woman. She's a something like a bum bum bum. Oh, she can't listen, can she? To Cyber because she's on the bench, on the stand. Deb says she's doing well. The prosecution looks mean and unsympathetic. Well, condescending. She's like, right? And she's like smirking while she's looking at the jury. It's now 7:05 in the evening, Crime Junkie. 7:05. Katie says, I'm moving to guilty. I don't see how she was afraid for her life. He may have been abusive, but that doesn't mean he deserved to die. Okay. I mean, I think for me, the fact they smashed the dog unconscious and, you know, shot in the ceiling and stuff, I think those, for me, play a factor in this. Yeah, it's dark. It is dark. I got the lights on and everything. I got lights on now. Curtains closed, lights on. It's not too bad, but it's still a little bit light out there. But I wanted to pull lights on now. I think she does a great job when it's in her favor, but then it's asking her to confirm things like court acted in favor of Doug. She's playing dumb. Oh, she shouldn't play dumb though. You know, it's all coming in. That's normal prosecution defense. They all have to act kind of intimidating. I don't know, you know, you've got to be careful with this kind of timid witness. You've got, you know, because you can lose a jury. The jury feels sorry for her. You know.
During this time, did you speak with members of the sheriff's office?
I'm not sure specifically what time you're referring to.
During the time that there were allegations that Doug was abusing Emerson, did you speak to the sheriff's office?
Yes, ma'am.
On numerous occasions?
I would say so, yes.
At least 5?
Probably, yes, ma'am.
Okay. And during those conversations, you were making allegations that Doug was abusing Emerson, right?
Well, I was explaining the injury she'd come home with. I mean, I wasn't there. I don't know what happened.
Okay, but you were alleging that Doug was abusing the child.
I was concerned after her pediatrician called CPS and said that she thought she was being abused.
Are you aware that pediatricians are required to call CPS when a mother alleges that?
I didn't allege anything. I brought a video to show her at the appointment, and she called
So you
CPS.
Objection. Finish your answer, ma'am.
Well, after showing her a video of some behavior, she called CPS and she informed me that I was also a mandatory reporter and that it would be negligent if I didn't also call and make a report.
You brought Emerson to the pediatrician specifically for this reason, correct?
No, ma'am. She had her checkup.
But you brought this up to the pediatrician.
At the end, she asked if either of us had any questions.
And that's when you bring up, oh, she must be being abused.
No, I described to her the behavior that I was seeing, and I showed her a video when she came to her own conclusions.
Okay. So you spoke to the sheriff's office about that investigation and other investigations, and about the investigations that Doug was abusing Emerson.
A sheriff usually comes out with the CPI from Child Protection.
And you spoke to them?
I mean, they were there when I was talking, I guess, yes.
And you were talking, making allegations against Doug, assuming that he caused injuries to Emerson.
I'm not sure of my exact words. I was trying to describe to them what I was seeing and my understanding of the situation at the time.
You filed a petition for an injunction based on those things, correct?
At the advice of my attorney, yes, ma'am.
Okay. Whether your attorney advised it or not, you chose to do that, correct?
Yes, I followed the advice of my attorney.
And you were aware that if you went forward on this injunction, that it was going to be in front of Judge Moreland?
Yes, ma'am.
And this injunction hearing was supposed to take place on September 30th of 2020. Yes, 2020.
Yeah, it got moved several times, but that was a date.
Okay. So it was supposed to take place on that day.
Yes, ma'am.
And there were other things pending. Do you know what the other pending items were?
Not specifically.
Okay.
I'm not sure what you're asking.
One of them was Doug's request for a divorce, correct?
Yes, we both filed for divorce at that point. Yes.
So Mr. Benefield filed for divorce. You file an injunction petition. Then you file for divorce.
I filed for divorce first.
Okay. And then you're scheduled to have this hearing on 9:30.
Yes, the hearing was scheduled for 9:30. Yes.
And you're speaking with Doug during this time, right? I mean, we just heard 200 and whatever text messages between you and Doug.
Yes, ma'am.
So do you at any time in that say to him, I'm going to go forward with this injunction on Wednesday, on the 30th?
No, ma'am.
In fact, based on those text messages, you were dropping the petition for an injunction.
Yes, we talked about dropping everything. Yes.
Okay. No, you talked about it, but you said you were going to.
Yes, ma'am.
And that is what the result of the mediation was. That there was not going to be any mediation really because you were reconciling.
Yeah, we agreed, I guess, in order to move to Maryland. My understanding, the attorneys were advising us to, if we close things down, that it would make it easier, like legal wise, for us to relocate.
So you were telling Doug that's what you were going to do.
Yes, we were trying to work things out so we could all go to Maryland, yes.
And drop the injunction.
That was one of the things.
Okay. And you wanted him to drop everything, right? The motion to release the report, the dissolution of marriage, you wanted him to drop everything.
No, we filed a joint stipulation so we could get the report.
But then you asked him to drop that, didn't you?
I know we kind of went back and forth with so many things.
Okay. You never had any intention of not going forward on your injunction.
Honestly, it was kind of one of those things that some days I thought that maybe I should, and some days I thought that I shouldn't.
So during this 1 week before you shot Doug, you're talking and you're saying to him things like, oh, we're packing boxes, we're getting everything together. This whole time, you knew you weren't going to stop that injunction hearing.
I hadn't decided yet.
Okay. Your attorney testified that you were going forward on that injunction hearing.
She was advising me to keep it.
Okay. So during this time when you're telling Doug to bring different boxes, bring tape, you asked him to go to Selby Gardens, right?
Yes, we all went. I think we got lunch. We brought Emerson so she could play.
Okay. And you are having conflicted emotions about whether to go forward on an injunction
Yes, ma'am.
while you're out having these types of experiences with them?
Yeah, sometimes things are really good and other times they weren't.
Okay. And so how about, let's see. This is part of State's Exhibit 98.
I didn't know what it's doing. I think it's giving you clues that I gotta guess. Get real? Real?
Working mother, not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum. Oh no, it's running out of time. House. Real house. White. Oh, housewives of. Oh, real house. Oh.
And this video was taken the week before you shot him, right?
I don't know the exact date.
When was? I mean, in your mind, it was very close to the time, correct?
Yeah, I'm sure it was right around then. I don't remember when it was.
And during this time that you were having these text messages with Doug and you're planning to move to Maryland, there's no violence going on.
No.
No?
I guess not, no.
He's not hitting you.
No, ma'am.
He's not choking you.
No, ma'am.
He's not shoving you around.
No, ma'am.
So this entire time, there is no violence going on.
Well, I don't know specifically what time frame you're talking about. I'm sorry.
But during this, let's say from 2018 to 2019, when you're not living with them.
I mean, if you classify violence as him like
I'm asking
punching me or
there's
choking me.
physical violence during this time.
He could be rough sometimes.
Okay.
Yeah.
Did he ever punch you?
Not during that time, though.
Did he ever hit you?
No, ma'am.
Did he ever use a weapon against you during that time?
Not during that time, no.
So in between the time of 2019 to 2020, where you shot him, was there any physical violence?
Like I said, sometimes he'd be a little rough, you know.
But other than that, he never was physically violent.
He didn't like punch holes in the walls or anything like that, no.
So when I asked you if has he been violent, you said, well, he didn't punch holes in the walls. Is that what you just said?
That's what I just said, yes, ma'am.
So punching a hole in a wall to you is a definition. When I ask, was he violent? Your definition of that is punching a hole in a wall.
I think that is violent.
Okay.
I'm not sure what you're asking.
Okay. So hang on just a second. So I want to get to the day that all of this happened. This happened on a Sunday, right?
Yes, ma'am.
And you're moving on, or you have a hearing on Wednesday.
I believe that's correct.
And
Yes,
you're
ma'am.
moving right after that.
I think the actual day of move was kind of in flex. It seemed like it changed 1,000 times.
You're all getting in the car together, not together, but you're driving cars together to go to Maryland.
Yeah, I believe he was going to be driving the U-Haul and pulling his truck. And I think that my mom was driving her car and I was driving mine.
And you were telling him during that time that you were going to move to Maryland and attempt to reconcile.
No, ma'am.
You weren't telling him that.
No, not in those words. No.
Did you hear Dr. Broder testify about that? That he said that when you were with Doug.
Objection here, sustained.
So you're denying that you ever told Doug that you were wanting to reconcile with him.
I said I wanted to find a way that we could do things together as a family for Emerson's sake, you know, and that's why we started doing things differently. He wanted to move back in, you know, together, and I told him that I didn't want to do that. I didn't feel comfortable with that.
Did you say that in Dr. Broder's office in front of Doug?
No, not in front of him.
So when you're with a safe person, a psychologist, you're not telling Doug this.
What? I'm sorry.
You're saying that you told Doug when it was just the two of you that you didn't want to move in together.
Yes, ma'am.
And you felt safe telling him, I don't want to move in with you. Right? That's what you're saying.
Yes, we had that conversation many times. Yes.
But you're in front of this psychologist who one would think is a safe environment with Doug sitting next to you. You hear Doug say to Dr. Broder, we are going to Maryland and we are going to try and reconcile. And you don't feel safe enough to say to Dr. Broder, no, that's not what I want to do.
I would want to make him look bad in front of somebody else.
Okay.
I wasn't going to disagree with him in front of anybody.
Okay. So the plan was to load up the truck, get everything done, and then move very shortly after the court hearing, right?
Yes, ma'am.
Okay. And you had no intention of dropping that injunction, so you knew on the day of that hearing, he was going to know, right?
I'm sorry.
You knew that Doug was going to know that you had no intention of reconciling with him.
We had the conversation many times. I think he understood where I was at.
Okay. You saw the text messages between you and him, right?
Yes, ma'am.
Would you agree that those text messages do not indicate that?
It doesn't say we're getting back together, moving in together.
It doesn't say we're not going to reconcile.
I mean, not specifically, no, I wasn't going to argue with him.
If you got your injunction on that day, September 30th, how would you have moved together?
Speculative.
What was your plan if that injunction was
Speculative.
granted?
Different question. Overruled.
Objection, speculative.
No. You can approach.
Like, even me, right? You know, none of this sits comfortably with me. I can sort of understand why she wouldn't say it in front of someone else, stuff like that. You're in a safe environment. I don't think you're in a safe environment. In the moment, maybe, but as soon as you leave, you're not safe once you get home. I hope the jury picking that up as well. I mean, yeah, I don't like the line of questioning here at all. And she's answered some good questions here, you know. I know she's been a little bit evasive on some of the things about Doug, but also I give her a little bit of grace because she's also nervous. You know, her life's on the line here as well. She's facing a minimum 25 years in prison. So
So if the injunction were granted on that day, what was your plan about moving to Maryland with them?
I don't know that I really had a plan. I wasn't even sure whether or not I was going to go through the injunction at that point.
So there's something sweating.
Take care.
Okay, so I want to get to the night that all this happened. So you knew Doug was coming over.
Yes.
You invited him over
Yes.
to help you move stuff in the house,
Well, specifically stuff in the garage, but yes.
stuff in the garage to the truck.
Mm-hmm.
Right. And he came to your house a couple of times. He came and then left and then came back again.
Yeah, I believe he came twice that day.
And there is a gate to your community.
Mm-hmm.
And when he's at the gate, you had to let him in.
Sometimes, because he was frequent in and out, sometimes the gate remembers license plates, and sometimes it opens and sometimes it doesn't. Sometimes he would just follow people in. The gate kind of stays open for a while. But yeah, sorry.
But on this day, you weren't concerned about him coming over.
No, I knew he was coming.
Okay. And when he came over, your mother and Emerson went to the park.
I believe they were headed there. I'm not sure. I think they were down the driveway or on the sidewalk, something like that. They were on their way there.
You weren't so afraid that you wanted your mother to stay there and watch.
No, we were just packing to move.
Okay, so you weren't afraid.
I definitely didn't expect this to happen.
So it was okay with you that your mother left?
Yeah, at that time.
Okay. So if I heard you right during your direct, you said he bumped your shoulder twice. Body check, I don't know if that's what you called it. He walked into you with a box, right?
Yes.
And then at the end, you say he slapped you?
He hit me. I wouldn't know how to classify it. He struck me, he hit me.
Was his hand open or closed?
I don't remember.
Okay. And because of those things, you claim that you thought he was going to kill you.
He had never hit me before.
Okay. And you thought he was going to kill you.
He wouldn't let me leave. I tried to leave. He stopped me.
The question is, you thought he was going to kill you.
Yeah.
Okay. Now, when you were in the bedroom, you decided to get your firearm. And it was where?
It was in a storage bin on top of the laundry basket.
Okay. So I'm going to show you State's Exhibit 52. If you could turn around and look at that. Where was your firearm?
It was in the bin on top of the basket.
Here?
That's the basket. The laundry
Where was
basket.
the bin?
It's that right on top.
Okay. So it was in here.
Yes, ma'am.
Why would you have a firearm in there?
I had just emptied all the furniture and everything out of my room, and it was kind of like what was left from my drawers, and so it got put into a bin.
Okay. And that was not your only firearm in that room, correct?
Correct.
You had a firearm in the closet.
My carry gun was in my backpack, which was my purse at the time.
So in this room, with a mattress and a broom and a hamper, you had 2 firearms.
Yes.
So you go into the room and you grab your firearm. Is it in a holster?
I don't remember.
Okay. And you claim that Doug does what?
He came and slammed the door open. He was standing in the doorway. He said, "You're fucking done."
He said, "You're fucking done." And that made you fear for your life.
Yeah.
Can we turn the lights up, please? Thank you. So So he says you're fucking done and you point the gun and you shoot.
I held it out in front of me first so he could see it. And I said, stop.
Judge, if I could have her step down so she can demonstrate.
You may.
If you could just come down. So Doug opens the door and does what?
Standing in the doorway, kind of like this. He said, you're fucking done. And I held the gun out in front of me. I said, stop. He got into this like fighting pose where he like turned sideways. And he was like moving around with his like arms in his hands. And he started like inching forward towards me.
So he why do you call it a fighting stance?
Well, he looks like a fighter. I don't know, like a ninja or something, I don't know.
Okay, so he's standing there, he turns to like this and starts moving his arms around.
Oh my God.
Well, show me, what was he doing?
Kind of like, I don't know, he got like this, and he was like making like fighting motions. I don't know, I'm not a fighter, I don't know.
Okay.
It was scary.
Did he have his hands in fists?
Not at that point, they were like, I don't know.
Was he coming at you like this?
And he lunged at me, he came very quickly.
Okay, so he lunged. Was his fist up when he lunged?
I don't remember.
Okay. So you start shooting, and he does what?
He kept coming at me.
Okay, so then you keep shooting again. And he falls down on his back.
His legs went up in the air.
Okay, where do his legs go?
In the air.
How high in the air?
I don't know.
Did they go over his head?
I don't know. It's like his feet slipped out.
Okay.
And his feet and his legs went up in the air.
And were you still shooting at the time?
I don't remember.
You can have a seat. So after this incident, you claim that you had swelling to your face, right?
It's going to take a minute. All right, members of the jury, can you please close up your notes, put them on your chairs. I'm going to ask you to step out for a minute. You can use the facilities. It's not quite our mid-afternoon break, but we'll treat it as such. Please don't discuss the case amongst yourselves. Don't discuss it with anybody outside the jury. Don't do any research like we've talked about. All right, the jury's out. You can have a seat.
I'm sorry.
All right, we'll take 5 minutes. Yes.
Wow. Wow. There's a way of doing it though. There's a way of doing it. The way that was portrayed was not the right way to do it. I think the DA has made more damage for herself. So I don't, you know, again, that's your opinion and that's fine. But I don't agree she should have done it that way. There's other ways to do it. Yeah, I agree. I think that's totally backfired on the state that has. there's ways of doing things, and that is not one. That's not one of the ways to do it, in my opinion. Um, that would have been very uncomfortable for the jury, for everybody. That would have been very uncomfortable. And do you know what? It gained nothing. It gained absolutely nothing. You can ask those questions on the stand, no problems, but to reenact something, uh, can you imagine though? Do you know what I mean? I agree with Deb. I think she's totally gained sympathy now with the jury. So if she was guilty, I think it's backfired. I think they're going to feel very sympathetic for her to go through that. I think you pick your battles. I don't think that was one battle that they should have gone through. You know, if she's deemed to be guilty, that's fine. But I mean, that's not the way to get a guilty verdict. You know, so. But hey, wow, I don't know what to say about that. I generally don't. That's a little bit shocking, even for me. And I've seen a lot, and I've never seen that before. I'm trying to see if there's anything. I'm gobsmacked. I honestly don't know what to say. I've got nothing to say for it. Um, you know, what position has always been. I don't think the state have proven anything anyway. So, um, she's not guilty, and I think that's just solidified it even more now. I think the defense, Young, knew what was going to happen. The defense knew that, you know, this is going to trigger her emotions. So it's good for her. You know, in terms of that, it's good for the defense. You know, I'm not saying it's good for her. That's the wrong word in, because obviously it's not good for her. But in terms of getting off this conviction, it's good for her. Jeepers. Oof, I've not seen something that bad for quite some time. Oh. Right. Yeah, I mean, look, I know you're here, Barbara. You might be able to troll, I don't know, but like, even if you think she's guilty, you know, there's ways of doing stuff. Even if you think she is guilty, that was unnecessary. Um, so yeah, I mean, appreciate the fact that you think she's guilty, but even if I did think she's guilty, I would still say the same. That was not necessary by the um, attorney, because even if she was not abused, there's other people out there watching or on the jury and stuff like that that have been abused. And in my opinion, the attorney was mocking a lot of that and downplaying um, domestic abuse. So as much as I respect the fact that you think he's guilty, I still think there's a time and place as well. Oh. If you could get Mighty Meat to change his mind, wow. And Mighty Meat's the most. Mighty Meat doesn't even have a heart. Hope you well, fella. If she finishes before long, there will be, yeah, probably.
All right, y'all can have a seat. Welcome back, everybody. Usual questions. Did anybody discuss the case or anything about the case amongst yourselves with anybody outside the jury or do any research? Everybody says no. You may resume your cross-examination.
Thank you. Can we dim the lights again, please? Thank you. So after this incident, you said you had swelling,
Yes, ma'am.
and that would be to the left side of your face?
Yes, ma'am.
And that would be where? Show me where.
Like in this area.
Okay. Now I'm going to show you State's Exhibit 103. I'm going to put it up on the big screen. Can you tell me what this is?
It's a picture of me.
And when was it taken?
I have no idea.
Was this taken before you met Doug?
I believe so.
Now I'm going to show you State's Exhibit 104. And I'll move it up a little bit. When was this picture taken?
I believe in October of 2020.
Wasn't it taken on November 4th of 2020?
I believe that's correct. I'm sorry.
Thank you. I have no further questions.
Redirect. No further questions. All right, man. You can retake your seat. Just leave that exhibit there. No, you're not. You can take your water. I meant the paper. Okay. There you go.
That was creepy Tommy, cousin Tommy.
Just, yeah, the clerk. Thank you. All right, defense, call your next witness.
I believe it's Mara Sweet, Your Honor. We're just checking to make sure she's here.
Judge, I think we need to have a conversation.
Okay.
That was a really poor cross. She did very well. Yeah, they could have rested there. I agree with you, Mighty Meat. I do think that they got a professional DV expert, though, coming in that will probably help the jury understand why maybe she didn't tell the psychologist. There's other experts coming in, I think. Yeah, do you want rule? This is a very good point. We're saying this, but the jury might think differently. So we just don't know. Gotta go pick up her parents. We're all going for pedicures. Enjoy yourselves, Mama Ames. Enjoy yourself. Yeah, he's Doug's cousin that tried it on with her. My heart goes out to her. She needs psychological help. not another man. Yeah, that's true. Have fun, Mama Ames. Although I think she is putting forth an exaggerated victim persona, I believe her. If she was lying, she would have made up more than what she testified to. Hugs to fellow survivors. See you later. See you later, Mama Ames. Enjoy, Mama. I really wish that Eva was not in the courtroom. I honestly believe that she's a victim of Doug too, and that seeing this is not healthy for her. Well, she stormed out as well, and I just, yeah, I don't know. Have a wonderful day, Dylan, and thank you to you and the mods. Thank you, Mama Ames. Yeah, so that's it. The DV advocate will be called just to do that. But I would just be tempted just to do that. Just leave it as that. I don't think they need to go into everything else. The state did not prove anything. Eva is, yeah. So Eva is 23 years old. She is the eldest daughter of Doug. Yes. He shouldn't be. I mean, that's ridiculous. That's ridiculous. I wish, in a way, that the defense had said, "Yeah, we'll subpoena him," which means that he couldn't be there and not call him. You know, end on the demo. Yeah, yeah. Prove nothing. Have a good day, Mama. The state tried and failed miserably. I hope the jury see that as well. I really do. Everything could have stopped me. Sorry, Bev.
I'm sorry. So I'm going to let you step in the back so we can have our legal conversations. I'll get you back out as soon as I can.
Thanks, Crime Junkie.
Don't begin your deliberations. You're free to use your phones, but don't communicate about the case with anybody outside the jury. Don't do any research on those things.
Oh.
Before you start on that, can the clerk just confirm she got all those exhibits back? I just,
You can all have a seat.
okay,
She
thank you.
counts them on a regular basis.
Thank you. I just didn't want to have any over here.
I'm sorry.
I messaged you back, Crime
Okay,
Junkie.
so we got a proponent, we've got an objection. Is the witness in here?
She's right outside.
Okay, good. I want to make sure she stepped out. Okay, so the defense has called a Miss Sweet, who apparently is a former prosecutor in the 12th Circuit.
Yes.
And she, if I understand correctly, she was assigned in the misdemeanor division, the domestic violence division, and the case, the alleged violation of domestic injunction regarding the T-set was assigned to her.
Correct.
And you expect her testimony to be that she intended to file the charge, she was waiting on some receipt.
Receipt is the package.
Like a mailing receipt?
Yes.
That would have shown what, the return?
That Stephanie Murphy gave to the detective Gillen.
And then you believe her testimony would be that she intended to file the charge, but then she was transferred out of that division.
She left the office.
She left the office, okay. Because that's one of the temporary assignments that they give to misdemeanor folks. So she left the office, and that's it?
Well, and her training based on domestic violence training, she believed Ashley to be a victim of domestic abuse, and that Ashley exhibited all the symptoms of domestic abuse, in particular, remaining quiet as a result of intimidation and going, for example, the state's case is predicated on Miss Benefield going along with Douglas Benefield. For example, on the first parent sharing exchange and the week leading up to the shooting, they put in those 263 text messages and the video at the restaurant, all showing Miss Benefield in Mr. Benefield's company as apparently happy and not afraid. And abused, those are the classic symptoms exhibited by abused women. They are afraid to reject the abuser for fear of reprisal. And what happens is after a while, they reach a state of compliance where physical threats are no longer necessary because they know what the potential is. So they become compliant. That's also what Bruce Ferris is going to enlighten the jury on. And I remind the court that this is the state's theory. They have put into play, they injected it, they raised it, initiated it, that because Miss Benefield didn't look scared in the company of Douglas Benefield, and that she was exchanging these text messages with him for the week leading up to the shooting with smiling faces and basically compliant behavior, that shows that her claim to fear of Douglas Benefield on the 27th is a fraud. And we now need to explain to the jurors why an abused woman would act like that and would, for example, not agree to be present at the first parent sharing exchange. When a child is involved, it magnifies the situation so that the mom, if she's afraid of, in this case, Mr. Benefield, because of prior acts of domestic violence, she's even more afraid for her child. So the mother's going to make it a point to accompany the abuser in an effort to protect her child. That's what we are now obligated to show to properly defend this case. And we can do that through the training and expertise of Samar Sweet, as well as Bruce Ferris.
Judge, first of all, this witness was not listed as an expert, because if she had been listed as an expert, I would challenge the qualifications to be an expert. Just for your honor's knowledge, we did not have a domestic violence unit at the time. I know our office has in the past. We did not have a domestic violence unit, so she was not in any domestic violence unit. Even if she were an expert, there is absolutely no way that she could testify that she felt that Ms. Benefield was exhibiting behaviors of an abused person. I think it's completely improper. And the issue of the decline of the injunction, or the fact that Ms. Sweet intended to file, is irrelevant. I can tell your honor, and for the court's knowledge, it's because when we got the receipt of when that package was sent, that receipt showed a date that was a problem for us. And that is why that case was declined. So the decision was made after Ms. Sweet left the office and we received the receipt. So the fact that she would be testifying, I believed her and I wanted to file it, is completely and totally irrelevant.
Yes, sir. Rebuttal?
Yeah, so the court may recall that Deputy Weber had issued a capias for the arrest of Douglas Benefield for the delivery of this package. Detective Gillum came into court and told us that he suspended Deputy Weber's request for a capias, and we have a communication from Deputy Gillum that we got by way of a public records request where he acknowledges plain as day that it was a violation, that it was during the time that the South Carolina injunction was in effect. But he nonetheless refers it to the state attorney's office. This is the assistant state attorney that was working that case. She would testify. We'd like to put her up for a proffer that she fully intended to file. She believed it was clearly a violation based on the fact that the court.
Well, I'm just saying, if you want to proffer, let's get her in and proffer, because then all these arguments would happen after the proffer.
Okay.
I mean, but I haven't made a ruling, so you can make your argument, I can make a preliminary ruling, and then you can proffer.
Yeah.
Okay. Mr. Taylor, you didn't go outside. So listen, how about I do this? The jury's out. It's about 3:00. I'm thinking maybe give them a 20-minute, a longer afternoon break. When I do that in the afternoons, I will typically have a deputy escort them down to the jury assembly room where they can kind of spread out. The machines are there, the restrooms, but deputies are with them. Okay? All right, deputy, can you excuse them until about 3:20? We'll get them back up as soon as we can. Thank you.
Happy days, Shari. 3 people. Happy days. We'll wait to see what happens here.
Yeah, it's a profit.
I'm good. I'm good, thanks. Fucking hell, better now. Hello.
Cool, man. My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself, go ahead and sit down. Make yourself comfortable in this seat. Pull yourself up so you're about 12 to 15 inches from that microphone. There you go. To adjust up, down, left, right, however you need it. Speak in a loud, clear voice. You'll hear everything. As you can see, I'll tell you, you're a former prosecutor and attorney. Jury's not here. At this point, the defense is going to proffer your testimony.
Okay.
Afternoon, Ms. Sweet. Will you tell us your full name and spell your last name?
Yes, Samara Sweet, SWEET.
Are you currently employed?
I am.
What's your title and where are you employed?
I am the trial lead of counsel at Lydecker, which is a civil litigation firm.
All right, and you're Florida Bar licensed attorney?
Yes, sir.
At one point, were you a staff attorney for the Manatee County State Attorney's Office?
Yes, I was.
How long did you serve in that capacity?
I was there from 2018 to 2022. It's about 4.5 years, I believe.
All right, and during that 4.5 year stint, was there any special assignment that you held?
I began with the misdemeanor division here in Manatee County. After 6 months, I moved to Arcadia. So I was in DeSoto County, where I started in misdemeanors and moved up into felonies, where I would have dealt with anything from possessions of controlled substances all the way up to child sex crimes and murders.
Specifically, did you have any training in domestic violence?
We did. Every attorney at the state attorney's office does go through CLE's trainings on how to deal with domestic violence victims, because especially when you're working in the misdemeanor portion, a lot of your crimes are batteries and a lot of them are domestic violence victims.
Can you give us an idea of how many cases you handled involving domestic violence?
Oh, I think at one point my caseload was 700 when I was in Arcadia, and at least a third of those were probably something domestic violence related.
Did you deal with not only abusers, but the abused?
Yes, most of the cases I had as a prosecutor, my victims were abused individuals.
Were the majority of your victims in domestic violence cases females?
I would say a large amount were females, yes.
Were you assigned, while in your capacity as an assistant state attorney for the 12th Judicial Circuit, were you assigned to a matter involving Ashley Benefield?
I was, yes.
How did that come to pass?
So when I was in Manatee, I had the caseloads with all defendants that had the last names with B, D, or I. So Ashley Benefield's case came to me, and she was the victim in the case that had been assigned to me for a violation of an injunction.
Do you recall specifically the nature of the violation?
It was a package that had been delivered to her allegedly from her ex-husband.
All right, and the domestic violence injunction that was violated, do you recall from where it had been issued?
It was from out of state. I believe it was South Carolina.
And did you meet with Miss Benefield?
I did.
Do you remember on how many occasions?
I believe it was twice, because when the case first came, there's elements to a violation of injunction that have to be met. We had not yet had all the information, so I did meet with Miss Benefield, got some more information, and then had to follow up on the investigation. I had to meet with her again after that.
Did there come a point in time when you made a filing decision?
I did not. I had left the office before a filing decision was made. I had been moved to Arcadia at that point.
I should have articulated that question better. Had you, as part of your investigation, individually reached a conclusion as to whether or not you felt it justified going forward and charging?
I did. I think I was still waiting on some information to prove if the package had actually been sent by Mr. Benefield. And that was the last information that I had left to my predecessor before I left. But I did think that if that information was given, there was enough to file.
And would it help refresh your recollection if I suggested that you were waiting on a copy of the receipt for the package?
Yes, I was waiting on to see who had sent that. And I know I had been in contact with the officers involved.
Do you recall whether or not you were dealing with Detective Gillum?
That I'm very bad with names, so I do not want to say yes or no, sir, if it was Detective Gillum or not. That does sound familiar, but I might have worked with him on other cases as well.
All right. How was Ashley Benefield when you first met her? Can you describe her demeanor?
Yes, she was very upset. She seemed scared, worried. She had come to my office and she was crying when she was sitting in my office with me. I did think that she was worried about the package that had been received.
Now, was it your practice generally to always meet with the victims in the cases that you were prosecuting?
Yes, it's office policy.
Had you formed an opinion about the genuineness of the fear that Ms. Benefield expressed?
I did believe that she was in fear and worried about that.
And from the investigation that you conducted, did it vindicate, other than the actual label for the package, the factual representations that Ms. Benefield had made to you? Want me to restate that?
Yes, please.
Yeah, that didn't come out too good. Did your investigation corroborate the facts that Ms. Benefield related to you?
It did, yes. There had been a package received. The package, I know she believed had some weird smell coming from it. And my recollection was that had been investigated, but the package had been delivered to her. I think she said it was close to her birthday around that date. I can't remember exactly. But it did. The facts that I had investigated did lead up. South Carolina, when I reached out to them, had said they had given an injunction for her.
All right. And do you recall contacting the toxicologist with respect to the contents of that package?
I did. She had brought me a toxicology report on that meeting, and I did call the doctor. Now, in all candor, I can't confirm if that's exactly the doctor, but I did speak to someone on the phone who said that Ashley did have weird things in her blood system at the time that did not correlate to someone's normal toxicology. But she couldn't say from where that had come from, but that there were abnormalities in that report.
And you say you have considerable experience with women who have been victims of domestic violence?
Yes.
Is there a certain pattern in your training and experience that you see in these women?
Yes. So a lot of times we'll have a lot of these meetings involve an abuser. We have the abuser who has abused someone. By the time they're coming to us, a lot of time has passed. So we always want to explain to them that normally we see a cycle. You have an abuser, he does something wrong. Then it's, I'm sorry, I'm very, very nice. They come back, and then we end up again in this situation with more abuse.
Kind of like a hamster wheel.
Yes.
Did you form an opinion as to whether or not in your discussions with Miss Benefield that she fit the profile of an abused woman?
I did. When we discussed, she did seem that she had been isolated at that time. She was very scared. The way she had spoken to me did give rise. She had mentioned some minor physical issues that had been occurring, but abuse doesn't always have to be physical. Sometimes it's psychological, mental, emotional. And she was in my office when she was sitting. She did seem to be presenting like that.
Is it a pattern and practice of abusers to employ psychological intimidation?
I mean, normally a lot of the times in the reports I would have, we would have something of threats or some sort of information leading up, text messages, Facebook messages, things of that sort.
And let me ask you this. Are these abused women, despite their fear, often in the company of the abuser?
A lot of times I've seen them return back to their abusers, yes.
And have you experienced abused women when in the company of the abuser acting as if everything is fine?
I wouldn't be able to say I've seen them with their abusers, but a lot of times if we were in court trying to present, I would see them come in to defend the defendant that we had or to withdraw claims and that kind of thing.
I guess the point of my questioning is merely because the woman appears content, is that an indication that she's happy in the company of the abuser?
No.
Why is that?
Just, I mean, I have more facts by the time I've seen the investigations, I've seen interviews, things of that sort in our caseload. They might be presenting, telling the judge something, but clearly we've seen, photos of abuse. They've sat and given us recollections of abuse, that kind of thing.
You left the office before you were able to actually conclude and file a charging document.
That's correct.
And as you sit here today, do you know what the disposition was?
I believe it was decided to not move forward, so it was dismissed.
That's all, Your Honor.
Close.
When you were in the misdemeanor division in Manatee, I think you said 6 months.
Yes.
So what was the time frame then?
I know I had started, I want to say April of 2018. So it would have been 6 months from there because I think I got out to Arcadia around October, November-ish.
Okay. And was the misdemeanor job in Manatee your first job out of law school?
No.
No. Okay. Did you work, where did you work before that?
Before I worked with Eric Reisinger, I actually did criminal defense.
Okay. All right. So when you talked about the the domestic violence training, were you referring to the domestic violence training at the state attorney's office?
Yes.
Okay. And was that the normal domestic violence that everyone is sent to the class?
Yes.
And how long is that class?
I think it's 4 days.
Okay. And is there any other domestic training?
I know the office does some pretty good domestic training. They'll do PowerPoints, luncheons, things of that sort. I think there's some, I don't know if they still do it because now I'm aging myself, some field trips to like the TILA and some of those organizations that work with abused women.
Okay. Thank you. I don't have any other questions.
Thank you.
No, I think that's got it.
All right, man, could you step back onto the hallway, please?
Yes, sir.
What a great witness.
All right. She's out. Proponent, you can start with your, there you go. She's waiting in the ante room. Now we got her in the hallway. Proponent of the evidence, argument.
Yes. So, Your Honor may remember that Detective Gillum made the allegations 2.5 years later, despite the fact that there was no earlier report documenting what he alleged 2.5 years later in any of his 2 or 3 prior supplements, that Miss Benefield acted completely inappropriately, that he did not believe that the South Carolina domestic violence injunction was in effect, because even though the hearing was on November 3rd, the judge hadn't signed the order till the end of the month. And therefore, he countermanded Deputy Weber's request for a capias. This witness impeaches the statement by Detective Gillum because she was the assistant assigned to the case at the time, and she had made a decision that, in fact, she was going to file, but for the fact that she left the office beforehand. She had conducted the investigation, completed it. All she was waiting on was the label of the package, which, interestingly enough, the court may recall, Detective Gillum recovered from Stephanie Murphy, but it apparently didn't make its way to Samara's suite until after she left the office.
All right. And the objecting party?
Judge, I would object. I don't think she can testify as to anything she just testified to. I think most of it is opinion, and she is not an expert. And even if she was an expert, she wasn't listed as an expert. So she cannot give opinions. And any opinion about whether someone, as a prosecutor, whether someone violated the law or not is inappropriate testimony for court. A lot goes into filing decisions. The prosecutor has discretion the same way police officers have discretion. To add any significance to that, I think would be completely improper. And so I would object to anything to do with her decision-making with the state attorney's office. And also, as I said, I think there was some information that was gained after she left that played into that decision. But additionally, I think she would not qualify as an expert of domestic violence, and I think even if she could, a lot of those things would be inadmissible anyway, what she would say.
All right. Mr. Taylor, do you have any final thoughts you want to put on the record? Any final thoughts? Rebuttal?
That's good.
All right, thank you. So one of the very interesting things about this case as we have gone along is there have been some very interesting, and I think I said the other day, unique legal arguments that have been made. Certainly, I would like to think it's in honor of the Olympics starting tonight that you guys have put me through my mental gymnastics for the last couple of months. You know, Another judge that's here in Manatee County, I hear him say this a lot, and I think it rings true. There are some very difficult decisions that we make as judges, emotionally difficult, legally difficult, factually difficult. This is not one of them. This is a very, very clear and easy decision. I'm going to put the part about Ms. Sweet offering any sorts of opinion as an expert kind of to the side, because I resolved this matter well before I consider that she wasn't listed as an expert and the Richardson aspects of that. And what I want to focus on is the purpose of allowing these other incidents of violence or threats is, as we all know, it's one of the carve-outs of obviously case law provides an exception in stand your ground and self-defense cases for battered spouse syndrome. Normally, any peculiarities for a particular defendant, PTSD, low IQ, mental health, are the ones that come to mind quickly, are not relevant and not admissible in a self-defense case because it's a reasonable person standard. So battered spouse syndrome is the carve-out, and the idea by once the defendant has laid the predicate of the overt act, allowing either reputation, and if it's reputation in a relevant community, we've all agreed, well, should agree, the case law says that the defendant doesn't have to know about that. It's just reputation evidence. On the flip side, whenever you want to get into specific acts of violence, threats, intimidation, and I know our net that we've casted here is beyond just prior acts of violence. There's also been issues of threats and intimidation. It's come in, it's in. The case law talks specifically about why that evidence is allowed and why all of that is not hearsay, because it's not offered for the truth. It's offered to show the jury what did the defendant know at the time that the self-defense was used. And unlike the mental ailments I mentioned earlier or other peculiarities of the particular defendant, this is just to show why the defendant would have stayed, and even if there wasn't an imminent violence at the moment, why that person would feel terrified, and all the other battered spouse. I won't go into the whole thing. So the issue is not, did this assistant state attorney believe the defendant? Did this police officer take a report and submit a capias or not issue a capias and send it to the state as a non-arrest? Did this ASA file it or not file it? Did this ASA believe that the defendant was the victim of domestic violence or not? All of those things are completely irrelevant, not to mention prohibited from the witness commenting on ultimate facts or invading the province of the jury. The issue is not the truth or falsity of the violation of injunction or the shooting into the ceiling or any of those issues. That's not the issue. The issue is, was the defendant aware of these prior acts? Example being that the evidence came in regarding domestic violence by Mr. Benefield against his first wife. The way the defendant learned about that was some sort of text message by or between Mr. Benefield and the former Mrs. Benefield. Clearly hearsay. But why does it come in? Because she was aware of it, and it shows some violent tendencies, so she can testify about it, she can talk about it, the jury hears about it to help understand what she knew, and this is in the jury instructions as the attorneys know, what she knew at the moment that this incident was happening. So Ms. Sweet's testimony about whether she believed the defendant or not, whether she was going to file or not, the conversation, that whether she thought that the defendant was genuine and legitimately a victim, the testimony that she had some report and she called someone and there were some sort of abnormalities, unspecified abnormalities in some lab test that she, characteristics of domestic violence victims and so forth is just of no moment. So it's irrelevant. It's commenting on the testimony of and the credibility and veracity of other witnesses. It's commenting on ultimate facts. If you want to talk about the expert portion of it, as the defense said, this is all the same things that Ferris is going to testify to. So in essence, I haven't heard his testimony, but what I understood was everything, I believe it was something along the lines of what she's going to testify to is the same as what Mr. Ferris is, and I only say Mr. because I don't know his professional designation. So Mr. Ferris is going to testify to. Finally, on the issue of 403, Ms. Sweet's testimony, the probative value of that is substantially outweighed by the danger of confusion of the issues and misleading of the jury, because it does not matter whether that particular person believes it was a violation of injunction or not. The point is, the testimony is out. It's been demonstrated that the defendant knew about that. She's alleged it was a violation of injunction. There's a dispute. That'll be a factual issue for the jury to determine. But she's alleged it was a violation, which she took as intimidating. And the smell that caused her headache was some sort of physical ailment that would have been caused by the present that was provided. I understand that's her position. State might have a different argument on all that. But this is not even a difficult question. Ms. Sweet is not admissible as a witness. I am glad you proffered, though, because now it's all on there. But no, she's not going to be allowed to testify to what I heard today. Do you have another witness we can call?
Yes.
All right.
We have an objection to him as well, Judge. We filed.
Oh, now, Mr. Ferris is the expert.
Yes.
And the state wanted to have a...
Judge, I'm sorry. We do have a lay witness that we want to get on. Amy Carlton. She's going to be quick. We need to get her back to work.
Oh, hold on. Amy Carlton. And then I assume, I know that's bad, that Mr. Ferris, tell me, does he have a professional designation? Is he a doctor or?
He's a licensed mental health counselor.
So he's Mr. Ferris.
Former deputy sheriff. His practice and his law enforcement experience has been combined exclusively to domestic violence. He teaches batteries.
I just want to know if he was had he a professional designation that I should use. All right. So Mr. Ferris, looking at the time, I would think that after we finish with Ms. Carlton, the Daubert hearing is very likely going to take us to the end of the day. So I expect that we would probably start with Mr. Ferris on Monday. Mr. Taylor?
Well, Your Honor, actually, we have some case law that I was hoping would obviate the necessity for a Daubert hearing.
All right, well, do you want to handle Ms. Carlton first?
Please.
All right.
Mr. O'Donnell just needed to go to the ladies' room, so.
Oh. All right.
If you want to bring them back in, that's fine. If you
Well,
want.
yeah, we can start working them back up.
Yeah.
I think that'll be good. So let me give you guys 5 minutes. If you need to step out, Mr. Taylor, Ms. Benefield, if you need to step out and use the facilities, that'll be fine as well. We're going to start working on getting the jury up. It usually takes about 5-10 minutes.
Yeah. Okay. Thanks, Judge.
Oh, what a shame. So we don't get to see her testify. I thought that he was going to do that. So they've got this other guy who, surprise, surprise, the prosecution are going to try and fight to not allow him to testify now as well. Which the judge better let him in. because if he's a DV expert, as in, he should be allowed in. I could sort of understand why she wasn't allowed in. Not really, but I can sort of understand why. But for an actual expert, I mean, you can see now the prosecution doing everything they can to not allow experts in, because that's the only way they think that they can win the case. So, well, yeah, no, she's very. All jokes aside, she's very obviously very attractive lady, but she was impressive. Her CV was very impressive. She sounded very experienced for. I wouldn't know how old she was. She's probably in the 30 odds with that experience. Over 30 anyway. So, but doesn't look like it. I was leaning hard towards guilty, but I have changed my mind after her testimony. There you go, Carol. This is why we, don't make our minds up until everything's done, isn't it? So I know you based a lot of your decision on the standing ground trial, but it's a free will to change your mind, which is great. Go peep her LinkedIn. Selby B, how are you, my darling? Oh, the only way, I just hope the defense don't take this too far now. I would actually probably just put this expert on and just leave it. I don't think they need to do anything else, but I mean, obviously, we're gonna have to see what they do. Stormcat, that's a very fair point. Do you know what I mean? I have no idea how the jury would rule. Who thought the jury would think Karen Reid was guilty? 9-3. I know. Yeah. I try to always keep an open mind, even if I think I know. There we go, Carol. Does your husband say the same? Evie said, Dylan agreed. Judge has got to let him in. Bummer that she didn't get it. He was a bummer, because that's a good story. But to be fair, that's what it is a story, so. Carl Draper, I was a soft guilty, but now fully believe her testimony on the stand made my mind up. Do you know what? Even taking her testimony away from it, I just what I'm sticking with not guilty is, I don't think the prosecution did their job. Simple as that. I just don't think they did it. So her testimony just added to that, for me, so. Thank you, Sammy B. Never imagined, no. It's what they pick up on, isn't it? The lawyer, Peter Tragos actually tweeted out saying, "Whoa, this is a bold move by the prosecution, getting her to step up and do a demonstration." And he was like, "They better have read that jury correctly to do this, because that is not the thing to do." So I'm glad he said that as well. But again, we're not on the courthouse; we don't see what they see. So that's the hoodie I got. The one next to you, red. Oh, also the corner one. They're nice, aren't they? I got El Chatty ones as well. They're nice hoodies. Not that I wear them because it's the weather. It's too nice at the minute. But yeah, I do wear the t-shirts. The t-shirts unfortunately don't really fit me that well. They're not in my size, unfortunately, but still okay though. Yeah, it's too hot, isn't it, Bev? Too hot. Oh. Excuse me. Hey, it's the weekend. Let's go. Freaking weekend, people. Let's get this party started. Let's get this party started. Oh, happy days. Crime junkie, happy days. If you can, that'd be great because I'll message you back now. Oh, Messenger. There you go, Crown Junkie. Message you back. How good am I messaging straight back? Right. Friday. That was a dumb move on the prosecution part. They are too defensive and trying too hard to keep stuff. Unless they see something we don't. I mean, I think it was a bad move, but they may see something we don't. I don't know. Yeah, too hot. Defense wanted Ashley's testimony to percolate in the minds of the jurors over the weekend. Ugh. Also, they wanted it now so that there's a story as well, Rule. Because now, obviously, the defense went after her about like, oh, you were fine in this situation, you were fine in that situation. They're now hopefully going to get an expert on to explain. Well, you know, you heard it from that lady who was on the stand. Like, people who suffer from TV will just comply. They're too scared to go against them. So yeah, they would be happy to be in a room with their abuser because the abuser himself won't have to hit them that often because they know what's coming. The victim knows what's coming. Friday. Any update on Proctor turning into the FBI? No, I've not heard anything since it was announced. But I don't like you know, it's all hearsay till we hear it properly announced.
Okay, bring him in.
Fuck. Here we go.
Oh, does anybody need the screen?
No. Oh, and can we get the site for the case? Mr. Taylor, can we get the site for the case that you sent that?
I can do better than that.
Perfect, thank you.
You can't. I think I know exactly which one you're bringing me. To bring me though. All right, y'all can have a seat. I see the jackets and the sweaters have gone on. Yeah, you would think in the afternoon it would get warmer, but I told you, even with the southern exposure, somehow it just gets cooler and cooler and cooler. So, all right, while you were out, did anybody discuss the case amongst yourselves, talk about anything about the case, talk about anybody outside of the jury about the case, or do any research on people, places, things, or legal topics you've heard anything about? All right, everybody says no. Mr. Taylor, call your next witness.
Amy Call.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
Hello, ma'am. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, or right if you need it. And just speak in a loud, clear voice and we'll hear everything. Can I just move you just a little bit forward?
Okay.
That's perfect. Thank you. Yes, sir, Mr. Taylor.
Good afternoon. Would you tell
Good
us your
afternoon.
full name and state your last name, please? Spell your last name.
spell my last name. Carlton.
And your first name?
Okay.
Tell
I'm
us.
sorry.
What is your first name?
Amy with a Y.
Okay, Amy, or Miss Carlton. Are you presently employed?
I'm presently employed, yes.
Yeah, where?
Where?
Where, for who?
I'm at one of the hotels in the area.
Okay, and what capacity do you serve in at the hotel?
I'm one of the managers.
How long you been doing that?
What was that?
How long you been doing that?
I've been with the ownership for 4 years now, going on 5.
Are you married?
Yes.
What's your husband's name?
Herbert.
Miss Carlton, were you and your husband Herbert living in Bradenton, Manatee County on September 30th, 2020?
Yes.
September 27th, 2020.
Yes, we were.
Do you recall that afternoon if you were outside with your husband?
Yes, we were.
Do you recall the address you lived at back then?
It was on Newport News Street or Drive. We've been renting, so to be honest with you, I don't recall the exact street, the number of the street, but it was Newport News.
Do you recall, Miss Carlton, whether or not, what was the reason why you and your husband were out that afternoon?
I have a mini golden doodle, and we were taking a walk.
Did anything unusual occur while you were out with your husband and the dog?
Reason I'm here, you know it. I mean,
would you share it with us? What happened?
We were taking a walk, and Newport News is a couple streets over from the incident area. And it was probably 3 houses down where we were. And at the time, my dog was probably just over 1. So I don't know. I'm a big dog lover, and she's my life outside of work with my husband. He and I both heard what I don't know. I didn't know what it to be, and he kind of grabbed my arm, and I kind of got startled because it did sound like gunshots. I don't know, at the time we didn't know what it was, and but we heard one right after the other, and me, because of where I work, I'm trained like the attack or panic mode. I am thinking of myself. Sorry to be selfish, and my dog and my husband. And he's looking ahead too. And I just remember being a little bit terrified myself and thinking of myself, my family. And so I remember looking up and telling him, well, let's go. Let's turn around. Let's go back behind the house, because at the time we weren't sure what it was. And also being trained, you don't know what is to come next. First of all, you don't know what it is. So as I'm telling my husband, I told him, call 911. As I'm telling him that, I'm sorry, I'm backing back behind the house because you don't know what's coming next.
All right, let me ask you a couple of specific questions if I can.
Yes.
You say you heard some gunshots.
It sounded like gunshots.
All right. Now, after you heard the gunshots, did you observe anybody exit a house?
Quickly, as we were trying to make sure of our safety, we saw someone leave the house, a lady leave the house. It was, I mean, I don't know exactly like timing wise, because it's like I said, my mind was going through a lot of things.
Let me just keep you on the questions, okay? I'll help you. I'll lead you through it. You hear the gunshots. The next thing you see is what?
A lady came from the house, and
describe.
I remember screaming, and
That's just the vivid recollection and memory that I have. Just the screaming, and I came from the house running to the neighbor's house. I don't remember too much other than the screaming and pounding on the neighbor's front door.
Is it a safe bet for us to say that this lady that you saw exit the house screaming was hysterical?
Yes, yes.
I want you to tell us, Miss Carlton, after the gunshots, approximately how long it took for that woman to come running out of the house.
Oh. So I'm not sure I recall. It was within seconds, though. It was, I don't know. It just, I mean, I didn't even have time, like I said, to pursue any hiding places. It was so quickly.
Do you remember speaking to the police about the incident?
We had an interview, yeah. It was probably 30 seconds, a minute. I don't know, 30 seconds.
Okay. So you hear the shots, and within 30 seconds, a screaming, hysterical woman comes running out of the house and goes to the neighbor's house.
Yes.
Did you hear banging on the door at the neighbor's house?
I don't recall if I remember stating that or not, but I remember the hysteria of the screaming.
Okay. That's all I have, Your Honor.
Can the witness be released?
Yes.
Yes.
Thank you, Ms. Carl.
Thank you.
Ma'am, you've been released from your subpoena, so you're free to go. Thank you.
All right, go ahead and approach.
So I think he's sending the jury home now, and we got a Dalbert hearing, or they got case law hearing in front about whether the expert is allowed to testify or not. So they're going, jury going, but you know, yeah. So I thought I didn't know to start off with where the hell he was going with this witness, but then yeah, it was because I'm sure someone testified, or the state alluded to the fact that she didn't go out straight away. She stood there for a while before she went to phone the 911. Yeah, I mean she's very. I just thought that she's hard of hearing. I think fucking pervert. Look, not him. One behind. Pervert Tommy. Look him chatting up to ladies. Hey, pervert. Oh, he fucking came back, bastard. Missed him. Yeah, we got there in the end, but for a while I was just like, bloody hell, where's she going? But we don't know. Maybe the husband has since died, or maybe he's even more of a hard of hearing. So I don't know. I think that he wanted her because of her experience, as well, working in hotels. Do you know what I mean? Why am I doing this? I don't know. About safety aspects and stuff like that. I don't know why I'm doing this with my hand. So she knows what to do in a hostage situation, or if guns are fired and stuff like that. She did the same as what we would have done. I think, get the fuck out of there. That's what we all would have done, probably. Oh, thank you, everybody. Thank you, Katie. Tommy's such a scumbag. He's probably thinking, oh, if she gets not guilty, I'm gonna hit on it. But she's got, I believe she's got a new boyfriend. Man in the bun. Man in the bun. Man in the bun. Oh, 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 oh. She's got a new boyfriend. Oh, her new boyfriend's the man. He's the man in the burn, in the back row. In the back row. Right, what is Erin? What's the song? Huckster. Oh, hang on. Let me find it. Let me find it. Da, 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 da. Um, hang on. I know what it is. He's just a city boy, born and raised in South Detroit. He took the midnight train. Is it? Is that one? She's just a small town girl, living in a lonely world. She took the midnight train going anywhere. Boom, 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 boom. He's just a city boy, born and raised in South Detroit. He took the midnight train going anywhere. Is that the one? Where's Mighty Meat? Where's Mighty Meat? Mighty Meat on the train. Mighty Meat loves the train. Mighty Meat loves the train and the bum bum boom boom. That's Journey. That is Journey. Oh, thank you, Jessica. Thank you, Jessica, darling. We need to legit karaoke that thing. I'd love it. Yeah. Do 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 do. Strangers waiting, walking down the boulevard, their shadows searching in the night street light. I don't know. But that's not bad. That's not bad, Mighty, is it? Mighty Meat loves Sleepy Train. Oh.
Thanks to the jury. So the attorneys and I need to talk about what's going to happen next week. We got to do some legal matters that are outside the province of the jury. So at this point, I'm going to let you go for the weekend. It's about 10 till 4, so you're free to go at this point. Remember the rules for the weekend. Please do not discuss the case amongst yourselves. Don't talk about it with anybody else outside of the jury. And certainly don't do any research on the people, places, things, or legal topics you've heard anything about. And that includes being very mindful of watching out for any media that may be on anywhere you go and wherever you might be to avoid all of that. Okay? Listen, do you still have your parking passes?
Yes.
Everybody's got that. If you've lost your sticker, is there somebody downstairs in the jury room? Okay. Oh, you've got a bunch of them?
Yes. He got us a bunch.
It's like pads and everything. We got them everywhere. Okay, great. So make sure you keep that parking pass. If something happens and you lose it, you're gonna have to come in Monday, see the jury coordinator to get another one, and then go park, because they will give you a ticket or tow you, one or the other. All right. So thank you very much. It's been a great week. Yes, ma'am.
What time do you want us here Monday?
I always forget that part. We're going to start at 9 o'clock on Monday. So if you can be downstairs, 8:30, 8:45 is just fine. Listen, I will say this though. Remember on this past Monday how there was a whole bunch of people? That's how it's going to be this coming Monday, because we're going to be picking another round. Other judges are going to be picking other rounds of juries. So you don't have to necessarily stick together, but you're probably going to want to be off a little bit. Unless you want to tell the other folks there how great jury duty is. That way they won't try and get out of it. All right. Great question. Sorry I forgot about that. Thank you very much. You are free to go for the weekend.
Thank you, sir.
Thank you. All right, you all can have a seat. I will tell you, I don't think I need to hear a whole lot more about Mr. Ferris. I think we've talked about it quite a bit. I'm ready for the hearing. I will say this: it is a hearing, so if you want to make an opening, don't feel like you can't. You're absolutely free to make an opening if you want, Mr. Taylor. So please don't let me dissuade you. If you want to make an opening, make an opening.
Not necessarily.
State?
No, Judge.
Thank you.
I think we've talked about it.
You saw Mr. Brown's testimony that's going to be the truth, the whole truth, and nothing but the truth.
I do.
Hello, sir. My name is Judge White. I'm presiding over the case. We're going to have a Daubert hearing. I'm sure you're familiar with that.
Yes, sir.
So just put yourself about 12 to 15 inches from that microphone. Make yourself comfortable in that chair.
Okay.
And we'll get started with the hearing.
All right.
Good afternoon.
Good afternoon.
Tell us your full name, please, and spell your last name.
Bruce Eric Ferris. The last name's Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor. I do individual therapy, and also I do consulting on domestic violence and expert witness testimony.
Let's discuss your education. Would you inform us, please?
Sure. I have a Bachelor of Science degree in civil engineering. I also graduated the local police academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
Do you have any specialized education or training in a specific field?
I do. If you look at my curriculum vitae, I think there's over 100 items listed where either classes or seminars or teachings and certificate training that I've attended.
And included in that, would domestic violence be a major part of it?
That was the definitely predominant theme of whether it be a specific class or a conference, et cetera, on domestic violence and intimate partner violence. And if you'd like, I can explain the difference.
Please.
Domestic violence has to do with what we might think of people have a child in common or family members. And that doesn't necessarily mean an intimate relationship. It could be two relatives living in the house together. Intimate partner means there's an intimate relationship, a spouse, a boyfriend, girlfriend. So there's a little difference there.
Try to make sure you voice in the microphone because it tails off.
Thank you.
Mr. Ferris, have you taught any courses or presentations in a specialized field?
I have.
Please enlighten us.
If you look at my CV, I've given, I think, over 40 some presentations and teachings. For 8 years, I taught batterers intervention program class to offenders, uniquely that. And for anyone that doesn't know, batterers intervention is program is for offenders. It's usually court ordered, part of probation or part of a sentence or part of an injunction or a restraining order. It's a 6-month psychoeducational class. I've been trained for that and teach that. I also I used to teach Gardner Lightham volunteers about domestic violence and effects on children. I taught the 8th Circuit staff at the state attorney's office about domestic violence and impact to women and children, and batterers intervention, how to interview people. From 2008 to 2020, I taught at the University of Florida Law Clinic on intimate partner violence to law students about the same type of subject, domestic violence and intimate partner violence and effects, and also enforcement of the law. I also trained police officers about domestic violence enforcement. Currently, since 2009, I've been teaching officers how to de-escalate confrontations as part of the crisis intervention training team. I teach the de-escalation part of that. There's a lot more I could talk about, but that's the nature, and you could see in my CV.
All right, let's talk about your work experience.
Okay, so I have an affiliation with Village Counseling Center, doing therapy, DCF cases, and domestic violence related cases. I used to also work with Creative Counseling in Gainesville, doing teaching batterers intervention program classes and doing individual therapy. I also have my own practice now, and I do individual counseling. Recently, I just looked up, since 2014, I've treated almost 1,000 individual clients or patients as an individual therapist. Work experience we're still talking about.
Yes, sir.
Okay, of course, I mentioned the doing consulting for attorneys on domestic violence and being an expert witness. You're gonna want to know my current work or my past work?
Well, let's stay in the past. How about any experience with the Gainesville, Florida Police Department?
Yes. I went through the police academy in 1993. I was sworn in 1994. I retired from there in 2013. The last 10 years of my career there, I was the lead detective in the domestic violence unit, part of the Investigations Bureau, uniquely just looking at the domestic violence cases, enforcing the law, training officers, doing some public outreach, and being on various task forces.
Can you give us an idea over the course of that time, approximately how many cases you would have handled?
Yeah, I was a lead detective on close to at least 500 cases I looked up were resulting in arrest or charges being filed.
And what kind of professional credentials do you hold?
I'm a licensed mental health counselor in the state of Florida. I have certification to teach batterers intervention program classes through the state. I also received certificates to do threat assessments, domestic violence threat assessments through Jackie Campbell at Johns Hopkins University. Also trained in doing counseling and work with adoptions through Rutgers University.
Have you been the recipient of various awards and recognitions?
Yes, I have. I was chosen by the Alachua Board of Commissioners to be recommended to Governor DeSantis to be on the Alachua County Child Fund, tax fund, I guess they call it, trust fund, excuse me. I've also received various awards as the for my domestic violence work through the local shelter. I received a statewide award from Attorney General Pam Bondi and Governor Scott at the time for my work. In 2010, I was awarded and recognized for my work with victims of crimes in the state. There's several other ones. Without looking at my CV, I don't recall them all.
Sure.
I received some recognition of the contributions for the work I did with that CIT team. The University of Florida also gave me recognition for training that I'd done with their officers. I was Big Brother of the Year, and for my work with my little brother for about 10 years, I worked with a little kid as my friend. And I was also the Law Enforcement Officer of the Year, as granted by the Domestic Violence Abuse Network in Gainesville.
Are you a member, Mr. Ferris, of any specialty boards, committees, or professional organizations?
Sure. Again, relying a little bit on my CV because of the nature of the question.
That's fine.
So in 2022 to 2024, I was a member of the Rape Crisis Center Advisory Council. I was a member of the American Mental Health Counselors Association, a retired member of the Fraternal Order of Police. I was a member of the 8th Judicial Circuit, Florida Family Law Advisory Group, member of the Gainesville Domestic Violence Task Force. I was a member of the 8th Judicial Circuit of Florida Domestic Violence Fatality Review Team. I was a board member of the Gainesville Commission on the Status of Women, a member of the Alachua County High Risk Domestic Violence Team. I got some recognition for my work as a volunteer with University of Florida College of Medicine. I was doing mobile outreach part-time as a volunteer. I was a member of the University of Florida Male Leadership Committee, again, dealing with domestic violence. I was also on the planning committee for the sexual battery conference in Gainesville for many years. I was a member of the Gainesville Mental Health Consortium, the United Way Community-Wide Strategic Planning Safety Committee. I was part of the working group for leader for domestic violence coordinated community response for local law enforcement and best practices procedure. And I was a member of the statewide domestic violence needs assessment group organized by the Office of State Courts Administrator, Office of Court Improvements.
Have you been recognized as an expert by courts in the state of Florida? An expert in domestic violence?
Yes. Just as a footnote, I've been recognized as an expert in domestic violence in Batterers Intervention Program class, effects of domestic violence on children, and generalized mental health work. I've been involved with about 60 cases, consulting or testifying. Not all of those did I testify. I did testify in over 50 of those cases.
Both civil and criminal?
Yes, both civil and criminal. Majority were in civil. The types of working both for the defense and the prosecutor of the state attorney's office, but the majority were civil.
All right. Would you be kind enough to educate us a little bit? What is domestic violence?
Okay. Domestic violence, excuse me? Domestic violence, according to Florida state criminal law, is acts of like battery and assault, ag battery, ag assault, false imprisonment, sexual battery, all these different person crimes from one family or household member to another family or household member. So that now the definition is what's a family or household member, and that's people that are married, living together, maybe had a child together, but have never lived together. People living together as a family in the house. It doesn't include, let's say, cousins that never lived together. So it's unique in that way.
And is there another definition of domestic violence?
Yes, and in my practice and in my training, this is a pretty accepted concept that domestic violence is actually a pattern of power and control. And the key word here is pattern, that's repetitive. And the criminal definitions, the physical things, those are used by perpetrators or abusers to control their victims. But along with that also is used control tactics. We often think about emotional abuse or those sorts of things, and they're defined in the Duluth Power and Control Wheel.
Would you explain to us what the Duluth Power and Control Wheel is.
So the Duluth Power and Control Wheel was developed up in Duluth, Minnesota by a group of researchers who deal with domestic violence. And what they did is they looked specifically at domestic violence cases that have been criminal cases, that victims who came through shelters, DV shelters, and they were looking for what were the tendencies or the tactics used by abusers against their victims. And they developed this power and control wheel. It's used around the country. It's the Duluth Power and Control Wheel is the basis for the Batterers Intervention Program class I mentioned. DCF, Department of Children and Families, has accepted that as a reality, a fact, and they that was the criteria or the curriculum for the BIP class used statewide and actually used around the country and internationally. So there's these 8 inner items, and on the outside of the depiction, I don't know if.
All right, yeah, let's see if, Judge, with the court's permission, we put the screen down.
Yeah, probably a little bit. That's perfect. Yeah, thank you.
Judge, may I ask you a question? Could I stand over here?
Sure.
And rather than try to do it for you.
Reposition as you need. It's just us.
Okay, thank you. Just a little easier to see this way for me.
Absolutely.
Thank you, Judge.
Oh, you know what though? The only thing is you can't be so far that the court reporter can't hear you, and she's listening to these microphones.
Okay.
So why don't you turn that?
Okay.
And then if you just position so you're facing there.
Okay. Can you hear me okay?
Okay, there we
Can
go.
you hear me now? Yes. So change that. So first. Okay. Okay. So you can see that.
Yeah, I was going to say,
Sure. Thank you, Judge. Thanks for reminding me. So this is the Duluth, as I said, if you look here, Domestic Abuse Intervention Project. And this was established some, I don't know, maybe 30 some years ago, 30, 40 years ago. And this is the standard used around the country and used for the Batterers Intervention Program class and a lot of counseling I do. And this is part of the counseling along with cognitive behavioral therapy is one of the therapies I've been trained in graduate school and my work. So on the outside here of domestic violence is physical violence and sexual violence. And that's covered in the state statutes, the criminal law statutes. Then there's these 8 items that are part of the power and control. And remember, I said it's a pattern of power and control. So that means it's repetitive, a way to get your, it's a way for the abuser to get their victim to comply, to get into a compliance mode. I'll talk about that in a moment. So the first item is using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons. Those are I run into this all the time in terms of using intimidation. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy. It's very common. Playing mind games, humiliating her, making her feel guilty, using isolation, controlling what she does, where she goes, who she sees, oftentimes spying on their victims, checking their phones, tracking them, etc. Minimizing, denying, and blaming. I find this in almost all the cases I work. They make light of the abuse, say it didn't happen. They shift responsibility. It didn't happen, it wasn't that bad. It was your fault. So minimizing, denying, blaming. Using children, sometimes put their victim, the mom, in fear of what he'll do to the child, or that he'll report her, etc., that she might lose the child. Male privilege, this has to do with the role that he makes the decisions in the family or in the relationship, and gives her a specific role. Economic abuse, and this would maybe be preventing her from having a job or money, or she should have an allowance, etc. And then the last item is using coercion and threats, making, or I'm just having problems reading the photos here a little bit, making and carrying out threats against her, threatening her, using coercion and threats. So I'm going to sit here, that can stay up, and I'm going to make a few comments about it. So the main issue here that, as we understand the power and control wheel, is these are techniques that the abuser uses to control their victim. And like we say, it's a pattern. So that means it's repetitive. And so what's the purpose of that? It's to get them to comply. And so the victim ends up trying to avoid the perceived danger that they'll experience if the abuser perceives that they're opposing them. That's particularly true for mothers that are, not only are they trying to protect themselves, but they're protecting their children. And I found that there's victims of domestic violence tend to get into what I call equilibrium sort of stasis experience. In other words, they avoid the perceived threat, so they the proverbial, the old phrase of walking on eggshells. So they end up being in this compliance, kind of like they don't want to poke the bear, so to speak. So they find this narrow way of coping by going along with the perpetrator and don't want to make him angry at them, because that's when the violence occurs, or the threats, or the emotional, the hardship. And that's exactly what the perpetrator, the abuser, wants to happen. He wants to keep her in line, so usually to manipulate, to get her to do what he wants to do, that they feel a sense of ownership, and they use these techniques to control. They also the victim wants to appear to be going along. They don't want to anger him. They'll actively hide that abuse from family and society, because if it gets out, he's going to be mad. I could speak certainly a lot more about that.
Are there, Mr. Ferris, common characteristics that abusers share?
Yes, they could be anyone from any socioeconomic group. I've been involved as a therapist and as a detective enforcing the law with all types of society and sexual orientation, from wealthy, well-known NASA scientists, doctors, as a perpetrator to the homeless person and everyone in between. And in Gainesville, where I worked, we have a great population from all around the world there. And I didn't find a difference other than sometimes attitude, but every socioeconomic group, it's very, and also they tend to be males, but females also. Just yesterday, I took on a new client, spoke to him. His wife's in jail. He has 4 children with her, and he's a victim. So, he's a victim. So there's female abusers and male abusers. Males are predominant. I know when I was working, I ran some statistics on cases, and I found it was about over 2/3 of my cases were males, and less than 1/3 were females. Some of those, and that kind of reflected also when people would, kind of want to debate that issue about men or women. One thing that always struck me is when you look at fatalities, the statistics are about the same. There's usually the murderers are mostly men by about 2/3 over the women. So the actual victimization cases and then the actual fatality cases, kind of the statistics I found ran together.
And what do they have in common?
Usually that they want to control their partners. There's kind of an ownership attitude. They use the power and control techniques I described to do that. I also find that they're in common, they're missing true empathy. I've kind of nicknamed it to myself as they're missing an empathy gene. And empathy has to do with the ability to feel someone else's feelings. And I find many of the perpetrators that I've counseled and also worked with in the BIP class, and certainly in my police career, they tend to be very selfish, a lot of narcissistic sort of ideas. I kind of image it as many of them, not 100%, but a majority. It's kind of like their point of view is I'm here and everyone and everything around me relates to me. I'm the center of the universe, as opposed to a healthy relationship. There's an equality. I'm being thoughtful and considerate of my wife as she is for me, and there's some balance. They don't necessarily adhere to that. They disguise how they treat their victims. Usually they don't want to let other people know about that, much like the isolation element. They want to keep it. And there's reasons for that. And some of it has to do, they don't want to go to jail if it gets out. And then they don't want, I found this a lot, that perpetrators don't want their victims to get the idea that they're not a good deal, that there's something they're doing that's wrong. So they isolate them from society as such. They'll put on a real front. I have numerous cases like this, how they disguise, how they treat their victims. There can be, the victims, the perpetrators, can oftentimes be very appealing, and they're very good at convincing people of things. I found a certain finesse amongst those thousands of BIP clients I had, that there were some very good talkers. I'll just leave it like that. But the emotional and physical abuse is certainly what we think of. I've certainly worked a lot of cases where there was broken bones and bruises, etc., and emotional abuse and isolation and coercion threats, etc. But many of the cases I see, there isn't acute violence. It's emotional abuse. It's these techniques. The question is, can the abuser convince the victim that and put them in fear so they adhere to what they say? If they can create the fear, like this one lady told me, she was in fear of him so much, they would be in a public place and they're separated and they're across the room. And if he saw her talking to a male, he looked at her and she knew right away, end the conversation, move on. There was a fear and there was no violence in that relationship, but she was scared of him. Also, as we know, as Judge knows, and Mr. Teller, the ASA knows, battery. In the state of Florida, there's assault and there's battery. Battery is the unwanted touching, that's the hitting, the punching, etc. But assault is also a crime. That's being in proximity to someone, showing a threat. I'm bowing up, have my fists up, and the victim has a perception that the violence is going to occur. That's a crime. Though there's no marks, there's no scar, there's no hitting, but there's fear. And so sometimes there's assaults that are taking place that aren't reported. And if on top of that, if they can create that fear to go along, that's a common technique that I see happening. It's all about keeping control, their victim. And one real common thing that I've seen is obsessive jealousy. And when I worked with batterers, I was surprised, and I came to learn very quickly that they oftentimes equate jealousy with love. And we all know jealousy can be very detrimental to the object of the jealousy, and also to the person having the jealousy, being obsessed and worried, etc. Love, we all know, is something else, completely different, very kind, considerate, and very empathetic, very different, but they didn't understand that dynamic.
Let me ask you, Mr. Ferris, do they exhibit, with respect to these characteristics in common, what is their behavior relative to animals, pets in particular? Domestic pets.
Yeah, I understand.
Cats.
So cats, dogs, etc. So there's above average abuse of pets by domestic violence abusers. So I have two explanations for that. One is what I talked about, their missing empathy, that they don't feel for a dog or a cat like I might feel. I'm very empathetic. I am in love with Rosie, my poodle. So is my wife, so that means a lot to me. But to an abuser who doesn't have empathy, it's not a big deal for them. They see it as an object. That's one thing. The more important item, especially in terms of power and control, has to do with that to get back to the controlling of their victim. If that victim is attached to that pet and I abuse that pet, now I'm putting you in fear for what I'm doing because I'm hurting your animal. So I'll attack that pet as a way to control you. You better not, oppose me again, or you better not leave, or you better not go out with your girlfriends when I say you shouldn't, or I'm going to hurt your pet. I'm going to kill your pet even. So it becomes part of the continuum of power and control. And the sad part is I've also found that many perpetrators have that same mentality they use against their females, children, in the sense that the women are highly protective of the children. And so he's using the child as a way to gain control over the female.
And what about the abused, Mr. Ferris? Do they have common characteristics as well?
Yes, the majority are female, though, like I say, I treat male victims of domestic violence also. I'm still kind of surprised at times when I meet a new victim for the first time. And remember, for 13 years, I've been getting clients from our local DV shelter as a consultant and a therapist working. So I get kind of a constant feed of them. And then I also have my other sources and attorneys, and just my people know who I am. So they come to me if they're victims. But I'm always amazed at how many don't truly know what domestic violence is. And even I've had I've had clients who don't think they're a victim of domestic violence. They'll know there's a marriage problem, but they haven't been I'm refraining from being too graphic because I've seen it all in terms of broken bones and types of violence in families. So they haven't been violently attacked and hit with the 2x4 or something. But I go over this, the power and control wheel, and they say, holy cow, this is my life. This is what's been going on with me. I remember one crime scene I was at, and the woman had been a victim of domestic violence, and she wouldn't talk to us. And I had a moment to speak to her, and I showed her the power control wheel and had a moment. There's a victim advocate there too. And we went over it, and all of a sudden it was like an aha moment. And she goes, darn. And I think it was a strangulation case. And she realized, and I've had some specialty training and some certification about being an expert in strangulation with the state, another subject. But she realized that she came within 4 minutes of dying for lack of oxygen to her brain. And once she realized the power and control wheel and how dangerous it was, she opened up and shared information, and that suspect who had left was eventually found. Also, statistics show that domestic violence victims will leave, on the average, about 8 times they'll leave their perpetrator before they finally leave. It often happens. And there's also socioeconomic and ethnic groups that have unique attitudes to domestic violence. This idea of protecting a child for the mother as a characteristic is very, very significant. I guess I'll take a short moment. There was a particular case that comes to mind. This mother was very abused by her husband, and he made her stay.
I'm going to object. We've just gotten into a narrative. I think he's established this fact.
Sustained to the narrative.
Okay.
Okay, so you want me to skip the story? Sure.
All right. Describe what coercive control in a relationship means.
Coercive control are acts of assault, threats, humiliation, trying to create harm, punishment to frighten the victim, much in the manner that we're talking about a pattern of power and control. By creating fear, it's all working towards controlling the victim. Of course, like I say, the power and control wheel is the tactics, along with physical violence and sexual violence. And then we get into that appeasement or compliance that I've talked about. They want to avoid the pain of the conflict. And pain can be emotional pain. I've had women tell me, I rather get slapped upside the head, excuse me for the phrase, but then be told I'm ugly or fat, or my self-esteem totally crumbled. And so don't underestimate how important emotional control is in that sense.
Do these offenders always behave violently, or does abusive behavior happen in cycles?
No, as I've explained, it's not always violence. It's perceived violence in terms of the threats are enough to create fear in a victim that because of some assaults or, like in using intimidation, making her afraid by looks, actions, gestures, smashing things, destroying property, displaying weapons. These are all acts of intimidation that affects them and can create a great fear, and because of the narrative they project, the reality that they're living as the victim, and they get into this compliance mode, and it's can be very dangerous. There is, in terms of cycles in the industry, I'll call it, we recognize there can be kind of this rain, sunshine sort of a model, that there's acute abuse, and that's kind of symbolic of it raining. and then the sun comes out and there's like a honeymoon phase with couples, and all the sun, everything's nice, there's no violence or no emotional abuse, and then all that rain with the hot sun, clouds form again, and then the clouds are too heavy to carry the rain, and then it rains again. So there's some relationships, not all, but there's this cycle of violence or emotional abuse, and then a honeymoon. There's also a cycle, a generational cycle that I'm aware of, that you grow up in a family where roles are very defined. The male is the head of the household. The wife doesn't, oppose him. So sometimes that cycle goes, I see it in my clients, from generation to generation until it can get someone breaks free from that. And maybe that male realizes that's not the best role to have. And a female realizes, I don't deserve this, and they move on. So that's another cycle.
Does the victim, Mr. Ferris, always appear to be afraid or act like they are afraid of the offender?
Definitely not. This gets back to what I've already been talking about. They're hiding that fear from friends, families, and for good reason, in the sense of the consequences of laying it out. And they may not understand all what's going on with domestic violence, but sometimes I've had victims say that they deserved it, that they caused the violence, that they didn't keep the house clean enough. They've got almost a brainwashing going on about what's expected of them as a woman, and they found this, I'll call it a dissociation from the facts. Mental health term, kind of an avoidance that allows them to comply because of their fear. And so it becomes, no, they don't always appear to be afraid.
So let me ask you this. How common is it for the victims to smile and act happy?
I'm going to object. I think we've gotten far afield from what needs to be established on her daughter. As far as domestic violence, I'll stipulate he has this knowledge as to domestic violence at this point, but I think we've gotten far afield from what needs to be established.
Judge, I might recall for the court that they played the video of them all in the restaurant.
I'm not sustaining. I mean, this is your proffer, so
yeah.
Thank you. You tell me what you want me to know about your expert, and I'll decide what he can say and not.
Thank you. Would you elaborate on how common it is for the victim to smile and act happy?
Very common. And it speaks to what I've already been discussing, that they try to hide the abuse from others sometimes for personal reasons. They don't want him to get in trouble. I've had mothers that are financially dependent, and they don't want him to go to jail or prison, because how will they take care of their kids? So they sacrifice themselves. They are afraid of, what society is going to say, or they're afraid of the abuser. So especially the afraid of the abuser is a really big part, and that they stay in line. And again, it speaks to this idea of compliance, or equilibrium, as I call it, finding the lowest resistance to survive. And so they get into survival mode, and that walking on eggshells. And as a therapist, when victims come to me, we've got to kind of untangle this stress and trauma and come to terms with that, because they've gotten kind of in this lifestyle of compliance and all the hurt that comes with that, and how their self-esteem's been damaged. I could go on and on with that subject.
All right. So tell us a bit, if you would, Mr. Ferris, the role that appeasement plays in domestic violence.
It plays a huge role. We could say appeasement. We could call it compliance. We could call it walking on eggshells. We could call it don't poke the bear.
Go along, get along.
Go along, get along. It's all about avoiding pain, and that's the very technique, the fear. I'll use fear as equivalent to pain. That is a way to control. Hence, why this is called the power and control wheel. These are techniques, along with physical violence, that are used to control their victim and get them. And there's an ownership, I've already mentioned, a certain ownership, the jealousy, etc. And also I found some of my abusers become obsessed with their partner, that ownership quality at all costs, and they're just highly obsessed, and it can get very dangerous. Actually, I've worked cases where there's been, suicide, homicide. That if I can't have you, nobody can have you. And if a victim realizes that their perpetrator's capable of hurting them, they're going to go along, or they're going to, get on a jet and fly somewhere real far away.
All right, tell us, if you would, what the impact of a child has on these dynamics.
So the impact to the child, or having a child in the scenario?
Having a child in the mix.
A huge impact. I found women who, certainly want to protect themselves and do this compliance. But when there's a child involved, and if they have a strong maternal instinct, they're going to sacrifice themselves to stay in a relationship. I've worked many cases, to my surprise, where there was no reporting of the violence or domestic abuse occurring. And so the woman, the mother, wouldn't seek a divorce, because they knew, typically in our state, if there's no extreme reason, criminal history, drug history, violence, etc., it's going to be a 50-50 custody. So I've had women who have stayed in the relationship, taking the abuse, because she's so concerned that she wouldn't want her child to be alone with that perpetrator. She sees him as a brute or a bad role model, etc.
And might that type of a scenario play out with the woman acting happy in an effort to go along and be in the company of the abuser to protect her child?
Without a doubt, that's the whole scenario. And and there are women that are better at it and more sophisticated at it than others. I'm just finished working a case where her family, as I interviewed, I won't make this long, but there was abuse. He's in prison. She was pregnant. She gave birth while he's in prison. She stayed with him. A couple years later, she was running his business while he's in prison. She finds out he's getting out early in 3 months. She commits suicide. She hangs herself because she was so afraid of him coming back. The grandparents, the maternal grandparents, have the child. I'm working on that custody issue and the criminal cause. But the point I'm making is that when I interviewed the parents, the sister, the friends, all these people before the suicide occurred, they didn't know how bad the relationship was. She wouldn't show up to family gatherings, or she'd come and go, or they wouldn't see him. She was totally hiding all that extreme abuse that she was going through. The family didn't know about it till the end, before he was charged and went to jail. So she went to great lengths to hide because she was scared of him. And I believe her going along with him and running the business was all out of fear also. And then she couldn't face it and decided to leave us.
A few questions, if I can, as it relates to domestic violence abusers. What have you found in your experience and education as it relates to their ability to charm and deceive others?
Yes. I found this in a majority of the cases. They want to project an image, again, hide the abuse. Sometimes that's their strategy to deceive others because they don't want to be found out. Also, I might add that the recidivism rate, when I was running the BIP classes, I was always surprised. I'm getting the same guy back again, that there's a personality issue here that hasn't been solved per se with some men, and that there's a tendency to abuse over and over.
Is there a unique pattern of denying, rationalizing, minimizing, or blaming the victim that's typical?
It's not only typical, it's in a majority of the cases that I've ever worked. I see this almost in all the cases, I'll say. And if we look at the Duluth Power and Control wheel, there's actually at 5 o'clock, minimizing, denying, and blaming. It didn't happen. It wasn't that bad. It was her fault, which, as I've explained in the past. So that's very typical. It's also a form of gaslighting that's been in, I think, the news the last 10 years or something. So it's a form of control and gaslighting a victim.
Does it include suggesting that the problem stems from the victim's mental health problems?
Definitely. That's a very common theme. It's also gaslighting, and also it's in the power and control wheel, using emotional abuse. If we, about the third line down, making her think she's crazy. So it's a destabilizing technique. If you've got so much influence over me that you convince me that I'm crazy, then maybe it didn't happen. Maybe I'm wrong. So it's a self-esteem killer.
Give us an idea, if you would, of the barriers that exist to these women leaving the abusers.
Fear of being harmed, certainly, if they report to victims. Barriers to leaving can be, as I mentioned, cultural upbringings or norms, roles. A lot of victims are financially dependent upon their perpetrators and don't know what else to do, and they don't necessarily have any other resources. Sometimes when I do trainings, I confront my audience, especially when I've got law enforcement or victim advocates, about their expectations of victims leaving that, perpetrator. You expect her to walk out on the street with 4 kids and she doesn't have a credit card and no family. And I kind of go into this a little deeper. I'll avoid doing that now. The fear of losing their children. So sometimes victims have experience with DCF. They understand what can be consequences if it's reported to DCF. So they don't want to report because, and I've been party to this in a lot of cases and termination of parental rights cases I've been involved with, that if she's staying with the abuser and a child, and I like I mentioned, I taught a class for DCF to men and fathers and mothers, and also trained on this a lot, that exposure to a child to trauma is trauma to that children. Separate from the traditional child abuse that we think of hitting the child or not changing the child's diaper, not having food, but actually subjecting the child to the yelling, the screaming, the abuse is trauma to that child. So if a female doesn't report and she's found out, then that can be considered a failure to protect. Now all of a sudden, and she's still a bona fide victim. So now she's being held accountable. Her children might be removed. She's got to go see people like Bruce Ferris for counseling. She's got to do all these classes. So and many know this, so they don't want that to be out and about. Also, sometimes I've had women, they still love him. They see the good in him. They feel he didn't have a good childhood, or it doesn't happen often, or maybe I created the problem.
So you mean these aren't split-second decisions?
What specifically?
Do they vacillate sometimes when children are involved?
No.
Should I leave? Should I stay?
I like to think of it as an evolution to leaving, but what's the motivation? If you're in that isolated situation of just he's the one. He's your world. Where's the education? Where's the involvement? That's what the role of a lot of our domestic violence shelters are in outreach, and is to involve and educate. And yes, here's services you can have. Here's someplace you can safely go. But that denial that violence will happen again is not uncommon. That feeling that it was her fault. Religious reasons. I'm always kind of surprised that, and I mean no ill towards any religious group. I don't mean to say that, but I found sometimes ministers or churches, very concerned about marriages or not getting divorced, and they actually recommend or counsel people to stay together that are hurting each other, and so that's an issue. This idea that he will hurt her if she leaves. In this quote, "I'd rather see you dead than with someone else," is not uncommon. And also the total power and control continuum and the use of that to control their partners.
Is there a particular time in these kinds of abusive relationships when violence is most likely?
Definitely. The most violent time is when she goes to leave and he knows about it or he's there.
In other words, when he forms the perception that the realization sets in that this is the end.
When she eventually puts her foot down and makes that clear, that's, and I know from my certification is doing fatality reviews with Johns Hopkins University, that's and then danger assessments. There's a high probability of fatalities or extreme bodily harm at that time. It's very dangerous. When we do many shelters and victim advocates that might be affiliated with the state attorney's office or wherever, they try to establish a safety plan with victims, and that plan will include, when you leave, it's when he's not home. Don't do it when he's home. And also have a safe, unknown location to go to. I have many stories I could tell of women being hunted down and actually killed because of he knew where they were. And that just the trauma of that, I don't, even though I work in this field and I've been doing it for 20 years, it's hard for me to conceive that cloud over me of being subjected to being violently hurt. And if I am, who's going to raise my child? And will he hurt my child also? It's overwhelming for those victims. And I certainly see that in my practice, my counseling practice.
So let me ask you this as we close. Given your education and experience as a law enforcement officer, tell me, is there a general bias against females by males?
I think there is. Some of it's different social ethnic groups, different cultures. I think I mentioned earlier, ownership of women. I've had, without mentioning the countries, I've been in, like I say, Gainesville is a little stewing pot of people from all over the world. I've run into men who actually thought it was okay to abuse their wife because they thought she belonged to him. And I said, sir, this is America. That's not how it works. So this ownership can be cultural. It can be dictated by social norms, what their parents did. Certainly the media and entertainment plays a big part towards women and male roles in our society.
And where can this bias be found?
Everywhere.
Everywhere
in society.
Including our institutions?
Including institutions.
And would those institutions include law enforcement?
Law enforcement, and of course I worked in law enforcement, and I was always surprised at how I constantly had to, I actually became a little internal affairs detective for my officers who didn't understand domestic violence and had biases. And I was always surprised of the biases and found sometimes they were personal. An officer's going through a divorce. So all of a sudden he's at a crime scene and he treats the female badly because of his own world. not enforcing the law appropriately. But yes, it can be, not everyone reacts the same way as a victim to domestic violence, and especially with other people. Some people have developed a very fat affect. In other words, they don't show emotion, and that's their coping skill. They actually shut down. They do this dissociative sort of thing. Other people become hysterical and exaggerated in describing. So every person is different. Just because you
object to narrative and non-responsive to the question.
Sustained.
All right. Lastly, do uninformed professionals, in your experience, cops, judges, lawyers, counselors, often fail to recognize the signs of domestic violence?
They do, and sometimes it's because they're not obvious and they're hidden, or they don't understand the dynamic of domestic violence, and they don't necessarily understand that that victim was in fear. And though it may not show, they may be smiling in a photo, or their family or someone doesn't know about it. That doesn't necessarily speak to what was going on.
All right. Now, would you be able to relate these principles to the facts of a domestic violence case with any kind of reliability?
100%.
Have you done that before?
Routinely.
Is that what you in fact do as a professional?
It's one of the major things I do. I might put as a footnote, I'm a therapist. So sometimes clients come to me and I'm helping them with their anxiety and their depression and generalized mental health issues. But many of my clients, because I focus on domestic violence, I'm helping them understand, or the perpetrators, I'm helping them change their attitudes, usually through what I call cognitive behavioral therapy. And I could go on and on.
All right. Could you make that application and its reliability by studying the facts and documents relative to a particular case?
Actually, this is one of my professions.
All right.
I'm hired by the state for cases doing domestic violence assessments, and sometimes I never get to interview some of the parties. Maybe they're not available, they're in prison, et cetera. In private practice, and also, like I say, through DCF, I've been hired. So I look at the characteristics, what fits, what was there a display of a weapon? Was there all these different things? And
would you be able to do the same application with the same reliability through a series of hypothetical questions?
Certainly.
All right.
And if I can, I would admit that I can't.
Yep. Finally, let's talk about battered spouse syndrome for a moment. Are there any characteristics in traditional battered spouse syndrome that might distinguish it from an otherwise domestic violence abusive situation?
Good question. So basically, the abuse is the same. I think what makes battered spouse syndrome or battered wife syndrome, different terms through the years, different is oftentimes the victim still lives with the abuser, and there can be a history of extreme violence or violence occurring and traumatizing the victim. But the techniques of power and control and compliance and fear and how they hide it and all those things are completely the same.
Thank you very much. I have no further questions.
Cross.
Good afternoon, sir.
Good afternoon.
Have you ever testified as an expert on battered spouse syndrome?
No, I have not.
Do you consider yourself an expert on battered spouse syndrome?
I consider myself an expert on domestic violence, not necessarily the BSS uniquely. I haven't been recognized by a judge in that doing that. So I think that for me, there's really no difference other than that distinguishing fact, whether they live there or not, or whether there's been physical violence or not. It's still the same dynamic. The victims are the same.
But you could recognize the law might make a distinction between those two things, an expertise in those two things.
Well, I think I'm expert enough to understand that. I just haven't testified uniquely in DSS.
And how did you interview did you speak to Miss Benefield?
I did speak to her.
And for how long?
I spoke to her multiple times with a Zoom call.
Okay, my question was how long? How much time did you spend speaking to her?
It varied a little bit per an hour. Most of the times it was 2 hours.
Okay, I need you to add it up. Did you speak to her 1 hour total, 3 hours total?
Oh, total time?
Yes, sir. I'm sorry if my question wasn't clear.
Going just by memory. I'd be guessing a little bit here, so I apologize. Could have been I'm just trying to could have been 15 to 20 hours easily.
So you spent 15 to 20 hours speaking to Miss Benefield?
I did.
Okay. And did you review paperwork in this case?
A lot. That's how I came to my conclusions, uniquely from the paperwork.
When you say uniquely from the paperwork, are you telling this court that you spent 15 to 20 hours with Miss Benefield, but you didn't base the opinions that you gave previously in a depot on that time?
That's true. I did not do an assessment of her. I was not hired to do an assessment. I did not produce an assessment.
Well, what were you doing for 15 to 20 hours?
Some of it was being a counselor, and some of it was I have a reputation to keep, and I wanted to understand was this really a victim? So kind of got into a routine of understanding some timeline with her about what occurred and how did it fit the facts that I was reading about.
Well, wouldn't that say, if what you just said is you needed to determine if she was a real victim, then it must have come into your decision-making about this case, with that assessment you made. Is that correct?
Could you restate the question,
Well,
please?
you just testified that you spent 15 to 20 hours in Miss Benefield, and part of that was to make an assessment on whether or not she was a real victim. And
No.
so,
Not to make an assessment as I compared the facts that I knew from what I was reading. I wanted some validity, and then some of my time was being empathetic and listening to her. But my conclusions I've come to that I talk about in the deposition were 100% from the discovery. Those were the items, and I could list them for you if you'd like.
did they include the stand your ground motion filed by Mr. Taylor and the defendant?
At the time, that was one of the items. Certainly, if I subtract that from what the things he quotes in the Stand Your Ground were other discovery items. Doug admitting to shooting the gun into the ceiling, him telling that to his priest, and phone calls and texts. So I didn't need the Stand Your Ground paperwork document to find all those bits of information that I found through looking at discovery.
Well, so the portions of the Stand Your Ground about what happened that night were not in discovery. That Mr. Benefield took a bladed stance and did this.
No, I didn't. Those items were not part of my conclusion. I can tell you I have 13 items I use uniquely in discovery that it came to my conclusion on. And it didn't include, and I never spoke to Ms. Benefield about what you just said about bladed stance. I never talked to her about that.
Well, you said you spoke to her to determine if she was a real, I guess to determine her veracity. Is that what you're trying to say?
That's one word, but I never spoke to her about the event of the shooting. Never.
Okay. Did you speak to her about the other things that were in the stand your ground hearing and the discovery from things that had occurred in the past?
I think some of the things did, yes. As I think about, as she's going, basically I did some timeline understanding, when they met up until before the event, and some of those items were in there.
And did you develop an opinion as to whether or not Ms. Benefield was a battered spouse? Like, as far as battered spouse syndrome, if you would say that she suffered from battered spouse syndrome?
Yeah, I did not determine that. I determined that she was a victim of domestic violence and that Doug was the perpetrator of that.
Based on
all the discovery and how it fits in with the continuum of power and control and her compliance, her fear, etc.
I don't have anything else, Judge. Thanks.
Thank you, sir. Tell us what you reviewed.
I reviewed a deposition that Doug gave, and I had a written version. He makes admissions. He talks about the gunshot. He talks about punching the dog, throwing the gun, punching holes in the wall. There was a letter to his pastor where Doug admits punching a hole in the wall and shooting the gun in the ceiling. There was a domestic violence injunction in South Carolina prohibiting mutual contact, and the text of that. The really important piece of evidence for me was Ashley wrote a letter on September 18th, 2017, when she separated, outlining domestic violence that Doug did to her. I have a copy of that if you want me to go through the items, but she outlines, without necessarily being a domestic violence counselor at all, she talks, it all fits very discreetly into what power and control and what abused women experience at the hands of their abusers. It was, and also for me, if I might say, that was a frozen moment in time. That wasn't something that she said after I met her or something like that. This was from, 2017.
And were you struck by the terms of basically art that she unwittingly included in that letter as it relates to domestic violence and the power and control continuum?
It was, it's a letter that I can use in training other people to counsel domestic violence victims, or if I was to work with a group of batterers, et cetera. It's classic.
Okay, what else did you review?
Deposition of a neighbor who caught Doug at night in the yard. A text of Doug admitting to putting a tracker on Ashley's car. I mean, these are all items that show ownership, that, stalking sort of items. A text from his ex-wife documenting him physically abusing her on her honeymoon. So this gets into his character, and
The object is not responsive. The question was, what did you review, not his opinion about them.
That's fine. Go ahead. Overruled.
Thank you, Judge. Go ahead.
So here I have all this experience dealing with perpetrators, being a perpetrator to multiple victims. Sometimes when I was a detective, I would, besides my therapy work, and I see that as I interview victims, but quite often my routine, I work day shift. So I come into the department, I go to a detective briefing, I look at cases where the suspect got away. My job was to review probable cause, go make the arrest or get the warrant. That's what I did. So the first thing I do is I run that perpetrator's name, and I find out there's an injunction, and I'm looking at the charging document that the officer left, and there's no violation of injunction in there. But then I open it up in the court system and I found it's a different victim. So I found there's multiple victims. And also, to be fair, I'd open up her the female, the victim's information, and I would find that there's an injunction, but it was with a different guy. So there's some serial victims and some serial offenders. So basically, the fact that he is very strong, and I know we talked about it in my deposition with the assistant state attorney. This text message from his ex-wife documenting how he abused her on a honeymoon was appalling to me, but it was not an unknown probability. And also it spoke to who am I looking at here? So that was one item. If I could continue. Of course, there was an injunction in Manatee County and some narrative. Dr. Russell, a forensic psychosocial mental health evaluation, I read, I think it was April 30th, 2020. She describes the abuse and domestic violence that Doug did against Ashley quite eloquently. It's quite clear the things she discovered in her she did interview and come to that conclusion. So I found that kind of enlightening. There were telephone calls and documentation between Doug and Ashley. I've got a date of August 16th, 2019, where he was, controlling, intimidating, amidst of being outside her house, following her. He was gaslighting her. He pulled a gun on his ex. There was a threat that he was going to kill himself with a gun, and there was more. There's more in that without pulling out the document. There was a very significant WhatsApp phone messages between Ashley and Doug, and in that there's statements about being armed, that he talks about warfare, rage, exterminating them, murderous mood, anger to take them out. A warrior side would be, the testosterone rage, talks about killing bad people. So let's say we could say, was this all true? Or was this techniques that to put her in fear of him? Both could be true, actually. I found that very, Dr. Broder, I read his testimony and that he gave, and it was clearly domestic violence was present. There was definitely power and control tactics reviewed by him. The mic blow up, the gun incident was, and I have a quote here, was certainly a frightening experience for Ashley. Doug's temper, yelling, screaming, punching holes in walls, and Mr. Taylor's cross was in that transcript I read. And as you spoke to Dr. Broder, angry temper, very controlling, highly manipulative, very intense. The holes punched in the wall, fired a gun in the ceiling. That there was an appeasement. That word was even used by Ashley, apparently by Dr. Broder, as a strategy with Doug to protect her child, keep him at bay. This is the very issues I've been talking about. And there was text about him kicking the dog and throwing the cat between Ashley and Doug. So all these elements right here, I got my conclusion from. I didn't need anything else. And this is clearly what I base my determination on.
And would you conclude, based on what you know, that Ashley was an abused woman?
Definitely.
Would you?
And I'm going to interrupt you, Mr. Taylor. Abused woman is to say one thing, but abused woman who was in compliance mode, that didn't want to poke the bear, that was afraid of what might happen if she opposed him. That's what I get here.
And how, if at all, would that explain, for example, Ashley agreeing to go on a parental exchange between Doug Benefield and her daughter, Emerson? Ashley, in the week leading up to the shooting, exchanging friendly, lovey-dovey text messages with emojis and things like that. And Ashley at a restaurant with her mother and her child, Emerson, in the company of Doug, acting happy.
Totally. It doesn't oppose my theory at all, or what I believe was going on. It may be that there's one thing I can say, Ashley did show from what I've read here and what you're presenting to me, a sophistication to, and maybe that's her performance side for being a ballerina or whatever, I don't know, but she could put up a good front. And this was to keep that warrior side of Doug at bay. She was concerned and afraid, and she was very afraid for her daughter. This is the mother factor. You know, her getting in that, I guess, you referred to the first visitation.
Yes, at the sheriff's office.
Her going along, that's much like I talked about that wife that stays with the abuser to protect the child. The idea of letting him, have custody at that time without, and I don't think, if I remember from documents I read, they didn't have that. He didn't have a lot of exposure to Emerson, and so that was definitely the mother, the maternal instinct, wanting to protect her daughter, and at her own expense. But that's nothing. I'm a parent. I take a bullet for my kid. It's not about me. It's about protecting them. I think that mothers do that. That's what mothers do.
All right. Thank you, Mr. Ferris.
Mr. Ferris, it's always a little bit dangerous when the court has questions, because certainly I'm the neutral party here. But in this kind of situation, in a Daubert hearing, I'm both the finder of fact and the decider of the law. So there are a couple of questions I have. I have said this multiple times. Mr. Taylor, I probably said it in hearings with you. I know you two have heard it. If you object to one of my questions, object. Please put your objection on the record. I have actually sustained objections against my own questions before. So I try to be intellectually honest, and if it's in retrospect, I realize that's not a good question.
You have been good about that, Judge.
First, I did not receive a copy of your CV in evidence. It may be in the file somewhere. Is it attached to something so I can find it?
I can give you a copy.
Any objection to me receiving a copy? I assume it's filed somewhere, but I don't know where.
Judge, may I make a statement briefly? When in my past experience, when my CV is presented to the judge, oftentimes I'm shown a copy of it to verify that that's the complete version.
Sure, you want to see it?
Yes.
Absolutely. I'll say, Mr. Taylor, there's markings on it.
Yes, sir.
You don't need it back? Is it in the court file?
I don't know if it's attached to the deposition. Let me take a look.
So here it is.
No, I'm informed we don't believe it's in the court file.
All right. And so, sir, this appears correct?
Yes, it does. Thank you for letting me look at it.
State, the copy that I've been given looks like there's highlighting where someone was making notes to highlight certain things to talk about. There's a couple of pages where there's some red pin markings where something has been circled or underlined. Any objection to me taking this and reviewing it?
If I may, it's the defense's burden. My only concern about your asking questions is that they have arrested their witness. And I understand what I have a guess as to what your questions will likely be, but that is my only concern. I don't know what objection that would be, but.
I mean, don't forget there's also the general and proper. So you object away.
Yeah,
You know me, I don't mind.
Yes, sir. Yes, sir.
All right, and then you had gone through a list of 13 things that you had reviewed.
Yes, sir.
And I was writing them down as we went, and I'm taking notes. I only got 12.
Okay. So do you want me to briefly?
I do. I don't want the narrative portion.
No,
I just want you to tell me.
Or you tell me. Okay, I'll tell
No,
you.
no, it's got to be the other one. You have to say to me.
I'll give you the first 3 or 4 words of each. Number 1, deposition of Doug. Number 2, letter to pasture. Number 3.
A little slower.
Okay, sorry. Number 3, DV injunction from South Carolina. Number 4, 9/18/17 letter from Ashley. Number 5, deposition of neighbor. Number 6, text of Doug admitting. 7, text from ex-wife. 8, the DV injunction. That's Manatee County. Number 9 was Dr. Russell. 10 was the telephone calls between Doug and Ashley. Number 11 was the WhatsApp phone messages between Ashley and Doug. Number 12 was the Broder testimony. And number 13 was the text, kick dog through cat and between Ashley and Doug.
Can I just ask to clarify, you said phone calls between Ashley and Doug, is that what you said?
Yes, from 8/16/2019, I have a transcript of phone calls between them.
Transcript of phone calls?
I believe so.
No.
All right, that's all the questions I had, surprisingly. State, do you have any questions based on my questions?
No, sir, thank you.
Mr. Taylor, do you have any questions based on my questions?
No, you are.
All right, and is he free to head on back to Gainesville?
Yes, sir.
Okay.
Am I released from my subpoena?
No, this is just a proffer.
Okay.
We're doing a Daubert hearing, so I imagine Mr. Taylor still has you under subpoena.
We have high hopes you will be returning early next week.
Okay.
So stay in touch.
Okay.
All right.
And so I'm still under my subpoena.
Yes, sir.
Thank you. Thank you. I do appreciate your attention.
Absolutely. Have a great weekend. Don't forget you've also got your wheel over here. Or is that yours?
That's theirs.
Okay.
I've got my own. Thank you. Thank you.
Safe travels back home.
Yes, appreciate it.
Well, we're looking to go right at the perfect time, aren't we?
Yeah.
Might want to stop and have dinner.
Or pack up my hotel room and put my blue jeans back on, right?
Yes, sir.
Thank you.
All right, the witness has left the courtroom. Did you have any other witnesses' testimony or evidence you wanted to put on for the Daubert hearing?
No, sir.
State? Did you have any evidence, testimony you want to put on?
No, sir, thank you.
All right, I'm ready for argument.
So 702 of the Florida Evidence Code, Your Honor, incorporates the new Daubert standard, as the court knows, provides if scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if and the court knows the three requirements. Sufficient if the testimony is based upon sufficient facts or data, testimony is a product of reliable principles and methods, and 3, the witness has applied the principles and methods reliably under the facts of the case. The state's theory of prosecution, although it was changed this afternoon from the release of the Broder report to the injunction that was set for the 30th, has as its predicate the specific behavior of Ashley Benefield in the week leading up to the shooting. And included in those text messages, as was the video at the restaurant, as well as the state's focus on how Ashley Benefield behaved in the presence of Douglas Benefield, but behaved differently when she was by herself, and how she led Douglas Benefield to believe that she wanted to reconcile, but in private, she clearly disclosed that she did not want to do that and wanted the relationship over. And finally, the instances where Ashley Benefield, as a result of the parental time sharing, accompanied her daughter, Emerson, and went with Doug, that Stephanie Murphy testified to. They were the picture of tranquility, that Ashley was very pleasant, happy to be in Douglas's presence. So what we know and what the record reflects based upon Mr. Ferris's testimony and the Duluth Power Wheel and its model for the evaluation of domestic abuse is that this is a classic sign of an abused woman who is in compliance, who indulges in, as Dr. Broder used the term, appeasement. Go along, get along. It keeps the beast at bay. And now, that element having been injected by the state in their case in chief, we, on behalf of Ms. Benefield, are prepared to meet with expert testimony explaining to the trier of fact, the jury in this case, exactly why the state's evidence of Ms. Benefield's compliance can be dismissed, can be explained, because this is the MO of abused women, women suffering from domestic violence, especially when a child is involved. So here's what, as the court knows, the Oquendo decision said, and it's the second DCA decision, referring to battered woman syndrome. Again, the notice we filed was notice of battered woman syndrome, but I footnoted it because two elements are not present. Those two elements are that Ms. Benefield had left the home and that she had not been physically battered by Mr. Benefield until the day of the homicide. But as the court heard from Mr. Ferris, it's inconsequential. It is the same syndrome. It is the same abuse. It carries over, and it explains under Duluth Power and Control Wheel why Ms. Benefield would engage in those kind of text messages 1 week before the shooting, why she would appear happy at the restaurant, why she would accompany her child at the parental time sharing with Doug, why she would try.
Please not get behind me. I'm sorry.
Why she would try to get along, go along.
You, but I don't want to bother you.
So here's what the Oquendo court said. Well, actually, before we go there, we should go first to the Supreme Court case of Kathleen Wyand versus the state of Florida. This is the case I cited to the court earlier in a memoranda, 732 Southern 2nd, 1044. It was an appeal from the second DCA.
Oquendo.
Yes. No, this is Wyand.
Wyand.
Kathleen Wyand, the Supreme Court of Florida. I'll get to Oquendo next. And the Wyand decision, Your Honor, was March of 1999. The Supreme Court rejected the second DCA's position in the Wyand case and instead embraced another circuit's decision, and it turned on the following question: whether or not there should be a duty to retreat as it applies to a spouse in the marital home. The Second Circuit had insisted on giving the instruction in a homicide case. The Supreme Court said, hey, look, we've learned quite a lot about domestic violence, and we're uncomfortable having a duty to retreat imposed upon a wife because of domestic violence. And it would render the wife's ability to defend herself in the face of battering and domestic violence ineffective. So we're going to reject that. We're going to retreat from our earlier decision that held there was a duty to retreat. And this is what they said about why. It starts on page 1052. And the topic is Section B, implications for victims of domestic violence. And they talk about how much of the public policy in this state has changed based upon increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, severely beaten again. If she managed to escape, other hurdles confront her.
While you're taking a breath, how is Wyand help me decide the Daubert question?
The issue is whether or not he has the credentials. I think we're past that. Unless I'm missing it, I think he's eminently qualified. I think the testimony is such that he's identified the syndrome of domestic violence, and he's explained that it is identical to battered spouse, the only difference being that the wife is not in the house and she has not sustained physical beatings. So this case in Wyan goes on for several pages talking about how domestic violence, the evolution of public policy, and the recognition of the plight of victims of domestic violence needs to be addressed and should be addressed by virtue of expert testimony. When you take that into account and you recognize what the Supreme Court is acknowledging, Judge White, about the timeliness of domestic violence, which is the overarching umbrella, battered spouse and those two components coming underneath it, you then go to Oquendo. And in Oquendo, they serve it up perfectly. Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind to the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. And then they distinguish post-traumatic stress disorder. And they hold, as such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. So we know in a homicide case, based on the law and the jury instructions, Ms. Benefield is entitled to introduce specific instances of conduct of Douglas Benefield that are consistent with violence. We have endeavored to do just that throughout this trial thus far, with considerable resistance, but I think we finally started making some progress once the court felt the predicate had been laid. We cannot, this jury must understand, and both the case law that I cited to Your Honor clearly says that it is a proper subject for expert testimony, domestic violence. These jurors must understand why a woman would do what the state has alleged she did, and as a result, they should find her guilty. That is to say, getting along with Douglas Benefield and the text messages that they put into evidence. So, given the credentials that he's established, given its reliability, given the tests that it's been vindicated with and that DCF employs, the Duluth Power Control Wheel throughout the state of Florida, given the fact that this is a domestic violence matter involving self-defense with specific instances of domestic violence, how can I successfully defend if I cannot explain to the jurors the essence of the state's case as to why Ms. Benefield is a malingerer in effect? That is to say, if she acted happy 1 week before the shooting, if she went ahead and got in a car with Doug when they were exchanging temporary time sharing, if she acts happy at the restaurant, then she obviously wasn't scared of Doug. And that's the whole issue. That's exactly what was at play on September 27, 2020, and why Ms. Benefield's perception of Douglas Benefield was so fraught with fear. Otherwise, I'm left with a case that there is, in fact, a substantial explanation to explain that conduct that the jury doesn't understand, as indicated by the case law in the Florida Supreme Court, and will have no idea why Ms. Benefield would have acted that way. And it's an element that the state introduced. We are trying to meet it. That's our position.
All right, thank you. State?
Thank you, Your Judge, I'm going to try to bring it back to Daubert, but I do want to address Okendo because it frames my arguments. Sorry. Under the Okendo case, or Oquendo, however you say it, the court carves out, as we've discussed at length, and I know Your Honor knows, carves out an exception for battered spouse syndrome, where it's talking about that that it's an objective standard. Self-defense is an objective standard, not a subjective standard. And that the one exception for that, and under Okendo thus far, is battered spouse syndrome. They discuss the definition of battered spouse syndrome. And part of it says, the main part, mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because she suffered from the syndrome, battered spouse syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. The Whelan case also defines battered spouse syndrome. It says,
No, spell it.
sorry, it's the case Mr.
Wyand?
I'm sorry, Wyand.
Whatever, however you want to say it. I see
Weiand, I
another
don't,
one.
Weiand, 732 Southern 2nd, 1044. It says, I was looking for the page, Your Honor, I'm sorry. I think it's on 1054. It says, as the expert evidence demonstrates, there are many reasons battered women do not feel free to leave the battering relationship. This woman might have been isolated from her family by the abuser. She may not be able to afford to go, and she may realize that leaving is more dangerous than staying. And the reason I cite that is because the state's argument is that despite Mr. Taylor's efforts to make this about battered spouse syndrome, despite his footnote, that is not what this is about. This is them trying to get an expert on domestic violence. This expert, Mr. Ferris, while very educated in domestic violence, is not a battered spouse syndrome expert. He does not say that this defendant, although I find it incredulous that he spent 15 to 20 hours with her and reviewed things that the state doesn't even know what they are, that he only based his opinions on those documents not meeting with her. But nonetheless, if he were evaluating, the reason that's important and the state asked it is because if he's evaluating her for battered spouse syndrome, which he clearly wasn't because he admits he does, that's not what he was doing. There's only two options for that, and your Honor's aware of that. That one, if she's evaluated, then they have to file notice and we are allowed to evaluate her. That's not what we're operating under here. So the other one is that their expert must not have evaluated her. And the state would argue that no matter what Mr. Ferris claims, that's an evaluation. The things he did were an evaluation. I believe the case actually, I think it's Hickson, but I could be misspeaking, even says that they're not supposed to be familiar with the facts of the case. He's clearly familiar and has formed opinions, personal opinions, and professional apparently, about the facts of this case. And the reason that's important is because the state would argue that this defendant has failed to meet her burden under Daubert, that this expert is an expert in battered spouse syndrome, that the testimony is based on sufficient facts or data, and that it's a product. I don't think he met any of the prongs as to battered spouse. As to domestic violence, I would admit he certainly has the skill and knowledge. But even then, I don't think that the methods were reliably, it says the witness has applied the principles and methods reliably to the facts of this case. The facts he got were incomplete and evidently biased because some of them include items that were never provided to the state, including transcripts of phone calls that the defense felt were appropriate. So the state's argument is that, one, the only option for them is battered spouse syndrome. They have certainly not met the burden for that. Under Okendo, the domestic violence should not be admitted. And two, that they did not meet their burden under Daubert because they did not satisfy the prongs of Daubert for domestic violence if it were admissible. And I don't know what they expect Mr. Ferris to actually testify to. I think 75 to 90% of what he said today is inadmissible. Stories about other people, those kind of things. The state is of the opinion that his opinions that this defendant is a victim of domestic violence are inadmissible. That's an inappropriate opinion for him to be making. And finally, the main prong that they have not met in the state's opinion is that it says if the scientific, and I'm citing Booker, but it's from Daubert, the scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or determining a fact at issue. The state has put forth motive evidence and evidence of how she was acting in the weeks before this murder. And it certainly goes to her depraved mind. But the concept of domestic violence and even the concept of the Duluth power and control wheel are not foreign to the average citizen. That an average juror, and this expert, scientific, technical, or other specialized knowledge would not be necessary to assist the trier of fact in understanding the evidence. The evidence is clear, and the jurors are people who are of normal knowledge, and it's a common domestic violence situations, and the idea of power and control, honeymoon phases, those kind of things are common knowledge. So I know I said a lot of ways in which we object, but ultimately, I don't think they met their burden under Daubert for battered spouse syndrome, certainly. I don't think they've met it for domestic. But even if Your Honor finds that they have, the state would argue that Okendo would keep that testimony out of this trial, as it's an objective standard, not a subjective standard. Thank you.
Rebuttal?
Yeah. Mr. Ferris was asked directly if he evaluated Ashley Benefield, and his testimony, which is the only testimony that's been brought forth in this hearing, was that at no time did he conduct an evaluation. He was not hired to do an evaluation. With respect to the state's statement about motive evidence, motive is not an element of the offense. However, self-defense is certainly a material element to be considered, and there is, according to the information that is discussed in the Supreme Court opinion, Your Honor, it is not, and decidedly not, a subject for lay testimony. They could not make it more clear that there are many aspects about domestic violence. In fact, the words that they use in the Supreme Court opinion is that judges and juries do not understand and would benefit from expert testimony. I would suggest to the court drawing a distinction between Daubert and the case law on battered spouse syndrome, I would suggest that given the facts of this case, an expert such as Bruce Ferris, who could educate the jurors on the impact of an abused relationship, domestic violence, in and of itself would be enough to provide expert testimony to counter the state's position and the issue that they raised about the go along, get along. I think it's clearly beyond the scope of lay people to understand that. And I think that expert testimony would help explain it. So Daubert, of course, doesn't apply any less under those circumstances. However, it would not be restricted to the extent the court wanted to draw such a narrow line and say, for example, okay, well, this is not battered spouse syndrome because for it to be battered spouse, you absolutely must have the abused party living with the abuser, having had physical beatings. If the court wanted to draw a line that narrow, rather than include it under the umbrella of domestic violence, I would still submit to Your Honor that the testimony from Bruce Ferris clearly met the Daubert standard for admissibility, and I would call him as an expert witness on domestic violence. And if the court really wanted to narrow it even further, as it relates to a woman who would choose appeasement and go along, get along, coincidentally, like I think we had 4 psychologists testify in this case so far, and every one of them have used the same terms to describe this phenomena. I think I need and I should be entitled to be able to explain that to the jurors. And I'm not going to be able to do that without expert testimony. So I think the state combines Daubert with the case law, and Daubert is the procedural vehicle for allowing expert testimony.
All right, I do have some questions.
Yes.
I end the week, kind of as I mentioned, at the hearing we had regarding Mr. Ferris before the trial started, whether it was last week or the week before. On July 11th, at a hearing, you said this was not a battered spouse case. On July 12th, you filed the notice of intent to rely on battered spouse syndrome. What is this? Are you arguing battered spouse syndrome or not?
Okay, Judge, once again, I filed that notice with a footnote in the title, Notice of Intent to Rely Upon Battered Spouse Syndrome, footnote.
Mm-hmm.
And the reason why I told the court this is not a battered spouse case is because technically, Your Honor, battered spouse requires those 2 elements. I shouldn't even say it requires those 2 elements. Those 2 elements are generally present in the battered spouse cases that we've seen. So in my footnote, I said, as it relates to domestic violence. So I wanted to cover both scenarios. I wanted to cover expert testimony to explain this phenomena under battered spouse as it relates to domestic violence because it's the same syndrome as you've heard. It's the same mentality. Everything about it's identical. But I also felt at the same time entitled, upon meeting the Daubert standard, to just call an expert on that particular issue. And this expert's eminently qualified to explain that kind of behavior. So Daubert is, again, the procedural vehicle that qualifies whether or not the expert is capable of meeting the standard. And that would apply whether it was to battered spouse or just as domestic violence.
All right. So we've got the case law that we've all been discussing for the last couple of weeks regarding battered spouse syndrome, the notice that's required, why it's a carve out, why it's allowed when Okendo doesn't allow PTSD, other cases don't allow, significantly impaired intelligence, mental health issues. When I say mental health issues, I'm not talking insanity and so forth. I'm talking about, diminished capacity, right? Essentially diminished capacity because we're looking at a reasonable person. Do you have cases that do not use the word battered spouse syndrome? They use domestic violence victim of domestic violence, and that is allowed in self-defense cases.
All right. Would it be any different, Your Honor, than a criminal case of culpable negligent homicide, the issue being the trigger pull and the weight that it would take in order for the weapon to fire? And you call an expert to testify that the trigger in that particular gun was set to a particular level to try to explain to the jurors why that gun might discharge, and you're not necessarily negligent because of the discharge. Other weapons, if you banged against the wall, might not discharge. This one has a hair trigger. The defendant turned, hit the banister, the weapon discharged, shot and killed somebody else. If that expert met the Daubert standard, why wouldn't that expert's testimony be admissible to explain that? To try and explain to the fact finder who would not have that knowledge that indeed this could be nothing more than an accident that does not rise to culpable negligence, and therefore the charged individual is not guilty. And what I'm saying to the court is that evidence of domestic violence, if it meets the Daubert level, I should be entitled to defend and explain to them why she would engage in this type of go along, get along.
So the answer is no, you don't have a case.
I do not have a specific case on that point. No. And so the court knows I instructed Mr. Ferris not to evaluate Ashley Benefield. I had planned, if it came in under battered spouse, to follow the Heenan option, whereby he would be given a series of hypotheticals based upon facts and evidence.
Excellent segue. That was my next question. I didn't keep track on the clock how long Mr. Ferris testified about the general properties of domestic violence, the Duluth wheel, the cycle of violence, his numerous anecdotes, personal anecdotes, and relatable anecdotes. So if I'm understanding correctly, you are going to seek for him to offer an opinion that Ashley Benefield was an abused person and Doug Benefield was an abuser. Is that correct?
No, not necessarily. That was for purposes of the hearing that we had. It would be my plan, if he comes in under the Heenan approach to battered spouse, Your Honor, to just have him educate the jurors about domestic violence and specifically ask him about the compliance aspect that would allow a woman to engage in the type of behaviors that the state has raised the issue about and injected the evidence that they have. I could then give him hypotheticals based on facts that were in evidence under the battered spouse syndrome exception. Or alternatively, were he to come in just as an expert on domestic violence, I had him review the discovery materials. As the court knows, he submitted to a deposition by the state under the Heenan approach or under just domestic violence expert. The state, as it says in the case law, would have had the option to get their own domestic violence expert. They haven't done that.
My ultimate question was, at one point you asked, can you relate these concepts to a domestic violence situation? Yes. He can study facts and documents. Can you relate these concepts to a situation where you study the facts and documents of a particular case? Yes. But you're saying you're not doing that way. You're doing hypotheticals. He's not going to render any opinions in this case.
Correct.
Specific to this case.
If it comes in, yeah, under battered spouse syndrome. That's correct, Judge. I would follow the Heenan approach.
I think it's Hickson. Are we talking about Hickson?
No, I don't think it's Hickson. I'll get it for you.
I know it's not. I was like, I heard it that when they could allow it, let's split up.
Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. We've not missed anything there. they're just looking stuff up. So I thought I'd play a song to wake us all up. Wake me up before you go. Da, 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 da. Wake me up. Oh, fuck.
Is he know? My question is this. He spent so much time on these Hornbook issues, and the question was asked, can you apply these principles to hypotheticals? But I didn't hear a single hypothetical that's going to be presented, so I could even hear him and consider him and listen and see if he applied the principles reliably to the scenario. So I have no idea, how am I going to make a ruling when I didn't even hear the hypotheticals?
Well, hypotheticals would be based on evidence in the record.
I understand.
I took him up to that threshold and I asked him, could you reliably apply these principles to a series of hypothetical questions if asked? He said yes.
So why didn't you ask the hypotheticals so I could hear them and make a ruling?
Well, I would ask the hypotheticals, Your Honor, based on what we know is record evidence. For example.
Exactly. What's in the record, what's been admitted.
Correct. But
is it your position that all 13 of those items have been admitted into evidence?
No.
So I would need to hear the hypotheticals to know what you're going to ask about.
Okay, so I would ask the hypotheticals, Your Honor, based upon shooting the gun in the ceiling. Actually, I would ask the hypotheticals based upon the evidence that the state has presented to create the issue. For example, I would ask, in a week's worth of text messages were to be exchanged leading up to a shooting that show emojis and friendly banter back and forth, would that be inconsistent with battered spouse syndrome? I would then ask, would a woman who shares a child and the husband has a right to joint custody and the woman agrees to go along with the husband when he is with the child, would that be inconsistent with battered spouse syndrome? And he would explain in response to those types of hypotheticals why it wouldn't be, why this issue of compliance exists and is so prominent in domestic violence cases or in battered spouse syndrome cases. I mean, the hypotheticals, I think, are readily available based on what we have record evidence. Now, I might also add, Judge, we've only called, I think, 2 witnesses. So there may be more that's in the record. But to the extent that I'm interested in it, it will relate to this issue that the state is teed up about acting friendly and not being fearful being in the company of the individual. It doesn't mean that they're not fearful.
Hold on.
Once again, Your Honor, I had him review the discovery documents in the event he came in as an expert on domestic violence and was going to speak to that issue.
Thank you, sir. All right, State.
Judge, I guess based on that line of questioning, I'm still not sure what the answer is to your first question, which is this a matter of spouse syndrome case or not? I would argue that it is not, that there's been no showing that matter of spouse syndrome applies in this case. And I think that's my first argument. As to the hypotheticals that we did not hear today, the state objects to the hypotheticals being offered to this doctor because under Hickson, if this were battered spouse syndrome, which is really all we have for guidance, it would have hypotheticals are available to someone who has not evaluated her. And I think because I know he said he has not evaluated her, but the fact that he read 13 items in this case, he's wholeheartedly familiar with what the defense believes the facts are in this case. And I think it would then be inappropriate for him to be asked hypotheticals based on what is in the record, because clearly he got a lot of things that are not in the record. That's it, Your Honor. Thank you for letting me be heard.
I think he's going to allow him to testify, but with limited scope. I'd guess. I don't think so, Pelloway. I don't think she's guilty, no. Personally, I don't think the state met their burden of proof. A long way from meeting it, in all honesty. BG, I think you're new here, so welcome, BG. I don't think I've seen you be here before, so welcome to you, and thanks for your contribution. Great minds think alike, Amy. Great minds think alike.
Okay, anything else we need to take care of before I let you go?
Nope.
When do you plan on calling Mr. Ferris?
Like to call him first out Monday morning.
Okay.
Do you think we'll be rolling over the weekend or Monday? Is there anything, I did have one question. Is there anything in here Monday morning before us, or can we leave some of the things we've been leaving?
I'm not aware of any hearings Monday morning.
Okay, thank you, sir.
Oh, so he's not ruling tonight. It's the time. It's the time. I think he's going to rule over the weekend.
Make sure that one's turned off. It'll run it back.
He's going to rule over the weekend. Horn books. Thank you, BG. As I say, welcome to you. And if you have been here before, I'm sorry, I just didn't recognize the name. I love the name BG, that's like the band. So we'll keep an eye out on the weekend. He probably will tell the attorneys on the weekend at some point what his ruling is. But we might not hear till Monday morning. Looks like he wants to call him first thing in the morning. I think he's going to let him in, my personal opinion. But I do think it's going to be very limited about what he's going to be able to speak about. Oh, that's just frozen. Okay. He's not going to allow him to just go into anything he wants. Also, he will not be allowed to look at all his books, reports and stuff like that, I don't think. Close that down. Well, it's been a long day. Nearly 10 hours today streaming. So 9 hours and 40 minutes, I believe. So, right. That's interesting since it sounds like he's Gainesville. So Gainesville is in Florida, so I'm not sure how far that will be from this court. I'm not sure. No worries. What a day, yes. Can someone drop the merch? Yeah, I could do it. Hang on. Because I think that this merch store is closing, I think Tuesday. I'm going back to the other one then. So if you want to buy merch, honestly, I'm not calling you. If you do want to buy merch, buy it now because this is cheaper than the other site because I have to pay for the site to make it cheaper for you guys. So all of it includes delivery and everything, whereas the other site, delivery is not included. I basically try to do this as cost effective as possible for you guys. So yeah. No, thank you for being here. Never thank me, guys. Always thanks to you for being here. Appreciate you. I've had Shandia Tulol, been on it since 12, and some good news that I'm going to share with you soon. No worries, Ape. No worries. Glad you got some good news. Brilliant. Amy, thank you for dialing. Surely if the prosecutors have pointed this picture and admitted evidence they think prove she was scared of him, the defense should be able to rebut that. The complication is this defense puts stuff in very late all the time. I think if they'd put this witness on early, I think it was not a problem. But my understanding is that they knew nothing about this witness. They put everything in last minute all the time. So I think that's the issue here. Similar to what happened with Karen Reid trial, if you remember. So, because I think if he wrote reports and stuff like that, they'd be in. There would be no questions, but they didn't do that. So, happy day, Stormcat. Thank you, Hippie Chicken. You as well. Enjoy the pool. Would cause more trauma. That's on his face. Seems cruel. Yeah, I did not like the reenactment. I did not like it. Well, everybody, thank you very much for being here. I am gonna love you and leave you because my years are now perking up. Have a great weekend as well to you, Carol Draper, and to you, Yaya Trucker, and I'll chat to all of you. Have a great weekend. We will be back at 8:30 Eastern on Monday, which is 1:30 UK time. Hopefully we've only got another 2-3 days. We should have a verdict Wednesday or Thursday, or Thursday probably, I would think. So we'll be back for that. Mark, have a good night. Ruka, have a good night. Recover well, Ruka, from the COVID. All right, my darling? Emma, night to you, my darling. Amy, have a wonderful weekend. Enjoy yourself in California. Be safe over there. It's only afternoon for you now. 8, 9, 10. Literally, you and Josie and everybody. It was only like 3 in the afternoon. Oh, I'm jealous. Okay. Okay, well, the alternate corner at hotmail.com. Just message me there, the alternate corner at hotmail.com. Hey, thank you, Lou. Enjoy yourself. You've had a tough week, my darling, so enjoy yourself. I can't believe how young you look in that picture as well. Enjoy yourself wherever you decide to do. I don't know what I'm going to be doing yet, so why would someone go to all this effort, have a baby with someone who then want to kill them to keep it that way? I just don't see. Zach, I think you in a second you're going to be speaking to yourself, Zach. See you later, Zach. When you get to this, have a good weekend, my friend. Lisa, have a good weekend as well to you, my darling. Lovely to see you. I love it when you chat, Lisa. I know you're probably working, so you can't chat, but yeah, lovely to see you, my darling. And Stormcat, have a great weekend. Mods, have a great weekend. I think Erin Hack is already sleeping. So lazy bitch. But yeah, everybody, thank you so much for all the support. And I'll see you all on Monday. Take care of yourselves. Bye bye, people. Now finding the outro. Oh fuck. This is what I always do. See you later. Bye bye.